ಯಾವ ಡಿಸಿಪ್ಲಿನ್ GMCPC ನ ಕೊಡಿ 230 ಬಟ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಅವ್ರನ್ನ ಹೆಂಗ್ ಕರ್ಕೊಂಡ್ ಬರ್ತೀರಾ? ನಾಳೆ ವಿಲ್ ಸಿ ಡೌಟ್ಫುಲ್ ಬರ್ಲಿ. ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಆರ್ಗ್ಯೂ ಮಾಡಿ, ವಿಲ್ ಟೇಕ್ ಇಟ್ ಆನ್ ಮಂಡೇ. ಆನ್ ಮಂಡೇ. FR ನಿಮ್ದಲ್ಲ, ಕೊಟ್ಟೆವ್ರದ್ದು. ಜೋಕಾರೆಡ್ಡಿ ಅವರ FR ಮಂಡೇ ಅಷ್ಟೊತ್ತು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ. ನಿಮ್ದಲ್ಲ ಸರ್, ಅವ್ರದ್ದು. ಒಂದು ನಿಮಿಷ, ಯಾಕೆ ನೀವು ಟೆನ್ಷನ್ ಮಾಡಿ. ಕೊಡಿ ನಿಮ್ದೀಗ ಏನು. ಸೊ ವಾಟ್? ಸೊ ವಾಟ್? So what? When? 2:30. Monday. No, ಅದ್ರಲ್ಲಿ ಏನು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಮೇಡಮ್? ನೀವು ಸುಮ್ಮನೆ ಏನು ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಅಂದ್ರೆ 8 weeks ಅಡ್ಜರ್ನ್ ಮಾಡ್ತೀನಿ. ವಿಲ್ ನಾಟ್ ಗೆಟ್ ಇಟ್ ಆನ್ ಮಂಡೇ ಆಲ್ಸೋ. ಆಯ್ತು, 2:30 ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ. ಏನಾರು ಆಗಿರ್ಲಿ, ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ, ಪರವಾಗಿಲ್ಲ ಸರ್, ಕೊಡಿ. ಗಿವ್ ಆಲ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್. ಡೇ ಬೈ ಡೇ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ, ಕೊಡಿ. ಗಿವ್ ಆಲ್ ದಿ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಸರ್. ವೈ? ಸೊ ವಾಟ್? ವೈ? ಆಲ್ ರೈಟ್. 2:30 ಗಿವ್ ಇಟ್. ಕೊಡಿ ಸರ್, ಏನಾಗಲ್ಲ, ಕೊಡಿ. ನೀವ್ ಯಾರು? ಇಂಜಂಕ್ಷನ್ ಯಾರ ಫೇವರ್ಲಿದೆ? then leave it, give it. No sir, give it. Monday, nothing doing. Yes. No sir, nothing. No sir. ಯಾಕೆ ಎಷ್ಟು ಕಟ್ಟಿಲ್ಲ ದುಡ್ಡು? ಅದ್ರಲ್ಲಿ ಏನು ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಬಿಡಿ, ನೋಡಿ. No, one has violated the law, we will not show indulgence, nothing. Give it sir. Yes. Give all the memos. 2:30 ಬೇಕಾದ್ರೆ ಮಾತ್ರ ಇರಿ, ಮಿಕ್ಕಿದೆಲ್ಲ ಮೆಮೋಸ್ ಕೊಡಿ. Tomorrow I am not taking any memo. Give it. Yes.
My lord.
Everything will come on Monday if it is fresh according to seniority. Give it.
My lord.
Give it. Give all the memos.
My lord, if I may make one. My lord, if I may make one submission.
Lochna madam, one ನಿಮಿಷ. ಕೊಡಿ ಸರ್. 2:30 ಕೊಡಲ್ಲ, ಕೊಡಿ. Tomorrow ಇಲ್ಲ, Monday.
That's one memo for speedy disposal, my lords.
Speedy. Which is speedy?
GMCPC.
Land acquisition case.
ಕೊಡಿ ಸರ್.
The petitioner is blocking the road, my lord.
ಅಯ್ಯೋ ಪರವಾಗಿಲ್ಲ, ಕೊಡಿ ಸರ್. ನಾಳೆ ಬ್ಲಾಕಿಂಗ್ ಇದೆಯಾ? ಪರವಾಗಿಲ್ಲ. Give it sir. Fresh matter.
For vacating the stay, my lord.
Vacating stay, it will come on Tuesday. Give it. No tomorrow sir. You don't fix the date, I fix the date. Give it. Yes.
CRP pending.
No, request rejected. Yes.
My lord, petitioner's application for recalling, my lord.
Give madam.
My lord, 2:30.
No 2:30. Yes. Why recalling ಅಲ್ಲಿ ಏನಾಗ ಹೋಗ್ಬಿಡು? Wait, ನಾನು ಕೇಳ್ತಾ ಇಲ್ವಾ?
Monday it is listed for
ಮಾರ್ಕೆಟ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ?
Monday it is listed for arguments.
Maybe give it madam. Yes.
2:30.
CRP pending matter.
Give all the memo.
Criminal matter 313 statement ಆಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ.
ಆಗ್ಲಿ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಬಂದ್ಬಿಟ್ಟು
ಪರವಾಗಿಲ್ಲ, ಕೊಡಿ ಸರ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
ಇಲ್ಲ, ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್
ಕೊಡಿ.
ನಾಳೆಗೆ
ಕೊಡಿ.
ಇದು ಕೂಡ ಅವರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಗಿದ್ದಾರೆ.
Give it sir, give it. Yes.
My lords, one tax matter, my lords.
Tax matters ಎಲ್ಲ ಕೊಡಿ.
My lords, it was filed before Justice Suraj
My lord, if
Raju,
I
but
may
he
make
said
one
not before me, and has not come up till then. For Monday, my lords.
See, give it sir.
For Monday, my lords.
ಫ್ರೆಶ್ ಆದ್ರೆ ಬರುತ್ತೆ. Give it sir.
So one GMC pending matter urgent.
ಕೊಡಿ sir.
Pending matter GMC urgency is this.
What is urgency?
During pendency of the writ petition, my lords, the respondent has taken.
You are for the respondent?
I am for the petitioner.
Yes sir.
They have taken possession, my lords. After taking possession, they are selling off my movable properties and sheds, my lords, which are.
File an application before the court sir.
My lords, during pendency of this writ petition, they have
ಏನು ಮಾಡಕ ಹಂಗಾರೆ ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ.
I have filed an application here also.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಬರುತ್ತೆ ಬಿಡಿ.
Monday, my lords.
No sir.
ಸ್ವಲ್ಪ urgency, 2 plus 1 property they are selling.
give it ಪರವಾಗಿಲ್ಲ.
My lord, once,
ಹಂಗೆ ಕರೆಕ್ಟ್ ಆಗಿ ಕೇಸ್ ಇದ್ರೆ ಸ್ಟೇ ಸಿಗ್ತಾ ಇತ್ತು ನಿಮ್ಗೆ, ಕೊಡಿ.
Status quo ಕೊಟ್ಟಿದ್ದೀರಾ?
ಬಿಡಿ ಮತ್ತೆ, ಡೋಂಟ್ ವರಿ. ಎಸ್, ನಥಿಂಗ್ ಡೂಯಿಂಗ್. ಎಸ್,
The petitioner has challenged the compromise petition. Your
ಕೊಡಿ
Honor.
ಸರ್.
ದಯವಿಟ್ಟು ಮಂಡೆಗೆ ಹಾಕಿ.
Kindly Monday postpone that.
ಅಲ್ಲ 2 ಕೋಟಿ ಮಾತ್ರ.
ಹಾ.
ಮಂಡೆ.
ಪೆಂಡಿಂಗ್ ಎನಿವೆ ಸ್ಟೇಟಸ್ ಕೋ ಕೊಟ್ಟಿದೆಯಲ್ಲ, ವೈಲೇಷನ್ ಆಫ್ ಸ್ಟೇಟಸ್ ಕೋ ಅಂತ ಹಾಕಿ
Urgency ಇಲ್ಲ, ಮಾಡ್ತಿರಲಿಲ್ಲ. ದಯವಿಟ್ಟು ಮಂಡೆಗೆ.
ಕೊಡಿ, ಮೆಮೊ ಕೊಡಿ. ಮಂಡೇಗೆ ಆಗಲ್ಲ.
Tuesday sir.
ವಿಲ್ ಸಿ, ಗಿವ್ ಇಟ್.
my lord, if,
ದಯವಿಟ್ಟು.
ಅದಕ್ಕೆ ಇಫ್ ಯು ಮೂವ್ ಇಟ್ ಟುಡೇ, ಮೆಮೊ ವಿಲ್ ಗೆಟ್ ಲಾಸ್ಟ್. ಮಂಡೇ ಮೂವ್ ಮಾಡಿ, ಟ್ಯೂಸ್ಡೇ ಆರ್ ವೆಡ್ನೆಸ್ಡೇ ವಿ ವಿಲ್ ಟೇಕ್ ಇಟ್ and do that.
I'll move on Monday.
If today, if any memo other than Monday you move, it will not come
I'll
definitely.
move on Monday for 2/3 or Tuesday.
my lord, if,
Yeah, Raghavendra.
Fresh matter, your lordship. There is a recovery threat.
A pending matter, Your Honor.
Produce a stay order.
Monday have to do.
14th, your lordship, they are going to recover the amount for tomorrow, your lordship.
Tomorrow ಇಲ್ಲ.
I request
Monday.
my lords.
Please.
my lord, 2 pending tax matters, my lord. Any day is fine, my lord, before vacation. I have the benefit of interim relief.
ಮತ್ತೆ why do you
But
want?
no, my lord, the petitioner company is in the process of amalgamation. All I'm seeking is a direction for opportunity
Next
of hearing.
Thursday.
It may be disposed of, my
Next
lord.
Thursday.
Yes, my lord.
Tax matters ಕೊಡಿ
Next
ಅಲ್ಲ.
Thursday.
Fresh matter, my lord.
Your lordship.
Madam, next
All the
Thursday.
tax matters.
My lord,
Lordship,
may it be,
pending tax
one
matter.
second, may it be listed in preliminary hearing. Sorry, my lord.
It will come back, don't worry.
Thursday.
Lordship, pending tax matter, it is
Give it.
covered by a circular, may be listed next week.
Give it, madam. Give all the tax memos.
My lord, fresh matter, my lord, for preliminary hearing.
Land acquisition matter, my lords. I was not issued notice. My name is also not shown in the notification.
Give it,
of
give
the
it.
proceeding. Kindly Monday, my lords.
Fresh matter.
Fresh matter, my lords. Kindly.
100 ದಾಟೋಗಿದೆಯಾ?
Agreed, RFP ಅಲ್ಲಿ fully compromise ಆಗಿದೆ. Execution petition ಮೇಲೆ stay ತಗೊಂಡ್ಬಿಟ್ಟು. At the time of getting.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ತೊಗೊಳ್ಳಿ, ವೆಡ್ನೆಸ್ಡೇ ಬರುತ್ತೆ.
Lord, application for vacating stay, my lord, some
Wednesday.
date may be fixed, 3, 4 times we move.
All vacating, it is GMCPC?
GMCPC.
Wednesday vacating stay. Yes. ಆಗಿಲ್ವಾ? ಆಗಿರುತ್ತೆ ನೋಡಿ. ಎಸ್. ಇನ್ಚಾರ್ಜ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಆಗಿರಲ್ಲ. ಆಯ್ತು, ನಾಳೆಗೆ ಹಾಕಿ.
This is regarding
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಅಂತ ಹಾಕಿ.
30th of 2021, my lord.
Give it, sir.
Maybe listed tomorrow, my lord.
Hey, memo ಕೊಡಿ.
The suit would become.
May I request the matter to be taken up at 2:30, my
No,
lords?
why?
The urgency is this, my lords, the matter is being now taken up for evidence. My application for rejection of counterclaim came,
Monday.
it has been taken up for defendant's evidence today before the commercial court.
What happens, sir?
I am a co-defendant.
What happens, sir?
I'll time.
Monday we
ಕೊಡ್ತಾ
can
ಇಲ್ಲ.
undo, sir. Give it, sir.
Monday, please, my lords. Both the matters, my lords.
We'll see, sir.
Challenge the compromise petition, Your Honor.
ಕೊಡ್ರಿ, ಮೆಮೊ ಕೊಡಿ. ತಗೊಳ್ಳಿ, ಅದೇನ್ ಮೆಮೊಗಳು ತಗೊಂಡ್ಬಿಡಿ.
Tuesday ಹಾಕೋದು.
ಮೆಮೊ ಕೊಡಿ.
Land acquisition matter, my lord.
ಕೊಡಿ ಸರ್, ಮೆಮೊ ಕೊಡಿ.
Last time the matter was responded
ಮೆಮೊ ಬೇಡ, ಕೊಡಲ್ವಾ? ಕೊಡಿ.
1940 acquisition.
ಅದು
ಈಗ
ಸೇಮ್ ಆರ್ಡರ್ ಕೊಡಿ.
ಕರೆಕ್ಷನ್ ಇದೆ ಅಂತ ಜನರಲ್ ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ. ನಾವು there are some mistake in 1940.
ಆಯ್ತು, ಸೇಮ್ ಆರ್ಡರ್ಸ್ ವಿ ಹ್ಯಾವ್ ಸ್ಟೇಟ್, ಸರ್. ವೆಕೇಟಿಂಗ್ ಕೊಡಿ. ಎಸ್.
For 2:30, my lords, attachment warrant has been issued, my lord.
ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ 2:30 ತಗೊಳ್ಳಿ.
Attachment warrant.
ಎಲ್ಲ ಒಂದೇ.
My lord, CRP 15/25. Can you post it tomorrow, Your Honor?
ಸೀರಿಯಲ್ ನಂಬರ್
CRP 15, but ನಾಳೆ ಹಾಕಿ.
ಎಲ್ಲಿದೆ?
post-
memo ಎಲ್ಲಿದೆ?
Posting ಹಾಕಿದ್ದೀನಿ.
ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಲ್ವಾ?
My lord, my lord.
One matter for end of the list, my lord.
ವೈ?
Petitioner has sought for injunction under 39(1) and 2. That's been, notice has been issued, my lord. Against the petitioner, the matters.
2:30.
Please, my lord, one now. Humble submission, my lord. Yesterday, end of the list, serial number 12, it is na, online ಅಲ್ಲಿ update ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಈಗ ಆಗಲ್ಲ ಸರ್, ಈಗ ಸೈನ್ ಮಾಡಿ ಬಂದಿದೆ.
ಅಲ್ಲ, ಇದು interim order stay ಸ್ವಾಮಿ ಅಲ್ಲಿ.
ಗೊತ್ತು ಸರ್, ಅದಕ್ಕೆ.
My lord, it is tax matter, it is 2 times, it is memo, it is given, still it is not listed.
No, you have to add a zero to it, only then it will come. Give it.
Already given, it is.
ಅದಕ್ಕೆ add a zero to it. If it's just 2 times ಅಲ್ವಾ? You make it 20th time, then I will take it. ಕೊಡಿ ಸರ್, ಸುಮ್ನೆ. Give it. You don't want to give it? Give it, leave it, yes.
Orders?
One memo for 2:30, my lord.
Why?
Delivery warrant has been issued.
2:30, take it, yes.
Orders number 1?
Yes, Madhu, where the land is covered, sale of land.
So, no, my lord.
Issue.
No, my lord. There are the point.
ಹೇಳಿರಿ.
Rohan Corporation's case covered this issue, my lords, in its entirety. And there is one judgment of Gujarat High Court, my lords, which also dealt with the same issue. Lords, the division bench of the Gujarat High Court said that even if it's a developed land includes a developed land. So if a land is procured, developed and then given, then land includes a developed land, even that will not come within the purview of GST. I'll just file a very short synopsis. This is all where the case lies, nothing more.
My lords, he is acting as a facilitator. My only point is, my lords, we have issued a summons. They are not culminated into any show cause notice. Let him come before the summons, let him answer, because it is worth what, as far as our issue is concerned, it's around 230 crores. It is not per se this land. He is acting as a facilitator. He has not taken any registration. There are other issues also involved. My submission before my honorable, this honorable court is, three summons have been issued. Let him come before the summons, let him answer this. If he's showing it, fair enough. But with regard to the judgment, what they're talking about is not per se related to this, because he's acting as a facilitator. He is facilitating everything. That is different to that of this.
No, he describes himself to
It's a
be a contractor.
facilitator. Millards, I really don't understand. Millards, it's very simple. 120 people pool in the consideration, not in separate accounts. They pool in the consideration, pay the landowners, and 120 people have got the property. Not so far as statutory payments are concerned, there is a firm which is constituted, which is consisting of all the contributions made by these 120 people who have already been the beneficiaries of a joint sale executed in respect of the entire 120 acres. That's 120 people. And now this firm is also wound up. Now whatever money was there is spent towards the statutory dues, and some surplus amount was kept because to handle the litigations, because it's a huge extent of land purchased. Surplus land was kept for the purpose of litigation. Other than these 120 people, there is nobody else who is involved. Now I am one of the 120. You are issuing the notice to me. I am one of the 120.
Let him come and answer.
There is this is the whole problem.
No, but then everything is depending upon the facts and circumstances.
What happened to all others?
They are the joint owners.
ಅವ್ರಿಗೇನ್ ಮಾಡಿಲ್ವಾ?
ಏನ್ ಅವ್ರಿಗೇನ್ ಕಳ್ಸಿಲ್ಲ 119 ಜನಕ್ಕೆ ಏನ್ ಕಳ್ಸಿಲ್ಲ.
We cannot let out what the investigation is all about at this point of time. We have issued 3 summons. Whatever they are making submissions before this honorable court may be made before us. Let us record it and let us see whether it is in sync with the judgment, whatever has happened, and with the facts of the case.
You have seen the judgment?
My lords, my submission in here is, my lord, he is acting as a facilitator and he has not taken any registration. That is our allegation. The point is squarely on that. We have issued 3 summons. We are asking him, please come and tell us, because there have been amounts which have been received, which has been dispersed. Adala nam investigation ಮಾಡಿದೀವಿ. We are asking him and he is not coming.
Just find out why we had to come. It is not that they issued a notice summons and therefore we came before the court. If your lords were to see what is that they have done, that's in the pleadings. There is a major also. They called me. They hold me till 12 o'clock in the night for 3 days. Confiscate all the documents which are in my custody. Keep calling me again and again and again and again. It is not that for the first time I came. Is it your statement that I came for the first, before this honorable court on the first occasion? I have come before them for 3 occasions. 5 occasions I have gone. 3 occasions they have recorded the statements. They have taken all the documents from me. No.
My lords,
ಬಂದಿದಾರಾ ಇಲ್ವಾ? 1 minute. ಬಂದಿದಾರಾ ಇಲ್ವಾ?
Annexure E page 37 is the major.
They have come for statement. My point is, they have come for statement.
Yes.
My point is, my lords, this is a 70 inquiry under section CGST Act.
How many times you can call?
No, my lords, as and when the investigation progresses, when we get some information, we ought to take some information from him, because he is the main partner
What
of
are you
2
doing?
firms.
What are you doing with others?
No, my lords, that has been investigating. He has taken all the proceedings full stay ಮಾಡಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಇದರಲ್ಲಿ ಇವಾಗ. Not as against only him. The entire proceedings have been stayed, my lords.
Only against me, my lords.
If my lords may kindly, if my lords may kindly see the prayer, my lords.
Where is the interim order?
Entire proceedings have been stalled.
No, let it be only against the petitioner.
Only against, my lords, proceeding summons is only against me.
For the interim order, all further.
Very well. Your lords may clarify it's only against me.
Even in such a case, my lords, even in such a case, you let him come before the summons, and if you are asking for an inquiry at the judicial inquiry, he ought to come. I am only asking, let him come, let him answer before us.
No, this we will
We are only
modify.
eliciting information.
This will modify qua the petitioner and then take it another day and close it.
Please, my lords.
Yes. This court on, coordinate bench of this court on 14/3/2025 had passed the following order. The learned counsel Madhu and Rao, representing the respondent, would submit that the entire investigation or a section 70 inquiry is stalled on the score that all further proceedings are stayed in the case at hand, while the petitioner is only one. In that light, the learned senior counsel for the petitioner, D.R. Ravi Shankar, would submit that the petitioner is not called once, but 5 times, and 3 times his statement is recorded and is made to sit in the office till 12 midnight.
12 midnight.
Till 12 AM, and is let off without recording any statement on 2 occasions.
Statements are recorded. All statements are recorded.
Allah, on 2 occasions or all occasions?
Lots on 3 occasions they have recorded.
On statements have been recorded on 3 occasions. It is
And
therefore,
confiscated all the documents.
it is therefore the petitioner, or ಹೇಳಿದೆ. It is therefore the petitioner is before this court calling in question the proceedings itself. In the light of others or the role of others also to be investigated into by the respondent, I deem it appropriate to modify the interim order, restricting the interim order in favor of the petitioner alone, and the petitioner alone, which would not be an impediment for the respondent to proceed against any other person, proceed on investigation any other person.
Please, Milord.
Yes, list the matter.
Sir, date may be given.
25th.
Please.
Maybe decided, my lords, on that
Is
day.
that correct? Yes. 20, list on 25th in preliminary hearing.
Lordships.
Adu adena? Why is it tagged then?
Maybe dealing, my lords, don't know why
Yes. D-link one, first D-link one, interim order idea? Yes. D-link 1.1, interim order subsisting would continue till the next date of hearing, 25th adunu.
Lordships.
Yes. Learned counsel submits, office objections have been complied with, office to verify. Yes.
Number 2.
My lord, I need to file objections.
First charge clause.
No, they are seeking for release of.
Correct, you don't have a first charge. Anta. That's the contention. Interim order ideyalla?
This is after search, my lord.
That thing, my lord. Apart from that, they have gone and seized the FD, converted into money, and they taken DD and gone, which is not permissible in law at all, my lord. It's covered by Honorable Supreme Court decision, which they can go and seize, attach, but they cannot convert FD into cash to take DD and go, my lord. That is a illegal action, my lord. That is one of the.
FD convert ಮಾಡ್ತಾರೆ. Where is that? Where do you get that? Judgment Allah. The fact that they have converted FD into cash and then seized it.
Yes, my lord.
Page 98.
Yes, my lord.
All right, objection haki. Is Siddhartha education da?
Yes, my lord.
ಅದು ತುಂಬಾ ಇದೆ ಬಿಡಿ. Yes. The learned counsel YV Raviraj seeks 2 weeks time to file statement of objections. List the matter on 25th. Objections, if any, by then. Yes.
My lord, office objection may be overruled, my lord. We have made submission, my lord.
Submission ಇದೆಯಾ?
Submission along with counsel submission.
Office accepting the submission of the counsel with the petition, office objections overruled. Next.
Much obliged.
Number 3.
Yes.
Lordship, for the petitioner, Your Lordship. Lordship, in this case, the petitioner's truck was intercepted.
Correct, driver summons serve ಮಾಡಿದ್ದಾರೆ. ಇನ್ಯಾರು ನಿಮ್ ಹುಡ್ಕೊಂಡ್ ಬಂದ್ ಮಾಡಕ್ಕಾಗತ್ತಾ?
No, Your Lordship, the thing is, in the page now, annexure G, Your Lordship, page 34. The payment slip is given at 11:26, Your Lordship. GST MOV 06 is given at 11:25, Your Lordship.
Yes, sir.
Your Lordship, without getting the actual quantity of the goods.
Once a notice has been issued to the driver of the vehicle, immediately, my lords, they have made the payment of penalty. ಮಾಡಿದ್ದಾರೆ and got the vehicle released. More, my lords,
The vehicle is not seized?
ಇಲ್ಲ ರಿಲೀಸ್ ಪೆನಾಲ್ಟಿ ಕಟ್ಟಿ ತಗೊಂಡೋಗಿದ್ದಾರೆ.
Yes.
Now it's an order passed under 129(1)(b, my lords.
That's the matter after 2 weeks.
It's an appealable order. They can go file an appeal.
Your Lordship, the appeal was rejected, Your Lordship.
Where is the appeal
Because
rejection?
no, Your Lordship.
Where is the order rejecting the appeal?
No, Your Lordship, the appeal memo also was not only accepted, Your Lordship.
How do you demonstrate that?
Your Lordship, they did not give us any acknowledgement. They said that its order passed is in the 2 different names.
You file an appeal, we will permit you to file an appeal.
Please, my lords.
The petitioner is before
Let
this.
them file physically so that because.
The petitioner is before this court
Your Lordship,
seeking.
let the matter be passed.
Appeal haki, sir.
Your Lordship, let the matter be passed, Your Lordship. Senior will appeal.
You file an appeal, it's an appealable order. You said appeal was filed, it was not even
Lordship,
taken.
but
I will direct them to take the appeal physically.
Lordship, but the confiscation of goods is not valid, Your Lordship. Because the vehicle was parked and the payment.
Appeal
paid,
ಹೇಳಿ
Your
ಅದೆಲ್ಲ.
Lordship.
Everything appeal, you can urge anything in the appeal. Urge.
Yes, Your Lordship.
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that the vehicle in which the goods were being carried was intercepted and penalty was immediately paid. Therefore, the vehicle was released. All that now remains is the proceeding under 129. In the light of the impugned order being appealable, the petitioner is reserved liberty to file petitioner ought to have preferred an appeal. The learned counsel appearing for the petitioner submits that the appellate authority, office of the appellate authority did not even receive the appeal. Therefore, there is no acknowledgement even of having made an attempt to file an appeal. Be that as it may, I deem it appropriate to direct dispose the petition with a direction to the petitioner to file an appeal in physical mode before the appellate authority. And if the appeal is sought, appeal is filed, the appellate authority shall receive the same, answer it on its merits without reference to the delay or otherwise.
Please.
Yes, all contentions urged in the subject petition shall remain open to be urged before the appellate authority.
Great,
Ordered
Your
according. Yes.
For the respondent.
Yes.
There's a case, Your Lordship.
Refund of ITC.
Refund of ITC, Your Lordship. There is an order of the appellate authority in my favor. Reject the overruling the objections, Your Lordship, that were raised in the order.
Yes, sir.
Now, 2 minutes.
Yes.
Now, that order, Your Lordship, has become final. They have not challenged it. Subsequently, Your Lordship, for 2 years, nothing happened. The order is of 23 till 25, nothing happened. So I go back to the officer and to say that this application has not been processed. Now, in GST, Your Lordship, they have a small problem they have in the GST pattern. Now, physical communication is not encouraged these days. Entire thing is through the system. Now, if you have to get a refund based on an appellate order as a consequential relief, I have to file an application once again. The original application, Your Lordship, stands disposed of. So now I have to file an application again. I can't file it for under the normal column because that, Your Lordship, is from for a particular period, etc. So I file it under the residuary column, any other category. There is a limitation of the period which you can mention. So this is from September to March. I can mention only 1 month, March. Now, the issues are show cause, saying that you have mentioned only month, but your refund is for the entire period. I will now reject it. He restarts the litigation. I write to him saying that this is not a fresh refund application. This is based on an appellate order. Please process it. He rejects it. Now it's a cycle, Your Lordship. Now I go to the appellate authority. He will pass an order in my favor. I go back to them, file a refund application. Now the period again can be a problem. This will keep on going. That is where, Your Lordship, I am before my lords.
File my objections, my lords.
No, file it. Now, what is the problem?
No,
Any impending problem?
no, Your Lord. This refund has to be sanctioned.
Said, refund of, we'll see. Let him file his objections. Heard the learned senior counsel Shivdas appearing for the petitioner. The learned counsel Akash seeks 2 weeks time to file statement of objections. List the matter on 25th. Objections, if any, by then. For 25th and preliminary hearing. Yes.
Because
Next. There's no interim order anyway.
no,
It's
because it's a
refund.
refund. 4 and 5.
4 and 5 both same. Yes.
6.
Non-compliance along with office objections, accepting the submission of the counsel for the petition, office objections overruled. List on 18th in preliminary hearing.
If the petitioner in this case, my lords,
Which matter?
serial number 6, my lords.
Ah,
My lords, the petitioner's bank accounts have been debit
I
frozen. my
know,
lords.
it's frozen. On 18th, you take notice on central tax, sir. Learned counsel, Jeevan Neralgi accepts notice for the respondent. The first office objections hange order really. Jeevan Neralgi accepts notice for the respondent. Petitioner to copy the
Yes.
petitioner to serve set of papers upon the council forthwith. List on 18th. The council to secure, council to Jeevan Neralgi to secure instructions and make his submissions on the next date. List on 18th.
Preliminary hearing 7.
Wait, please, Scott. My lords, this is a petition challenging a notice under section 148 of the Income Tax Act.
Beyond limitation.
Please, my lords, beyond 6 years. Your lordship has passed.
Kodiyat, my order. Yes.
The assessment year is 1617 and the impugned notice was issued on the 10th of April 2023.
beyond the 6-year period.
We'll close it, Raviraj. Yes. The petitioner is before this court seeking the following prayer.
Page 31.
Yes. Heard so and so. On 9/10/2017, it transpires that the petitioner trust furnishes various documents in the course of a scrutiny assessment proceedings, including a financial statement showing the application expenditure and expenditure inter alia. Later on 8/11/2017, return of income was filed for the year assessment year 2016-17, claiming its income to be exempt from sections 11 and 12. The long there assessment order was passed. An assessment order comes to be passed on 2/12/2018 under section 143(3), recording that the details submitted when verified by the assessing officer and accepting the returned income. When things stood thus, after about 5 years, where is the notice? After about 6 years, after about 5 years, a notice emerges on 29/3/2023 from the hands of the respondent, invoking 148A within bracket small b of the Act, alleging inter alia that the trust had incurred legal and professional fees close to 69,47,060 without receiving any services in return. It is then the petitioner appeared and furnished all the documents. Personal hearing was also afforded, but the proceedings continued. It is then the petitioner is before this court on the score that the notice issued under section 148AB is on the face of it without jurisdiction, as it is beyond limitation prescribed under law. The learned counsel would submit that the issue in the list stands answered by what this court has held in terms of its so and so. The learned counsel Y.V. Raviraj, though would in the first blush seek to defend the action, is not in a position to dispute the law as is laid down in the case, laid down in the aforesaid judgment, which follows the judgment of the apex court in the case of Union of India versus Rajiv Bansal. This court, considering the judgments of the apex court, has held as follows. Quote from para 2 to end. In the light of the issue standing answered, I deem it appropriate to follow suit SUIT and grant the relief that is granted in the aforesaid order. Allowed.
My lords, there is one more prayer on another issue. Your lordship may clarify that that may be left open to be determined in appropriate procedure.
Except the issue that is considered, which has led to quashment of the impugned orders, any other issue is left open to be urged and considered by the petitioner and the respondent.
The date of the notice may be mentioned.
10th of April 2023.
Prayer lidiyala ille?
Ide.
Adu date annexure prayer lidadu question. They'll do it.
The notice has been issued by the jurisdiction
151.
officer, the faceless.
My name will be shown for respondent.
Faceless. Learned counsel, name Torsilva Sanmati?
Torsila.
Registry to print the name of E.I. Sanmati as appearing for the respondent. Idu faceless anta bracket alli haki dispose ಮಾಡಿದ್ದೀನಿ.
May I make a mention for serial number 57, my lord, similar faceless issue.
ಯಾವ faceless ಇದೆ ಕೊಡಿ ಇವತ್ತು ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
Serial number 57, my lord.
Serial number
57.
ಆಮೇಲೆ
That's all.
57 and this 8. ಎರಡು the petitioner is before this court seeking the following prayer. In the light of the judgment rendered by this court in so and so chamber ಇದೆ ಕೊಡ್ತಾರೆ. The petition deserves to succeed ಅಂದ್ಬಿಟ್ಟು impugned orders ಏನಿದೆ ಅದೆಲ್ಲ quash ಮಾಡಬೇಕು. Quash ಮಾಡಿ ಅದ್ರಲ್ಲಿ ಏನು reason ಹೇಳಿ. Quashed with the following observations, with the observations made in the course of the order. Yes.
9.
My lords, I beg to appear online, my lords.
Yes, sir.
My lords, this is a income tax disputed demand for assessment year 18-19 of 7.44 crore, which got adjusted subsequently by CPC against my refund, which was due for assessment year 2024-25. Despite there was a stay of this honorable court in operation at the relevant time.
Yes.
So they they have recovered 7.4 crore.
I think
tax.
refund ಆಗ್ಬೇಕಲ್ಲ.
Your Lordship, one
Yes, my
submission.
lords.
Annexure F assessment order, 148 is issued beyond 29/3/2024. Spaceless ಅಲ್ಲಿ ಹೋಗ್ಬಿಡುತ್ತೆ.
One minute, come to annexure A.
Annexure F.
F page.
Page number 88.
88.
148, second line. Page number 88, Lord. Second line, assessment. notice-
Assessment year is 2018-19.
148 notice is issued on 18/4/22.
Beyond limitation.
ಅಲ್ಲ 29/3/22 ಗೆ ಫೇಸ್ಲೆಸ್ ಸ್ಕೀಮ್ ಬಂತು. ಇದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಹೋಗ್ಬಿಡುತ್ತೆ.
Correct,
Let them
correct.
amend it and let them-
29/3/22, correct.
let them amend this petition and withdraw the
Yes.
first appeal.
You
My
heard
lords,
it.
I am before my lords to get a complete waiver of pre-deposit of 20%, which is asked. I am already before CITC.
We'll see, we'll take it on 25th.
Please.
Yes. Doesn't want it to be allowed.
10,
Yes.
This is a challenge to the order where, my lords, I have issued invoices for common input services to my other branches. The department's contention is ideally I should have distributed this credit to the ISD mechanism instead of issuing invoices. This precise issue is considered by the circular. I have filed a compilation.
My lord,
Para 1 of the
submission
circular.
is- I have just received instructions 2 days back. I'll complete my pleadings.
Interim order ಇದೆ.
Interim order.
In fact, this has been last 3 months, this is the same time, the same, see the order of 23rd July.
No worries, sir. Next time ಅಷ್ಟೇ. The learned counsel Arvind Chavan submits that he has received instructions and would take 2 weeks time to file statement of objections. Objections, if any, by the next date. List the matter on 25th. Interim order subsisting would continue to the next date of
Same
hearing.
stage. months.
ಎಲ್ಲರೂ preliminary ಕೇಳಿದ್ರೆ ಹೆಂಗೆ ಸಾಧ್ಯ? Everybody are asking preliminary hearing, what can be done? We'll take it, don't, yes.
11,
Whatever is possible, we'll do. 11. Last time argue ಮಾಡಿದ್ದ ಇದು?
No, I did not. That was at 4 o'clock lordships have today.
Yes,
That's-
yes.
This matter ಕೂತ್ಕೊಳ್ಳಿ ದಯವಿಟ್ಟು. Pertains to seeking lordship's indulgence for waiver of pre-deposit amount before the appellate tribunal. Section 129E, lordships may kindly.
ಕೊಡಿ. ಕೊಡಿ ಮೇಡಮ್.
Customs Act.
129 Customs Act.
Customs. Deposit of a certain percentage, 129E subclause 1. The tribunal, in this case, the tribunal, commissioner appeals as the case may shall not entertain an appeal under subsection 1 of section 128 unless the appellant has deposited 7.5% of the duty in case where duty and penalty are in dispute, or penalty where such penalty is in dispute in pursuance of a decision or an order passed by an officer of the customs lower in rank than the principal commissioner of customs or commissioner of customs. Proviso 1 limits the deposit to 10 crores. One of the contentions the state, the first respondent has taken is that under Article 226, this court would be disabled in exercising its jurisdiction for waiver of that penalty. But I must place before your lordship judgment. Second. But that consistently, different high courts have taken the view, of course, not well settled. If my lords are to see this compilation.
Yes.
Second judgment, not page number 12, if lordships are to see. This was from Delhi High Court. Para 9. Paragraph 9. A direction, therefore, it starts from the word. To the sestage that it should waive the pre-deposit would be contrary to the express legislative intent expressed in the amended section 35F with effect from 6th August 2004. Paragraph 9, page number 15.
Yes, sir.
While the jurisdiction of the High Court under Article 226 of the Constitution to grant relief, notwithstanding the amended 35F, cannot be possibly be taken away, the court is of the view that the said power should be used in a rare and deserving cases. This is the position. Then with second judgment, my lords may kindly see page 33, Techmax Electronics.
Yes.
Relevant portion, lords, would be at page, my lords, 39. First 37, lords may kindly see para 11. The court has heard the para 11.
Yes, yes.
The court has heard the parties and perused the various decisions relied upon by the parties. The issue of whether this court has the discretion to waive the mandatory pre-deposit under 129E of the Customs Act is no longer res integra in view of the consistent decisions passed by the Supreme Court and this court. But then, para 13, Diamond Entertainment Technologies is cited at page 39. Though it may be argued that this writ court in exercises of its inherent powers conferred on it by Article 226 of the Constitution of India, in appropriate cases may allow the appellant to prosecute its appeal before sestat without requiring to pay the mandatory pre-deposit.
Yes.
The law is summed up, lords, at
Para
paragraph-
17.
Yes, 50. Then there is one more judgment, last judgment, Muhammad Akman Uddin Ahmad. That is at serial number 7. They reiterate the position of law. The reason
The position is in rare and exceptional cases,
Rare and
this court
exceptional cases.
can exercise
Of course.
jurisdiction, but none of the cases you have given, court has said it is not a rare and exceptional
Alla
case.
like Madi. In that Akramuddin case, they have done page 50 and 61.
Delhi High Court.
Delhi High Court. On the ground of financial hardship.
Financial hardship.
Madida.
Everybody will project that.
No, I'm not. I'm only reiterating the position before your lordship that this court does have the power because of the specific ground. Lord, kindly see by page 60.
Page 60, para 19.
20.2 only they waive off that.
Para 19 is what is analyzed.
Yes. No, para
When the
20.2.
financial position and wherewithal of the petitioners, an opportunity needs to be given to them to contest the valuation so imposed by the respondents.
Therefore, Lord, they have.
What are the facts
Yes,
here?
I'll have now. It is not now. The burden is upon me, having met this preliminary objection they have raised, as to whether or not this would be a case where lordships may have to exercise lordships extraordinary jurisdiction under Article 226.
Extraordinary case.
Extraordinary jurisdiction, Lord, and ultimately, my Lord, the reason why, my Lord, they say lordships are vested with this power is in order to, my Lord, appreciate the fine distinction. Sometimes, my Lord, which the executive or that the decision-making authority at the adjudicating level do not go through. But I may quickly state before your lordships what are the
Now,
facts.
the financial position is not.
It's not on a different ground. I must bring to. I should not. What has been imposed upon us is a sum of about 455 crores.
All right.
To state the exact amount, but it's about 450.
What is
crores.
7.5% deposit?
No, 7.5% or 10 crores is the ceiling limit.
Ceiling
So we'll have
limit,
to pay.
10 crores. Yes.
But the only point is this point. The case of the adjudicating authority is that, so what is exempted from customs duty is crude palm oil, and what we have imported is crude palm oil is exempted. What we have imported is crude palm oil. Therefore, we are not entitled. This is the only distinction. Customs tariff.
What's the difference between the two?
There is no difference is what we want to bring to lordships notice. That is the only interpretation. May I request lordships to kindly see
Palm oil and
palm oil. But may I request lordships first to see, permit me to read for your
Yes, sir. Page.
how the exemption is given. But if lordships are to now just now what I have passed down before your lordships, the custom tariff act.
Custom tariff act. Yes.
Custom tariff act, the first schedule import of the tariff.
Act kotra.
ಈಗ just now custom tariff act.
Yes.
But in that lordships may
Schedule.
kindly- But I had marked it. 1 second. I'll just point out. None copy out for the side.
ಬರೀ ಮೀಟ ಇದೆ.
Yes, Lord, Lord, may I request Lordships to kindly see in that mode, there is no marking in that mode. Last few mode.
I don't find palm oil, very boneless chicken is.
Yes. But I'll just point.
Live swine,
No, but
boneless.
Lordships may kindly see this one. But I'll just mark and pass it. Lordships.
ಕೊಡಿ.
There are two entries there. 1511 and 151100.
Oh, it's here. ಮಾಡಿದೀರಾ mark ಮಾಡಿ.
1511.
Mark ಮಾಡಿದೀರಾ. It's at the end anyway. Palm oil and its fractions, whether or not
That
refined
was exempted. That was exempted.
from customs duty.
One second. Now, palm oil and its fractions were in. What is a fraction, Lords? Is
Refined, bleached, deodorized palmolin.
what is the difference between palm oil and palmolin? In fact, the
That is what I want.
The authority discusses it. It is the same. But may I
Authority alla. Other than the authority, you have something?
Yes, yes, the expert is, experts, this one is there. May I request Lordships to kindly see page 287
Of the paper book?
writ petition. Yes.
Yes. Ah.
287 ನಲ್ಲಿ opinion on dated 29/8/2024, Professor Amit Pratap, the Institute of Chemical Technology. But may I request Lordships to kindly see the last paragraph, 2. It is generally observed crude palmolin oil and crude palm are quite similar when iodine value of palm oil is in range of 53-54. It can be considered nearly identical to crude palmolin oil, as crude palm oil stored in large tanks for longer duration, palm fractions get settled in bottom portion and top portion will have material similar to crude palmolin oil. Now kindly see the next sentence. Shri Avinash Kumar Shukla has commented on difference of crude palm oil and crude palmolin. He submitted that crude palm oil is derived from the mesocrop of fresh fruit, palm of palm fruit, and crude palm kernel oil is derived from so and so, so and so. Lord, then let's kindly see page number. The difference here, tabular column is being given. Basically, at page note 70. Page 70. Page 70, tabular column, distinction between crude. Page 70 of the writ petition.
Yes.
Page 70. Distinction between crude palm oil and crude palmolin. Kindly see entry 8, one of the distinction. Crude palm oil is a base material. Crude palmolin is obtained by fractionation of crude palm oil. Lordships have seen entry 15100. Crude oil
1511.
Crude oil and all its fraction. Therefore, what actually happened was this. From Indonesia, we used to import crude palm oil earlier. Indonesia banned crude palm oil. So crude palmolin, which is a fraction of crude palm oil, started being imported. Indian government actually exempted customs duty for this reason. Both when refined becomes edible, palm oil for human consumption. The object of the exemption was to make available to the consumers at a lower price. But while granting exemption, they only refer to crude palmolin. That Lordships may kindly see that in that Customs Tariff Act I have given. Kindly see the exemption, how it was given. That first page of that, just now. Otherly, yes.
Objections ಹಾಕಿದ್ದಾರೆ.
I have filed objections. It is limited to.
I'm only trying to make out before your Lordships as to why only on this interpretation, not the entire case, not at first one Lordships. What was exempted was 1511-1000 crude palm oil, they said. Now, our objection has been throughout is the object of how an exemption notification must be construed is it must be construed with reference to the original which was given. That is the only interpretation. Having regard to this, Lord, this request has been made to either exempt us or partially exempt us from Lord's paying the pre-deposit.
Andre 5 crores madbeka?
No, I would not say any amount, but I would beseech lordships Lord, jurisdiction for this reason. Ultimately, Lord, it would all depends upon this interpretation of these two words, nothing else. It therefore becomes an extraordinary case for lordships Lord's kind interference.
My humble submission is that after section 129E, after amendment 2014, my lord, before amendment, it was for 100% that has to be paid, my lord.
Cap
After
is 10
amendment, it
crores.
is, my lord, the Honorable Supreme Court and the Delhi High Court in the latest judgment has.
Alla, adaitu, but exemption. He's on the other point. Now appeal, you have to pay, that's a different thing. 129E cannot be relaxed unless there is rare circumstance.
Yes.
You may not find any rare circumstance
Honorable
here.
Supreme Court has held that 129E after amendment cannot be relaxed at all because
sorry.
earlier it was 100%.
100%.
Now it is 70.
10 crores.
No, the Supreme
So
Court
what is
has
the
not,
statute
10 crores.
the
imposition?
Honorable Supreme Court has not held that it cannot be relaxed. The law is not that it can be relaxed.
You've seen
No,
this?
I have not.
Chandrasekhar Jha.
Please, Lord.
Prior to substitution, it was relaxable because of the onerous
Was 100%.
amount. Yes.
No, this judgment, what I have seen, this judgment, Lord, their lordship say that, 1 second, sir, adjudicating authority does not have the power to relax. But kindly see that. Para 10. There is no dispute about that. Therefore, Lord, we invoke lordship's jurisdiction on Article 226. Lord, kindly see para 9. It is in sharp departure from the previous regime that the new provision has been enacted.
Yes.
Under the new regime, on the one hand, the amount to be deposited to maintainable has been reduced from 100% to 7%. But the discretion which was made available to the appellate body to scale down the pre-deposit has now been taken.
Has been taken away.
Taken away by the authority. Therefore, Lord, Delhi High Court, Lord, their lordships,
Para 12 may
consistent
also
decision.
be.
No, that is not, in fact, not Lord. I don't have to labor much, Lord. It runs contrary to principle of Chandar Kumar's case, where, my lord, the jurisdiction of this court under Article 226 cannot be abridged even by a constitutional provision. It's in that line, my lords, what their lordships hold in that Chandrasekhar Jha's case is that authority does not have the jurisdiction. But that this pedantic, my lord, approach of construing.
This is, if you give liberal construction to this, why?
I'm not on this one. Pedantic approach by the authorities of the exemption applications.
Authorities will not do it.
Yes,
That's a
therefore,
different- why would
their
they do
hands are tied. But this kind of interpretation, in fact, the Honorable Supreme Court says, exemption applications must be liberally construed. When you first gave exemption to crude oil, and
But
all
para
its
11
fractions must also be exempted, is a natural way of it.
Delhi, 2024.
2044. In fact, my lord, para 11 of this Honorable Supreme
Yes,
Court,
yes, I
the
saw.
appeal was filed in 2013.
I saw
Even then,
Saw that.
no, Delhi is 2024 matter, my lord.
Paragraph.
Paragraph 11, man. Para 11.
This so Chandrasekhar Jha's case was about. Anyway, lordships, my.
My lord, because of amendment, the only problem is that such state cannot proceed with the appeal, my lord. They have to deposit.
But that
In
No,
fact,
there are
from
not only this enactment, several enactments which mandate pre-deposit have all been affirmed because that's the prerequisite.
May I make note? But this Delhi judgment, once again, now that lordships.
Unless now you're saying the extraordinary circumstance, that extraordinary circumstance is gone now.
No, Lord, that Delhi judgment, my lordship, Justice Pratibha Singh's judgment
ಈಗ
deals with the
2024.
2025.
2025, but there it is not.
No, the principle of law, my lords, is.
ಈಗ now you come on merits, why you can't? You're on exemption.
Exemption, Lord, and how exemption applications must be construed. Not kindly see this first judgment, Lords, in that compilation. Assistant Commissioner LTU and another. But kindly see paragraph 26 and 27. As to how much the exemption application requires to be construed. Para 26.
Which judgment did you say?
Look, that is more the CST versus Amara Raja batteries.
E compilation.
Oh, page number 10, para 26.
CST versus.
It is now a well-established principle of law that whereas eligibility criteria laid down in exemption notification are required to be construed strictly, once it is found that the applicant satisfies the same, the exemption notification should be construed liberally. Then 28 lots.
He is on that. Now, 129E we will not tinker, but if it is exempted, now palm oil is exempted. Palm oil, you have now said it is subject to duty. Now, if palm oil is a derivative of palm oil.
Already, my learned friend is in appeal before this estate, my lord. He is not contested on merits here. The only relief he sought in this writ petition is that waiver of pre-deposit of 7.5%.
Correct. Waiver is linked to the exemption that he is now seeking.
My lord, exemption, my lord, if lordship permit me, I'll quote. There are various Supreme Court judgments which says exemption should be considered extremely strict, my lord. Because exemption is something which is a benefit given to the assessee.
Correct.
Once it is given to the assessee, he has to establish that he falls under the category.
Before
That he has to establish before the authority, my lord, such that.
But that would not take away 129E.
Please,
no, the right of appeal.
My lord, one more thing.
My
learned friend
is right of an appeal which conditioned with an onerous,
correct,
onerous condition cannot be exercised at all. But this is the first principle. Second principle is not what the challenge to 129E virus. But I do not know whether it is an appeal, but we have not challenged it. But what their lordships now consistently, all the high courts hold is, though it is true that 129E prescribes and takes away the discretion of the appellate authority from waiving it, but that does not take away the power of the Article 226 to waive it. So in the
power of this court,
therefore, that is, as lordships observed, it is linked to I making out a now today. What has happened is a pedantic approach to these notifications by the authorities concerned literally takes away my ability to contest the appeal without making a pre-deposit. If at all, my lords, if it is not even an arguable case. On the face of it, if I am able to demonstrate.
Is that just Pratibha Singh's judgment 2025?
Yes, that is TechMax. That is at page 3346. Page 33 to 46.
That's 2025.
Yes, 2025. The latest 28th August. This is the latest judgment. This is not 28th August.
No, it's not exempted here. The exemption is not given.
There they did not exercise their jurisdiction. Then, the next judgment actually Texplus India Limited, not Texplus, sorry, the page at page 51.
Mohammad Akram.
Now, Mohammad Akram Ali, they have exhaustively considered the question. But the problem comes here, not this. All that is required is a true construction of that word crude oil. Whether it includes a fraction, it includes a fraction, is what I am saying before. But either a partial exemption to us or a complete exemption is what we have prayed. Even a partial exemption to us, or a deferred payment.
The appeal is not entertained now.
We have filed the appeal. We have approached your lordships and exercised that.
Up to 129E, we may have to, we'll see.
No, I will only put it.
What is the rare circumstance that?
No, the rare circumstance. I will put it. It need not.
Palm oil is not rare circumstance.
No, I will put it across in this way.
Yes.
If on the face of it, of an interpretation of a notification, on the face of it, without any argument, it is shown.
That appeal alla customs duty ne baralla.
Barodilla.
Barodilla andmele appeal.
Therefore, Mulad, this is something, Mulad, where if I can show a case beyond the prima facie one, yet, Mulad, today I am conditioned to pay 10 crores. Therefore, Mulad, we have invoked lordships extraordinary jurisdiction. But this argument, I cannot, even if I make before the appellate authority, I still cannot be exempted from payment of.
No, first 10 crores admele you can make this argument.
No, that is the whole thing is about that. But I'll only put
prerequisite is money.
I will make this request before your lordships. Even if a partial exemption is given, we will get some instructions to make that payment. But the entire amount, when on the face of it, if I have to persuade your lordships once again to take.
No, 435 crores is the duty.
Yes, 435 crores. That is, and we have paid the duty. I mean, we have taken the exemptions, certified by them, imported everything. Thereafter, they revisit it by issuing a show cause.
It's on a revisit.
Yes, it is revisiting.
Why did you permit?
They permitted us.
Why did you permit?
I don't have instruction. Why it was?
And not only that,
No,
my lord,
why
after-
did you permit, why did you
after
affix
lab
your seal
report-
saying that it is perfectly exempted from duty and then revisit it? What is this?
And after a lab report, Lordships may kindly see the lab report was taken. They said it is, they certified that it is crude oil coming within the definition. After everything is over, that they have revisited. Not, may I request Lordships to kindly see?
Where is that order?
Yes.
Permitting you to import without duty?
Yes, my lord, I'll just point.
It's not in dispute that you have imported something else, only this.
Same thing, lord, same thing. There's nothing else. But may I request Lordships to kindly see at para 7. Para 7 of the writ petition.
Other pleading, where is the order?
No, other bardi there. In the show cause notice, it is there. I'll just point.
You don't have the order of permitting you?
No, that they have recorded that it was permitted. The department itself records. May I request?
Page.
Please. Lords, may I? Lord, there is no.
Yes,
dispute.
Arvind, why do you do that?
My lord, maybe.
Lords, may I request?
permit
May I
body-
request just to permit Lordships to permit me to read para 7, just para 7 of the writ petition. Para 7. There is no dispute, Mulappa. In June 2022, export of crude palm oil was banned in Indonesia. For the purpose of continuing the business, the petitioner decided to import crude palm oil in, which is a fraction of crude palm oil from Indonesia. The petitioner has imported 7 consignment of crude palm oil in during period from 17/6/2022 to 5/1/2023. For the said,
You are not permitted.
no, it's there further. I'm sorry. For the said imports, general manifest specifying the description of the goods, number and date of bill landing and quantity of the said goods were filed by the vessel agent prior to the arrival of vessel consignment.
Sample was taken both.
Samples of
so-and-so.
imported goods were taken both by the petitioner as well as the custom authorities to
Correct.
determine the nature.
FSA identifying the nature of import.
Identifying the test
reports provided so and so confirm that the goods imported crude palm oil in,
Yeah.
and the same is the nature of other than refined, bleached and deodorized. The test report obtained with petitioner through private laboratories in conformity so and so. It was not cleared.
Last sentence.
Test reports.
Further, the benefit of nil duty availed by the petitioner under the said exemption notification was indicated in the said BOEs, and the consignments were allowed to be cleared by the proper officer of customs after verification of BOEs filed by the petitioner.
Where are those?
But that I can produce it. I can produce it.
And you also see about the exemption and get back.
Please, my lord, the only.
This is an important issue having ramifications, not yes.
My lord, Honorable Delhi High Court also Tax Max. The court only
A
benefit. that
power
has
of the
given is
court
just-
to do it. It is rejected there.
They have given some extended time, 2 months or 3 months for them to make payment.
cases-
That
ಅದು
is-
ಬೇಕಾದ್ರೆ ಕೊಡ್ತೀನಿ.
that can be extended. my lord.
Not the jurisdiction. I only wanted to make this. Why that power is
Except
vested?
asking an EMI, you ask
No,
anything
no,
else.
why the
Yes.
power is vested with your lordship sees and that, why they have give that power lordships? Only this distinction could be made by your lordship. We
Let us
cannot go
see.
before the authorities who make a pedantic approach. It is your lordships lords who in number of cases, particularly in Customs Tariffs Act, have made the distinction to see object of the exemption must be fulfilled. Not
Give me all
Yeah,
that,
I'll-
all those orders. Why compilation you don't file?
this earlier one. I will file. Lordship.
All that, see, all that you want to lay support on should be here. Yes. Heard the learned senior counsel, Public Navatgi appearing for the petitioner. Again, ತೊಂದ್ರೆ ಏನಾಗಿಲ್ಲಲ್ಲ?
No, and that is interim order. We have said let them not take coercive action.
ಅದೇನಿಲ್ಲ interim order ಅಲ್ಲಿ.
We have asked.
Asked, yes. The learned senior counsel makes his, is on twin fold submissions. The first fold is with regard to the power of this court to entertain the petition or direct entertainment of an appeal before the appellate authority as obtaining under subclause E of section 129 without a deposit. The section 129 reads as follows. Section 129E reads as follows. The proviso to section 129E mandates that the appeal would be entertained only when the deposit maximum to an amount of 10 crores is paid. The duty imposed upon the petitioners in the case at hand runs to staggering 435 crores.
450,
452.
54.
454 crores. The learned senior counsel submits that the goods that are imported are palm oil, which is a derivative of palm oil. The learned senior counsel submits that palm oil is exempt from customs duty, so the derivative also should follow suit by granting such exemption. The learned senior, on these twin folds.
And that both of them were classified as the same subject matter under the customs tax.
Yes, that
Act.
are the final order. The learned senior counsel further submits that partial exemption of the cap of 10 crores also should merit consideration at the hands of this court to be with a direction to the appellate authority. The learned counsel Arvind Chavan would seek weeks' time to secure instructions and make his submissions on the issue. In the light of the issue meriting consideration till the next date, no coercive steps would be taken against the petitioner. List on 18th in preliminary hearing. Those orders alla compile ಮಾಡಿ ಕೊಡಿ ಅದು.
Please.
12.
Should be a service tax matter.
Huh?
Service tax matter it is.
So?
My lordship, our reply was not considered. In the order it says reply was not filed. And personal hearing was sent to my old address. Never attended. So
ಯಾರು
all
ಜೀವನ್
asked-
ನೆರಳಿಗೆಯ
Chinmay.
ಚಿನ್ಮಯ ಸೇವಾ ಟ್ರಸ್ಟ್.
Remand back with
To the stage of reply to the show cause.
Correct, yes. The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that the notice to submit a reply to the notice never reached the doors of the petitioner or the inbox of the petitioner. The learned counsel for the petitioner further submits that the issue in the list stands answered by the judgment rendered by the coordinate bench in Chinmaya Seva Trust. Adu quote ಮಾಡಿ. Same. Allowed, quashed. The matter is remitted back to the hands of the, which authority? Ondena?
Yes.
Back to the hands of the, which respondent?
3.
Respondent number 3. From a stage to a stage of submitting reply to the show cause notice. It is open to the authority to regulate its procedure and take the issue to its logical conclusion. Yes.
Obliged.
Ordered according.
This is that
Refund.
refund matter which came up last week, covered by your lordship's decisions in 2 matters, but those orders are not.
Saicom alva. Saicom
and,
bandila. Correct ಮಾಡಿ sign
USL
ಮಾಡಿದೆ.
last week your lordships disposed, but otherwise B's was the first decision.
Following
if I
that
may-
only I have done it.
Yes.
But Saicom is not, ಅದು ಸ್ವಲ್ಪ. I have now
B's,
signed it. It will
B's
come.
is learned single judge affirmed by the DB also.
ಕೊಡಿ.
My lord, there was a difficulty, my lord, because merger, my lord, there were 3 mergers, my lord, and that's why, my lord, the communication could not be made in time.
3 mergers. Merge everything and refund. How is merger got to do
No,
with?
because the PAN number will get changed.
That is verification. If they are entitled to refund, they are entitled to refund.
Please.
Merger or no merger, it's verification. No, PAN change ಆದ ತಕ್ಷಣ refund
Illa,
ಹೋಗ್ಬಿಡುತ್ತೆ.
that's why, I'm not saying
The entity remains.
order could not be passed.
Aಷ್ಟೇನಾ?
As far as the
That,
counter
my
filed
lord,
by
that
them,
submission may be recorded as that.
That will do.
in the counter filed by them, the only stand taken by them is the provision which existed
No,
prior to the
Saicom ali
2000.
what had happened was they had adjusted towards an assessment that was pending assessment until 6 years ago. There was no assessment pending.
Oh.
So in that Saicom I directed that.
Slightly different fact.
It's slightly
Really,
different here.
2003-4 is the assessment year in which the tribunal passed the order in 2017.
Yes.
That is, my lords will get it at annexure E,
Page.
page 117. The order, as your lordships will see, is 3/4/2017.
Correct.
This order, the proviso, second proviso to section 153(5) says that from the end of the financial year. in
That
which-
is what I have held in that Saicom.
Correct. So the time period expires on 31st December 2018 as per the second proviso to 153(5).
Correct.
Now, the TP OG to the tribunal's order by the transfer pricing officer himself was passed on 24/10/2019, which your lordships will get at page 145. And thereafter, no final assessment order has been passed even till date. So 31/12/2018, the time for giving effect to
that
the
is
tribunal's
over,
order
yes.
has expired.
So refund follows. That's what is.
We have contended, my lord, section 153(9) stipulates that, my lord, so far as the assessment reassessment prior to 1st June 2016, old provisions will apply.
That's been dealt with in both the
Both these
B's and
judgments?
the other decision in USL also,
Yes.
which has also been affirmed by the
The
division bench.
petitioner is before this court seeking a direction by issuance of a writ in the nature of mandamus, directing the respondents to refund an amount of 19 crore, 19 lakhs,
19 crores.
19 crore 89 lakh 19,122, along with applicable interest. Heard the learned senior counsel in Narayan, the counsels represent Ellaridira. Counsel shows one matter just all three.
Represent CPC.
All fine. What is that, sir?
This is USL affirmed by the DB.
This is also affirmed by DB.
P is also affirmed by it. That point of 153(9) has been dealt with elaborately in
Yes,
USL.
USL I have followed.
In US.
Yes. The petitioner is a company engaged in the business of providing software development, marketing, consultancy, and related services to Blue Yonder, which was earlier known as I2 Technologies and its affiliate companies. For the assessment year 2003-4, return of income filed by the petitioner was picked up for scrutiny assessment, and in the course of the assessment proceedings, the transfer pricing officer passes an order determining transfer pricing adjustments. This led to the petitioner approaching the Commission of Income Tax Appeals on 31/1/2014, which comes to be allowed in favor of the SSE on 3/4/2017.
CIT appeals order is 31/1/2014.
Against that, he went to the tribunal.
Against that, we
The-
both revenue and SC went to the tribunal.
The
CIT
petitioner files an appeal before the Commissioner Income Tax Appeals, which comes to be disposed on 31/1/2014, against which both the SSC and the revenue were before the tribunal. The tribunal, in terms of its order dated 3/4/2017, passes an order, disposes the appeals, remitting the matter on certain issues to the assessing officer with a direction to consider the said issues afresh in accordance with the observations made in the course of the order by the tribunal. The order was passed on 3/4/2017. Time ticked, and the assessing officer did not initiate any proceedings in terms of the liberty that was granted by the tribunal. After about 2 years, the assessing office,
The transfer pricing.
the TPO, on 4/1/2021, the petitioner is said to have come to know that a demand of rupees 3 crore 60 lakhs was appearing as outstanding for the year under consideration, emanating from an intimation. What intimation? Emanating from an earlier intimation. The petitioner then is said to have communicated to the respondents that the respondents seeking all necessary information with regard to the observation that was found on 4/1/2021. The petitioner is then given to understand by the communication that that for the assessment year 2003-4, the impugned demand was raised. The petitioner then demand madidru.
Demand was showing in the portal. 3 crore.
The
although
demand was shown in the portal. The petitioner then files his objections to the adjustments so made and seeks refund for the assessment year 2003-4, and on the score that the third respondent had failed to pass any order excising liberty that was granted by the tribunal while disposing the aforesaid appeal. The non-consideration of the representation or claim for the, of the petitioner seeking, seeking refund, the petitioner is before this court in the subject petition. The learned senior counsel, Surnaran, appearing for the petitioner, would submit that the issue in the list stands answered by judgment rendered by the coordinate bench in writ petition so and so, as also the division bench in United Spirits Limited. All the United Spirits Limited, the division benches in the aforesaid orders would clearly hold that if the transfer pricing officer has not exercised the liberty that is granted by the tribunal while passing an order, on account of delay, the petitioner, the assessee, would be entitled to a relief of refund, the refund for a particular assessment year, which was the subject matter of the subject matter before the tribunal. In the learned counsel appearing for the respondent would, however, dispute the
Para 2.3 and 5 of the statement of objections.
the learned counsel for the respondent, YB Raviraj, and the other counsels would in unison submit that para
2.3 and 5 of my statement of objections.
Objections ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದಾರೆ.
10th June. 10th June.
2.3 and 5.
5.
The learned counsel would seek to place reliance upon subsection 9 of section 153 to buttress their submission that it is the pre-amended provisions to 153(3) of the Act that would prevail, and the assessing officer is entitled to pass consequential orders at any point in time. The learned senior counsel
Also,
with
one more point, that there were frequent changes in the due to
Amal, the merger. The refund is not processed. Refund, if at all the petitioner was entitled to, also is not processed on the score that there has been 3 mergers.
order itself. Order giving effect to itself.
The tribunal's order. All right, yes. The learned counsel would seek to defend the action of the respondent not passing any order pursuant to the liberty granted by the tribunal on the score that there has been 3 mergers of the subject company, and therefore the orders are not passed.
The jurisdiction of the officers also will change.
Orders are not passed in the light of the jurisdiction of the officers changing on account of the mergers of the petitioner. He would seek dismissal of the petition. I have given my response. The aforenarrated facts are not in this. The aforenarrated facts link in the chain of events and the dates are not in dispute. The issue is whether the petitioner would become entitled to a refund that is claimed. The assessment year was picked up. Assessment year 2003-4 was picked up for scrutiny assessment. Is not in dispute. The petitioner files an appeal before the commercial tax appeals. Appeals of what appeal is that?
Commissioner of
Income Tax Appeals, who dispose the appeal, which both the revenue and the assessee get aggrieved and approach the tribunal. The tribunal, in terms of its order dated, what is that? 3/4/2017, disposes the appeal by the following order. Where do you get that?
Annexure E, my lord, page.
The operative portion.
Operative portion, there are multiple paragraphs, my
lord. Liberty ಕೊಟ್ಟಿದ್ದೆ
multiple paragraphs, if my lord.
Multiple liberty.
Because each issue they remanded it back, issue wise. Paragraph 9 is the first
TP
issue of
125.
remand on TP.
125.
Then paragraph 11. Then paragraph 15.
Paragraph ಹೇಳಿ sir. 9.
9, 11, 15. And then, my lord, paragraph 21 and paragraph 26.
The appellate tribunal, the tribunal, while reserving liberty to the revenue to proceed further or proceed afresh, by the following observations, paragraphs ಹಾಕ್ಬಿಡಿ. The order of the tribunal, as observed here and above, was on 3/4/2017. Time passes by, there is no action taken by the respondent, in terms of the liberty so reserved by the tribunal. The justification of the respondent revenue that there were mergers and therefore no action could be taken is a submission that is noted only to be rejected for the reason that the order of the tribunal to be implemented, whether merger or otherwise, would not come in the way. It is an admitted fact that the petitioner, that no action is taken pursuant to the order of the tribunal on 3/4/2017. Even otherwise, the issue is completely answered by the judgment rendered by the coordinate bench in BC. That is para 8 in the para 8 to 21.
Actually, dates, paragraph 14 is enough, my lord, because the dates are also mentioned.
Para 14 Saka.
How?
Paragraph 14 to
14 to
18, sorry, 14 to 21. Again, the division bench in
this was affirmed by division bench, and in USL learned single judge's order deals with
is affirmed again.
153(9).
Yes.
That's also affirmed by the.
That's again para 9 to 19. Merger also is considered in this. Yes. In the light of the law, in the light of the elucidation of law by the coordinate bench, which stands affirmed by the division bench in both the cases, or the judgment of the division bench itself, this court need not delve deep into the matter. In the light of the issue standing answered and the issue in the case at hand covering, and the issue standing answered and the said issue covering the subject list on all its force, the petition deserves to succeed with a direction to the respondent authority to process refund and consider the claim and process refund and pay the petitioner the outer limit of
With applicable interest.
of course applicable, with applicable interest.
3 months.
ಎಷ್ಟು months?
3 months.
3 months.
Already 2 years ಆಗಿದೆ.
Interest
Follow
for
ಮಾಡ್ತಾರೆ.
applicable interest. Yes.
8 weeks ಮಾಡೋಣ.
12 weeks.
Reasonable.
12 weeks.
Very.
Within 12 weeks from the date of receipt of the copy of the order.
There's some similar matters, if I may just pass on the list.
ಇವತ್ತಿದೆಯಾ?
ಇವತ್ತಿಲ್ಲ, but
All
covered
refund matters.
Next week, maybe perhaps.
We'll see. ಕೊಟ್ಟಿರಿ. We'll see. Yes. All covered by USL and others?
ಹೌದು.
Lord, serial number 13. I request a short accommodation. Lordship may have it on 25th month.
13 ಅಲ್ವಾ ಈಗ ಆಗಿದೆ ಯಾವುದು?
13.
ಇವಾಗ ಆಗಿದೆ 13.
Oh, sorry, 14.
Learned Counsel Arvind Chavan seeks 2 weeks time to file statement of objections.
Interim order, Your Lordship.
4 weeks time to file statement of objections. Interim order subsisting would continue to the next day.
Obliged. I'm grateful.
15.
Your Lordship, in this matter, I'm challenging the order of rejection of my fresh GST application for having not filed returns associated to the previously cancelled GST registration number.
Last time I've heard you.
Yes, my lord. It was auto-generated and I have not conducted any business. And subsequent to its auto-generation, I have surrendered my VAT within a month itself.
Yes. They are Jeevan, huh?
I apply for respond number 3, ma'am. Some, my lord, factual aspects, my lord. They say that, my lord, they surrendered earlier in the VAT regime. They surrendered their GST registration, and, my lord, due to which, my lord, the GST registration never deemed to have been taken.
Oh, penalty is already imposed.
Penalty has been imposed and late fee has been imposed for having not filed returns where I have not even conducted business. Page number 30, I have submitted the surrender of VAT certificate.
We'll arrest the penalty, let him apply or represent and clarify everything.
Please, please.
Till then, we'll arrest the penalty. Yes. The petitioner
I don't know if they are intending to surrender the, my lord, GST registration. Why did they apply it, my lord? Is again.
I have the enrollment process which has been.
ಇದು ಒಂದು escape ಆಗಕ್ಕೆ ಇನ್ನೊಂದು ಅಷ್ಟೇ.
They didn't want to GST registration, but they applied it subsequently.
Lordship,
But we had already granted the GST registration.
Lordship, I'm submitting the enrollment process of GST, which is updated online. The very first page shows
Sir,
that all existing tax.
Let him say before the authorities.
The petitioner is before this court seeking the following prayer. The petitioner heard so and so. Facts in brief. What are you?
I am petition number 1 is an applicant. Petition number 2 is a one person.
In the month of October 2024, the first petitioner applies for a fresh GST registration to secure a letter of undertaking for the export of services in terms of a necessary application. Show cause notice avagale kotra.
Immediately they have issued a show cause.
A show cause notice was issued to the petitioner on receipt of the said application on 17/10/2024, which was replied to by the petitioner, and despite the said reply, the proceedings were taken forward and a penalty is imposed upon the petitioner and the late fee of seeking registration of the GST. The reason for imposition of penalty is that the petitioner had already secured a GST registration and therefore it was the second in line. The learned counsel appearing for the petitioner submits that no doubt the registration in GST was taken, but no business was transacted in the said GST registration. Therefore, the second registration emerges.
Lordship, there is one correction here. I have not voluntarily taken the GST registration. In 2017, all existing VAT and taxpayers were auto-migrated to GST, where provisional ID was automatically generated.
That was the first one.
That is first one.
The learned counsel appearing for the petitioner submits that the petitioner was assessed to VAT earlier to the regime of GST, and whoever had taken the VAT registration were automatically to be transposed to the GST regime. Therefore, the GST of the petitioner also stood transposed into the VAT registration also stood transport to the GST regime. This was notwithstanding this, the petitioner had to apply for a fresh GST, and therefore he applies. No fault can be found with the petitioner, much less imposing penalty or late fee for the next registration, as the earlier registration was already in place by operation of law. He would seek quashment of the proceedings. The learned counsel Jeevan Neralgi, though accepts the fact that the VAT regime on the seizure of the VAT regime and the emerging of the GST regime, the VAT registrations would get transposed by operation of law. The petitioner need not have applied for another GST registration. If he has applied, then the law will apply. Late fee is applied, and penalty for not having GST and done business would also become applicable. In that light, he would submit that the petition be dismissed. I have given my anxious considerations. The afore narrated facts, dates, and the link in the chain of events are a matter of record. The petitioner was assessed to who had a VAT registration is not in dispute. The GST regime springs from 4th July 2017, and on the onset of the GST regime, the VAT registrations were automatically transposed to that of the GST regime. Likewise, the petitioner's VAT registration also stood transposed to the GST regime, but no transaction took place in the said GST registration, which was on transfer of a VAT registration. The petitioner then, at a later point in time, secured a separate GST registration and has incurred all the penalty or the late fee for having taken the registration of GST belatedly. When did you take 25 Allah?
24-25.
As the petitioner applied for securing the GST in the year 2024-25 and had been in the business and is allegedly been in the business from 2017, pre-2017 and post-2017 till 2025. Therefore, the petitioner now shall explain to the respondent with regard to his transacting business or otherwise, and after the emergence of the GST regime, when the VAT certificate of the petitioner was transposed to that of the GST certificate, till the petitioner secured a GST registration in the year 2025. The petitioner shall submit a comprehensive reply or representation to the petition to the which respondent?
3, Your Lordship.
Respondent number 3. Respondent number 3 shall consider the explanation so submitted by the petitioner and if found plausible, pass necessary orders in accordance with law. In the light of the penalty already being in place, I deem it appropriate to arrest the imposition of penalty or any coercive steps to be taken against the petitioner till the authority would pass necessary orders on the representation of the submitter of the petitioner as observed in the course of the order. For the aforesaid reasons, the following order. The petition stands disposed. The petitioner shall now submit his explanation to the explanation against the penalty that is now imposed. The authority shall consider the explanation and pass necessary orders in accordance with law. Till the order is passed, the order of penalty stands arrested.
So this may be applicable with regard to both the applications. Your Lordship.
Again, both the applications.
So petition number 1 also formed a one-person company and tried to apply fresh registration.
All contention, all defense, all contentions and all defense of both the parties shall remain open to be urged and considered by the third respondent. Before the third respondent and considered by the third respondent.
Great job.
16.
It's case of non-service of show cause notice, my lords, and it has been issued on based on the information of income tax returns. So if it's a case of remand under Chinmay mission, my lords, I don't have any
address change.
Address was changed.
No, the show cause notice was never served. That is one. And the second submission is that, Your Lordship, it's even the adjudication order was passed beyond the statutory period of limitation. So considering that a stay has been granted, Your Lordship, and we are awaiting for addition. No, Your Lordship.
It's based on
Because
26 AS only.
notice was not served within 5 years. So it has to be
File
questioned.
your objections if you want. Parent Counsel Akash seeks 3 weeks time to file statement of objections. Objections, if any, in the next 3 weeks. Interim order subsisting would continue to the next date of hearing.
17. Filed statement of objection.
Akpaka, you have filed or
Yes, fine.
already filed? What's the matter?
4 writ petitions, Your Lordship.
4 is there.
17, 18, 19, and serial number 90, Your Lordship.
17, 18, 90, 90.
Serial number 90.
Ah.
The petitioner, Your Lordship, is in the business of undertaking power projects in India, Your Lordship. The
Anagilva? Yes.
The petitioner, Your Lordship, undertakes power projects in the country. Now we pay GST, Your Lordship, based on the consideration which we receive from the customers. Now we had, Your Lordship, a branch in Sri Lanka. Now we had customers in Sri Lanka. So we had undertaken power projects in Sri Lanka, Your Lordship, where the supply of goods and services takes outside the country. Now this power division, Your Lordship, was hived off to Hitachi. Now once it is hived off to Your Lordship, we wanted these existing contracts also to be hived off to Hitachi. But some of the customers in Sri Lanka, Your Lordship, did not agree for a novation of the contracts. So the contracts continued with us. So we continued, Your Lordship, to pay GST, Your Lordship, on several transactions that takes place inside the country. Now, somewhere in 20, Your Lordship, we noticed that in respect of transactions that have taken place outside the country, we have paid the GST, which, Your Lordship, we are not liable to pay the GST. Roughly, the refund works out to, Your Lordship, about 8 crores or so for a period of 4 months. December, January, February, and March 20. So what we did, Your Lordship, we redid the transactions. We issued a credit note to Hitachi so that the transactions are neutralized. They had taken credit of the tax paid by us. That they reversed, Your Lordship, gave us the documents. So we had a chartered accountant who examined the entire transactions, gave a certificate, Your Lordship, that we have not passed on the burden because we have neutralized it. And then, Your Lordship, we filed a refund claim. Now this refund claim, Your Lordship, we sought to be rejected on the ground that we had not issued the credit note within the time limit stipulated in GST. In GST, what happens, Your Lordship, for a credit note for a particular year, say April to March of a particular financial year, we have to issue the credit note by the September or the November of the subsequent year. So he rejects the refund claim on the ground, Your Lordship, that the credit note has not been issued within the time limit. On submission, Your Lordship, the entire act will apply only if it is a taxable transaction within the country. In a situation where, your lordship, it happens outside the country, where it is not amenable to tax. Therefore, none of the rigors, your lordship, of this act will apply to us. Therefore, we say, your lordship, that our financial credit notes, the various documents which shows that the transactions have been utilized, have to be taken into account. You cannot press the GST law into service, your lordship, on this issue. That's a limited point, your lordship, before my lords. My lords will kindly have a look at the order in original. Page 87, your lordship. I'm looking at the first
87.
page 87. At page 93, your lordship. Page 93, your lordship. The refund application cannot be considered, my lords have it, your lordship.
Yes, and there.
The refund application cannot be considered for the following reasons. The scrutiny of the refund application, along with the aforementioned documents and submissions, revealed that the taxable person had issued tax invoices during December 19 to March 20 by collecting GST and declared the said turnover and taxes in the corresponding tax periods as required under Section 37 and under Section 39. After furnishing a return under Section 37, 38 and 39, discovers any omission or an incorrect particulars therein, other than as a result of scrutiny, audit, inspection, etc., he shall rectify such omission or incorrect particulars in the return to be furnished for the month or quarter during which such omission or incorrect particulars are noticed, subject to payment of interest, provided that no such rectification shall be allowed after the due date for furnishing of a return for the month of September or second quarter following the end of the financial year. Here it is to be noted that in the instant case, returns for the month of December 19 to March 20 should have been revised in any case on or before the date of filing of the return for September 20, that is 2010-2020, since the annual return was filed on 26/2/2021. Whereas the instant case, credit notes and bills of supply were issued for those invoices on 31/10/2021. The said credit notes are beyond the time prescribed under Section 34 of the GST. Section 34 prescribes the provisions for issue of credit notes, which are reproduced below. My lords will see 34(1), where one or more tax invoices have been issued for supply of any goods or services or both, and the taxable value or tax charged in that tax invoice is found to exceed the taxable value or tax payable in respect of such supply, or where the goods supplied are returned by the recipient, the registered person who has supplied such goods or services or both may issue to the recipient one or more credit notes containing such particulars as may be prescribed. Any registered person who issues a credit note in relation to a supply of goods or service shall declare the details of such credit note in the return for the month during which such credit note has been issued, but not later than September following the end of the financial year in which such supply was made, or the date of furnishing of the relevant annual return, and the tax liability shall be adjusted in such manner as may be prescribed. From the above, it is evident that the credit notes issued to the transactions reported in December 19 to March 20 are much beyond 2010-2020, therefore found to be not valid in terms of the time limitation under Section 34 as narrated above. Our limited submission is only this.
Yes.
All this, your lordship, will apply to taxable transactions under the GST. For a transaction that is not amenable to GST, none of these rigors will apply, your lordship. There are a number of decisions, your lordship, on where tax is paid on mistake of law, etc. Then none of the rigors will. Just point out, your lordship. Because whether I do it, your lordship, within the time limit
No,
or
now
not.
the blame is saddled on you that you did not collect invoices at the appropriate time and give it to them so that they would process. And beyond the time, that's the objection.
Yes, my lord.
Along with the refund application, your lordship, all the documents were submitted. My lordship, just have a
So that
look
is
at
along with the refund application, not at the appropriate time under Section 54. The Section 33
34, your lordship,
requires all documents to be furnished.
50, no, your lordship. 34, your lordship,
34.
requires me to issue a credit note within the time limit. That credit note has not been done,
Yes,
admittedly.
credit note is not issued.
Absolutely.
So when
Under
30
section
the-
54, your lordship, I am supposed to file a refund application
Without 34?
without 34, because your lordship, what will happen, your lordship, 34 or 54, both will not apply to me. Because it's not
No,
a
no,
taxable
that is,
activity.
you are cutting at the root of the matter.
Correct, your lordship.
Because the transactions that have taken place outside
Therefore, it
is
will
not
not
amenable to tax, that is the root of the matter.
Yes, sir.
But whether you have complied with the conditions of such refund under 54
Yes, your lordship.
by submitting those documents under
All the
34.
documents, your lordship, were submitted. All the documents were submitted. My lordship, just have a look at
That is
my.
while claiming refund.
Correct.
Ah,
Before that, your lordship,
one ನಿಮಿಷ ತಾಳಿ, I'll get back.
Sorry.
before that, your lordship, there was no occasion for me to revise the return or issue the credit note. Because we looked at it, your lordship, only much after the time limit was over. Then we realized, your lordship, that it is a transaction that happened outside India. So what we can do,
How is that you realize when the transaction was happening throughout?
Yes, sir.
You said everybody,
Any number of
everything was in
transactions-
Sri Lanka.
yes, sir.
And how did you realize it at a later
Now,
point?
what happened, your lordship, since for the same company, we were undertaking number of transactions both within and outside. In terms of the software, your lordship, these transactions.
That
your
is
lordship,
not in dispute.
That transactions.
No, transaction happening outside the country is
Absolutely
not
not
in
in
dispute. That is not their ground also.
Absolutely.
That's all right. Then let's not delve upon
Yes,
that.
your lordship. Now, only point, your lordship, is when I file a claim, there are two ways I can file a claim. I can file a claim without getting into the rigors of the time limit under the act, which, your lordship, is 2 years. I can file within the reasonable time limit of 3 years, etc.
Yes.
What I have done, your lordship, filed a claim within the time limit of section 54 of 2 years. The transactions, your lordship, happened in December 19. I filed the applications, your lordship, in November 21.
So it is not belated.
It's not belated. Therefore, all that I am required to do.
All the objection of the respondent is that at the appropriate time, 34 is not complied. So 54 will not be given.
Absolutely.
Ashte avada.
That's
That's
all
all
your
the objections. Howdalla?
Yes, ma'am. And even GSTR 1, GSTR 1 and GSTR 3B also, they are not reported, my lord. That is the crucial mandate statutory
These are-
provisions should be
no,
complied.
No, your
They are not complied.
GSTR and 1.
That is admitted.
No, 1 or 3B, your lordship, I have reported it as a taxable transaction.
That's, see,
Yes, sir.
now for claiming refund 1 and 2 is not complied, but taxable transaction that it is mistakenly given to you.
Absolutely.
That is what is being sought to be refunded now.
54.
It is not that they have not done anything. 54, yes, we will have to interpret.
Subject to benefit will be proved only he is eligible. When he has not failed to comply the provisions, then definitely he is not eligible, our contention.
Let us.
You'll also kindly have a look at two documents.
Yes.
Compilation view. You'll also kindly see page 17 of this compilation I have passed on.
Which compilation?
This compilation of,
This one?
yes, documents, the
1-7.
1/7.
Yes, sir.
Section 54, your lordship.
50 refund of tax.
Yes. Now, my lords will kindly see 54. Any person claiming refund of any tax and interest, if any paid on such tax, or any other amount paid by him, he may make an application before the expiry of 2 years.
Yes.
And thereafter, your lordship, I am supposed to demonstrate what all documents are there. All these documents you have given along with the application under 54. 54 doesn't confine only to tax or penalty. Any other amount which is paid by me or lordship is specifically added under section 54 of the GST law. Therefore, your lordship, all these documents were filed
No.
along with the.
Subsection 2 of section 54
Yes, your lordship.
is only with, it should be within 2 years from the last day of the quarter.
Yes, your lordship.
So there is no dispute that you have filed it before 2 years. Now, the only issue is that whether you are entitled to this without the rigor of whatever the government
Yes.
advocate said.
Yes.
That's all.
Our submission.
But it is that an admitted fact that there is tax paid out of mistake?
Those transactions have happened outside India.
No,
your lordship.
that's
It is admitted,
Madam,
my lord.
transaction is admitted.
Yes, ma'am.
Tax payment is admitted. Transaction having outside the country transaction is admitted, payment is admitted.
To cure the mistake, 1 year time is there. They have not done. Beyond time they are coming. Even GSTR 1 and 3B is only for to report mistake. They have not done.
Mistake of taxable transactions, your lordship. 1 or 3B,
No,
etc.
that is why, that's why I told Shivdas sir is at the root of the matter. If transaction itself is not taxable, Holding it would be prima facie unjust,
260
unjust enrichment.
Beyond 265 also here.
Yes.
That will be the problem. There are two decisions I wanted to point out here. Page 42 of the same compilation.
Forty-two.
Yes, sir. NAM Estates Limited.
Hmm.
We'll also see para 3.
Yes, next.
The perusal of the material on record would indicate
That's
was
affirmed by the division bench.
affirmed by the division.
Yes.
And division bench, your lordship, is slightly.
Division bench is more elaborate here. Yes.
That's all what. Page para
For that, there
para
are.
5.
I'll get back to you, madam. Yes.
Para 5.4, your lordship, page 46, para 5.4. Two other decisions are along with this.
My lord, page number 25 of my
ಈಗ
objection. My
ನಿಮ್ದು
lord.
ಹೇಳಿ. What is that 1 and 3? Tell me.
My lord, I have taken specifically that contention. My lord. The petitioner relies solely on a CA certificate to prove that the tax burden was not passed on. However, no corroborative documentary evidence such as contractual communication, customer confirmation, revised invoices, etc., has not been provided.
ಅದೇ 1 year time ಅಲ್ಲಿ it is
and
not
hence
provided.
Has been provided and hence claim has not been agbeku, adu mistake agide. He has not provided, my lord. My contention is he has not provided. That's why last occasion alli ವಾಪಸ್ ಕಳಿಸಿ ರಿಮಾಂಡ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು. ನಾವು ಒಪ್ಕೊಂಡಿದ್ವಿ. ಇಲ್ಲ ಮೆರಿಟ್ ಮೇಲೆ ಮಾಡ್ತೀವಿ ಅಂತ. If they want to merit, they have not provided.
They have no merit.
Beginning ಅಲ್ಲೂ ತಗೊಂಡಿದ್ದೀನಿ ನಾನು contention.
Well-
They have not provided any invoices.
We'll also see page 155 of the writ petition.
155 of?
Writ petition. 157 in fact. This is my. We'll also see 157.
Yes.
Letter dated 18/11/2021. This is here, your lordship. We explained the entire transaction. Last paragraph. Due to such inadvertent error, the company has collected tax on supplies which are not taxable. Hence, to rectify the same, the company has issued credit notes for transaction value and tax thereon, issued bill of supply afresh. Next page. We are herewith submitting the statement containing the details of the invoices issued during the period so and so, correlated with the vendor invoice details and details of credit notes issued and bill of supply issued as annexuriate to this intimation. So every document, your lordship, has been filed. What all I am supposed to file, your lordship? I am supposed to file my original invoice. That is part of their return. I am supposed to file a credit note.
Correct.
I am supposed
Is
to
that
give a-
done within that 1 year period?
That will be done, your lordship, along with my refund application. Within
Along
1
with,
year, your lordship.
everything along with 54.
Correct. That's all what I am supposed to do, your lordship. For a 34, 39, this will not apply because that will apply only to taxable
Taxable
transactions, not to this. Along with this, your lordship, I am supposed to do with my 54 application.
All are same?
All are same.
We'll dictate it next week. Yes. Heard the learned senior counsel, Shivdas appearing for the petitioner and the learned HCGP. List on 25th, we'll dictate on that.
There's one more request, your lordship.
Number
Serial
ಕೊಟ್ಬಿಡಿ.
Serial number 4 and 5. My lords have kept it on 25th. Can be kept at the same stage, your lordship.
Orders alla, preliminary hearing I have told. Yes.
Great.
Yes, next.
20. My lord, this is the recovery made during search investigation proceedings.
Last time?
Yes,
we've
ma'am.
heard. Yes, Madhu?
My lord, I seek the indulgence of the court on two aspects, my lord. One is RFD 02, that is acknowledgement. Second is refund of the money is recovered during the time of search. If they have any submissions, they can make, or I'll continue, my lord.
Two matters.
Martira?
Now, I would like to place on record the fake invoice, they claimed input. There are no actual supply. There is no actual supply. There is no existence of the registered dealer himself. So we have conducted the search and he was in US. Then he came back and he said, I come on so and so date. Whenever we issue notice, he comes only at 4:30 and he says, beyond 7, don't hold me. And he's not
He's
cooperating.
talking about
And,
20.1, which we can deal later, my lord, because we can address either 20. First we can,
First is 20.
yes, my lord.
20
That
ಇಲ್ಲಿ
is
ಯಾರಿದೆ?
Gunnam. That is 17779 of 2025.
20, I think Madhu is there.
As well as,
Unni Krishnan.
I'm for R4 and R5.
Unni Krishna ಯಾರಿಗೆ?
R6.
Union of India.
ಇಲ್ಲ ಇಲ್ಲ. R6. R6. Lords, Union of India.
R6 is central tax, all right, yes.
Lords, they have sought for refund of this money, my lords. Kindly the prayer. We had given deficiency memo, which is at A to A3. My lords may peruse it.
No, these are search and seizure proceedings.
Please. Investigation is going on. Now, during the investigation, they have made some DRC 03 payments, which is in voluntary, in the nature of voluntary nature. Now, which is forthcoming from their annexure.
So that they cannot claim refund ಅಂತ ಹೇಳ್ತಾರೆ ಅದಕ್ಕೆ.
No, one more submission, because they have relied on certain judgments. I would only request this honorable court to kindly see DRC 03 form, which was amended in 2024.
Tax. ಅಲ್ಲ, GST. GST. Forms ಇದೆಯಾ?
I'll provide this.
In the schedule at the end, my lord.
ಇದರಲ್ಲಿ
That will not happen.
24. ಅದು ಮಧುದೆ ಕೊಡಿ.
25. Which, well, specifically considering all these things, in my research, my lord, GST Council had amended para number 5 to say that payment during investigation is also covered. Now they are telling these payments, whatever is made, is under coercion. Now, my lords, they have made payments. If my lords may kindly see para annexure D, my lords, page number 56 to 58, 60. My lords, on different occasions. One is 8/6/2023. Next is payment is made on 5/7/2023. Next is made on 23/1/2024. Next is made on 29/5/2024. In the petition, they have alleged that there is coercion, that we coerce them to pay. We have not let them show any document where we have coerced them to pay. In other way around, I am submitting in terms of DRC 03. They have not told anything in DRC 03 that there was any coercion from our end.
ಅಲ್ಲ, coercion ಡಾಕ್ಯುಮೆಂಟ್ ಇದಲ್ಲ.
ಅಲ್ಲ,
My lord, last occasion
ಹೇಳ್ಬೋದು, because whenever they make payments,
So that is not their case in the reply.
It's not there. They are only telling it is only coercion. My lords, my submission is what they do is, my lords, in order to get away from arrest, they make the payments.
Last time ಹೇಳಿದ್ರಿ, you told me.
Yeah, therefore, my lords, they want to get away from this. Therefore, in 2024, a notification was given in terms of the GST Council, where they have amended it to say that even during investigation or scrutiny, payments can be made. In terms of that, the payment has been made. Now, my lords, that is not considered perhaps in the judgments what has been relayed by my friend. What I want to tell.
My lord, the submission that Learned Council made is a ground reality. What they do, they come during the search to my premises and they say, if you don't pay, I'll arrest you. As a taxpayer, I have no option. He's actually stating the ground reality and making my case. That is what happens in the premises when they come to search.
Ground reality he told, but why of it?
My lord, in the DRC 03, in last occasion, I exhibited that I have clearly mentioned payment is being made during investigation and pursuant to investigation of DGGI. That is sufficient enough. Secondly, my lord, in the compilation that I have filed, Delhi High Court Division Bench has held that court need not even go into details of, I'll just.
Yes, madam.
That was before the judgment, the amendment, my lords.
Which
Amendment has no bearing on this, but I will establish that, my lord. Page number 8, my lord. Page number 8. The last paragraph, 29, which has been reproduced. It is not necessary to examine in detail any controversy whether such payments were made voluntarily. Clearly, where a taxpayer turns around and states the payments had been made involuntarily and the circumstances prima facie indicate so, the taxpayer must be granted the benefit of withdrawing such payments. It says I don't even have to establish anything. One, that, my lord, this search happened in the year 2023. Now we are in 2025 of September. No show cause notice has been issued. There is no proceedings that have happened. This amount, they cannot appropriate against anything. There is no tax demand as on date. This is nothing but illegal recovery, my lord. This is in 20. 21 I
What
have.
date of the search and seizure?
My lord,
8/6/2020.
8/6/2023.
ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಇಲ್ಲಿವರೆಗೆ?
5 years time ಇದೆ ನಮ್ಗೆ.
ಓ ಅಲ್ಲಿವರೆಗೂ
Because
They
74
will
invoke
withhold my money till then.
That is,
3.12 crores, my
But
lord.
what have you done? 2 years ಆಯ್ತು.
my lords, once we do the investigation, my lords, ma'am, submit under section 74, we can
So
invoke.
investigation is not commenced at all still.
It is commenced.
But
They
no
keep
summons,
issuing
nothing.
summons, I keep appearing.
My lords,
ಅಷ್ಟೇ.
issuing
Oh,
of
you have summons issue ಮಾಡಿದ.
ಮಾಡಿದ್ದಾರೆ, I am
summons
appearing.
under 70, we have taken statements, we have done further investigation, it is all fake invoice matters. So therefore, my lords, that is all on that done. My only submission is, my lords, in this case, it cannot be a payment, once payment I can understand. Suppose say for example night payment ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಅವರು ಹೋಗ್ಬಿಟ್ಟು 4 ಸರಿ ಆಫೀಸ್ ಇಂದ ಅವರೇ ಪೇಮೆಂಟ್ ಮಾಡ್ತಾರೆ. Nowhere they have told that because of the coercion we have paid ಅಂದ್ಬಿಟ್ಟು ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ ಅವರು. And I have taken, payments have been made in terms of DRC 03, in terms of the notification. Let them challenge the notification, I have no issues. But
I don't want to,
grounds
I am
taken-
happy with the notification. Why can I
then my lords,
challenge?
they
It
have to
favors
be with
me.
then my lords, they have to be with the notification. If they're saying, my lords, my humble submission, investigation period ಅಲ್ಲಿ pay ಮಾಡಿದೀವಿ, ಮಾಡಬಾರ್ದಾಗಿತ್ತು, ಶೋಕಾಸ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ, there is a notification to that effect which says that during investigation money has to
You
be
can pay.
Yes, my lords. And my lords, one more thing, my lords. The
Voluntary or involuntary we should be.
My lords, that is
That's difficult to
No, my lords.
establish.
Yes,
my lords, section 9, my lords, page number 40 of their own petition, my lords. In this judgment, my lords, an application.
So these judgments were post the completion of investigation or during investigation?
During.
The
There are some
division
during.
bench judgment,
Yes, my lord.
which
In
is
fact, our
2025.
very own High Court,
Ah.
case circular came during. There also the question of law that has been adjudicated on, my lord. If I can take my law to the particular
Facts may be
page.
shown.
That's where page
Page number
29,
7.
para 29 is what you read from that
That is,
judgment.
no, my lord. Page 7,
That is Delhi judgment.
Delhi na.
Delhi. Page 7,
Oh, ಇದು.
para
This is
27.
ಕಾಮೇಶ್ವರ ಅಂದ ತಕ್ಷಣ ಇಲ್ಲಿಗೆ ಅನ್ಕೊಂಡ್ಬಿಟ್ರೆ.
Yes, my lord. In fact, here,
Yes.
they, para 27, my lord, analysis,
Of
page 7.
of Kesar color.
Yes, my lord. Page 7. Having heard the learned counsel for the party in Peru's records, the learned single judge has allowed the writ petition finding the deposit of so-and-so on so-and-so cannot be treated as self-ascertainment as the element of voluntariness is absent. According to the learned single judge, the sine qua non of self-ascertainment is not fulfilled, and as such payment is under coercion, the same is liable to be refunded back to the respondent. Now, my lord, the division bench. The issue is whether such conclusion of learned single judge
Justified.
is justified, and it is held in favor of the taxpayer. After the in-depth analyze the entire
So here
sequence
also
and
payments
situation.
were made
Yes, my
at
lord.
staggered intervals
Yes, my lord.
and voluntarily.
Is what they claim.
No, no.
Involuntary is what I
In
say.
this case. in this
Yes,
case.
yes, my lord. Involuntary payments is what. They say that is self-ascertainment. They are
ಈಗ
making
ಎಷ್ಟು
the
ಪೇ ಮಾಡಿದ್ದೀರಾ?
3.12 crores, my lord, and they have held on to it. But I am participating in the proceedings. It is not that I have not appeared. I am participating. I need the refund.
Now,
One
once
that is
you
that.
once you seize an amount at the time of search, what do you do with that?
When the showcase notice is given, we'll appropriate it.
You'll appropriate.
We'll seek for appropriation.
How do you release it then?
Then they have to get an order. If in the order in original, if something is given, then
All
we can
right.
get.
Till appropriation, what is the status of the amount?
It'll be.
We have not
it'll be in the
passed any order of
consolidated fund
appropriation now. Order of appropriation is not yet passed in this case.
ಇಲ್ಲ
Showcase notice
ಇಲ್ಲ
has to be issued.
ಇಲ್ಲ ಇಲ್ಲ
So ಆ stage ಹೋಗೇ ಇಲ್ಲ.
ಇಲ್ಲ
So
investigation ನಡೀತಿದೆ.
investigation ಇದೆ. Iನ್ನ 3 years ಇಂದ you're holding on to this amount.
ಅಲ್ಲ ಯಾವಾಗ refund 10 ವರ್ಷ ಆದ್ಮೇಲೆ ಕೇಳಿದ್ರು refund with interest ಬಂದೇ ಬರುತ್ತೆ ಅವ್ರಿಗೆ.
ಆಗಲ್ಲ ಹಂಗೆ because there's limitation of 2 years which
What
section
bank account.
54 says I have to make an application within 2 years
of
from the relevant date. Relevant date is
11
the date
date
of
is search
payment.
date.
Payment, date of
Date
payment.
of payment.
I'm not, my submission, my lords, on that point is not. My friend read out page number 8. My lords may read page number 2. The details of the things have been given, which is.
Correct.
there.
Dates
No, my lords.
well. Dates
No, my
and
lords,
events are here.
In their petition, my lords, page number 40. Page number 40. There is one judgment where they have told an application can be rejected as deficient only when there are deficiencies are noted. Now we have noted deficiencies.
and we have issued a RFD 03. Now they have to come against the deficiencies. Now they are telling you, give me an acknowledgement of RFD 02. Now the moment I give an acknowledgement, I have to give them.
This is very.
I am only seeking,
This
I am
is-
only telling them, there are deficiencies which you need to comply with. Therefore you come.
So you tell
My
me
lord,
one thing,
if I may, what is-
one minute,
Yes, sir.
you tell me one thing. Now you don't give an acknowledgement of seizing. You don't give an acknowledgement of anything.
No, not seizure, my lords. It is a payment made under
Payment made.
voluntary payment.
ಅಲ್ಲ voluntary payment ಮಾಡಿದ acknowledgement ನೀವು ಕೊಡಲ್ಲ.
Automatic ಆಗಿ ಅದು ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ಅವರೇ ಮಾಡಿರೋದು.
That is auto-generated.
Lords,
What he showed DRC 03, my lord, is auto-generated.
No, my lords,
Now
if
what
I-
learned
if I-
counsel
if
is
I-
presenting,
if I
my
assess the
lord.
court, if
No,
I
one
don't-
ನಿಮಿಷ, I'll just
ಅಲ್ಲ,
finish
ನಾನು
my
ಹೇಳ್ಬಿಟ್ಟು
submission.
ಹೇಳಾಯ್ತು ನೀವು.
ಆಯ್ತು,
DRC 03 ನಲ್ಲಿ, my lords, page number 58, my lords. Intimation of payment of voluntary made ಅಂತೆಲ್ಲ ಇದೆ. This is the payment which they have made in the system whenever they are in capacity to make the payment.
Or whenever you call them for investigation.
Let them show the records, my lords. Let
They
them
will,
No, we
who
have-
will come and give it to you just like that?
ಅಲ್ಲ,
ನೀವು
there has to be
investigation
some
ಕರೆದಾಗ,
arbitrary value.
so every time investigation ಕರೆದಾಗ ಅರೆಸ್ಟ್ ಮಾಡ್ತೇವೆ ಅಂತ ಮಾಡ್ತೀವಿ.
ಇಲ್ಲ ಆತರ
My lord, ಇವಾಗ
ಅದಕ್ಕಾದ್ರೂ ಅವರು coercive steps ಏನ್ ಮಾಡಿದೀವಿ ಅಂತ ಅವರು at least ಒಂದು affidavit ಹಾಕಿ ತೋರಿಸ್ಲಿ. My only
See,
submission is, my lords, they pay all these things in order to get away from arrest. And now, my lords, I'll be at a situation where ದುಡ್ಡು ಹೊರಟೋಗುತ್ತೆ. Now attachment is also a problem for me. After 1 year, it is not there for me.
Statutory limit ಆಗೋಗಿದೆ.
Therefore, my lords, what happens is, my lords, if after 5 years I have to issue a show cause notice, then I can only seek for appropriation of that amount. So my point is, my lords, if we have sought for RFD 03, let them come settle the deficiencies, sir. That is what this
That's
court has.
subject matter of investigation. Where is settlement deficiencies now?
No. ಅವರು refund application.
Deficiencies in the payment.
ಅಲ್ಲಲ್ಲ, refund application ಮಾಡಿದಾಗ RFD 03 ಅಂತ ಒಂದು memo of deficiency ಅಂತ ಕೇಳ್ತೀವಿ. ಅದನ್ನ ಕೊಡ್ಬೇಕು ಅವ್ರು ಅದನ್ನ.
ಈಗ ಕೊಟ್ಟಿದ್ದೀರಾ ಅದು?
ಕೊಟ್ಟಿದೀವಿ. ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು ಅದನ್ನ ಅವರು ಡಿಫಿಷಿಯನ್ಸಿ ಇದೆ ಅಂತ ಅವ್ರು ಫುಲ್ಫಿಲ್ ಮಾಡ್ಬೇಕು. That is what the judgment what they have quoted in page number 40.
Yes, Losna madam.
My lord, ಅವ್ರು ಹೇಳೋದು that they have no other way to recover money from me is untrue at all, because there's no adjudication that happened till date. Once adjudication happens, they have ample provisions under law to recover money, starting from attaching of my bank account to whatever they wish to. In fact, provisional attachment is also there. Now, second, my lord, RFD 02, that is deficiency memo or acknowledgement. This is what my learned friend is saying. Once I file a writ petition before this honorable court, a WP number is generated and the matter comes up for hearing before my lord. Can I demand for a favorable order, my lord? Just because you've acknowledged that case has been filed. That is what he's saying. RFD 02 by the name itself says it's an acknowledgement. After acknowledgement is adjudication. Once adjudication, they can reject my application. I have appeal remedy. At this stage, one, I don't have appeal remedy. Second, they don't even allow me the benefit of limitation. They keep issuing this deficiency memo. This happened twice. How can I demand a favorable order just for acknowledging my application, my lord? Secondly, my lord, all of the provisions that he's speaking about applies when it is a legitimate recovery. This is an illegitimate recovery. I don't have to comply with. Despite that, I have filed an application. So only two aspects, my lord. Acknowledgement. Second is on refund. This is in 20, my lord. 20.1 is even more interesting, my lord. There.
That is because
They-
second was issue.
I'll
There-
make submission. Whatever my learned friend is, tip of the iceberg. It is not the correct statement. The procedure established in law itself, we have followed. There is no such coercion. All the other judgment, what they have referred, previously in one point of time, that mood was such, whenever you go for search, a payment is made. That's why they started from Gujarat High Court and they traveled to Karnataka and also Delhi. That is not the only issue. Now issues have been changed. All fake invoices. Supreme Court has held that cannot be practiced. There is no supply.
So-
There is no amount paid to the government, but claiming the amount as if I have paid, it is a fraud. They are establishing from whom they are.
The amount is paid here.
Where is the money going then? If they don't have, I don't have, where is?
Input
Now,
tax.
amount, input tax alive. Amount is paid now.
No. Lordship,
Like
here
those
we conducted the investigation and search because we came to know intelligence
Correct,
gathered.
sir. You have, during the search, you have seized
No,
certain
not
amount
that.
or they have, no, not the amount, they have paid.
No, not that I am just telling. Intelligence gathered by the DGGA shown that they have availed the input tax from a person who has not actually supplied the service or supplied the goods or rendered
All
service.
this matter
as-
of adjudication, my lord.
That is where.
That's investigation.
That is where we have culled out what is the amount. We have shown this is what according to us. Then they know that they are aware of it. That's why they make the payment.
No.
Then they come and turn around and say that.
Payment is.
Now
No.
afterwards they have made some.
Correct. Under what head payment is made?
They
My
can
lord,
make on
that is
74
the
itself.
that is the
Provision
amendment
itself.
in the 2024, my lords.
Now, payment is.
Investigation ಅಂತ ಇರುತ್ತೆ. Investigation or scrutiny ಅದರಲ್ಲಿ payment ಹಾಕ್ಬೇಕು. That is what the amendment is all about, that. my
All
lords.
right. So
Under that they have paid.
under that head, they have made the payment.
Yes.
Is your case?
Yes, my
That is
lords.
the only head I can make. DRC
No, they have to
03, I
make under
cannot
that.
make other, I can't give them hard cash.
They have
The
to
only
make
way any payment can be done is DRC 03. That is, if they have problems with that, then it's with the portal, my lord. There is no other way I can make a payment. Now, even in
Notification-
payment, there are two methods, my lord. One is cash ledger, the other one is credit ledger. Credit ledger is where what I have, I reverse that. ITC. So in 20, both are included. That is cash and credit ledger.
Let's see, we'll consider.
Please and
20.1.
20.1. 20.1, my
ಅದು
lord.
ಸಮನ್ಸ್ಗೂ ಬರ್ತಿಲ್ಲ ಅವ್ರು ಹಾಗೆ. ಅದು
ಇಲ್ಲ, ಇಲ್ಲ,
ಬರೋದು
I will,
ಎಷ್ಟೊತ್ತಿಗೆ? Problem in that.
no, if I can just make some submissions, my lord, then they can.
Wait, sir. ಹೇಳಿ.
There are total 13 summons have been called for. I'm not saying issued, my lord, called for. Out of 13, 6 are unofficial.
Unofficially?
They call me,
What is
they
unofficial
threaten me,
summons?
they ask me if I don't come, same, arrest. I will establish that. One of the summons, my lord, to only establish my point.
Page 67.
81, my lord.
Hmm.
20.1. 81, my lord.
Hmm.
This is the one. There is the Saptashri. Page number 80, my lord. Idrali, summons is issued to me. I have been called to appear. This is the one. Sorry, my lord. 79. I've been called to appear on 12/12/2024 at 4 p.m.
Correct.
Yes, my lord. I am now placing the extract of the summons that is generated on the system. They generate the summons at 5:36 p.m. on the same date. But I am asked to come at 4. This is how they operate, my lord.
So one clerical
In
mistake
this,
might be there.
no,
Typical
it cannot be clerical. My lord, if they have such defense saying clerical mistake in a matter so.
Handwritten alla ಇದು.
I'll clarify.
This is how they call unofficial summons. In this, there are 13. Of that, 6 are unofficial, 7 are official, where summons are generated or issued to me. The rest are all I am coerced to come there, or my staff are harassed if I don't come. They confiscate my mobile phones. They come. In fact, in this case, my lord, the proprietor was not in India. It was a planned outside travel. His entire family. The officers come at 6:30 p.m. and then they force me to come. I cannot come. So they contact my CA. My chartered accountant's father is admitted in hospital. They go to the extent of going to the hospital HCG and verifying whether the father is actually admitted or not. And when the father of my chartered accountant passes away, they go there and check whether he's passed away or not. This is the way they are conducting the proceedings, my lord, which again I am not questioning here. I will take it up at the appropriate time. The recovery is to only show how they are coercing me to make these payments is what I want to establish, my lord.
So I'll place on record. There is a there's a circular what it says. Now, this is an online DIN gets created. Generally, we should issue DIN with regard to whenever summons has been issued. Now, my lord, there is a provision for us to issue summons. If the DIN is not getting generated, we'll put it in our note sheet. So therefore, it has been given. We give it. Therefore, to say that this summons has been given, then it has been generated is not correct. Is incorrect. That is point number 1. Point number 2, my lord, these are all issues of fake invoices. These are all intelligence actions, which are not like, unlike a category where a book audit is done or an audit is done based on an inspection 67(1). These are all not like that. They're all under 67(2) search proceedings which have been taken place. So therefore, my lords, this should be seen separately. And my lords, my only submission is, whenever they have made payments under DRC 03 voluntarily, they have made in terms of the amended notification of 17 of 2024. Therefore, my lords, they cannot come now to say that it has been paid out of coercion and so on to say. Second thing, let them answer to the deficiencies, then it can be good. That is what section rule 90 also says. They have to answer to the deficiencies is what we seek for.
We'll pass out.
My lord, deficiency in this matter, How there is no application of mind at all? They're asking me to provide an order.
Where is it order?
Page number
In 20 or 20.1?
20.1, my lord.
Page?
Page number 58, annexure A.
We are given
First
reasons.
point of deficiency that they have notified to me, relevant, down, my lord, at the bottom, relevant order not attached. What is the order that they want?
Relevant supporting
You should tell
documents.
that.
Allah, my lord, first
Tell
page
that.
number
A
58.
relevant order not
Order,
attached.
in order madeko. This is a non-application of mind of the officers who are passing this deficiency memo. What they're doing, my lord, they're using this deficiency memo at threshold to reject applications, not even let it go to the stage of adjudication. This is how much, and second, my lord, the very next page, page 60, another, second, I file another application, there they note the deficiency. Third one, my lord, no debit made in electronic cash ledger. I have not even whispered about cash ledger in my entire application. It is electronic credit ledger.
That is left to the discretion of the
This is
officer.
how they are verifying the applications, and this is how they are
This cannot be
passing
decided.
orders on
Cannot be
deficiency
decided in
memos.
petition, my lord. That
This
has
is
to be
the
decided
level
by
of
the
application of mind, my lord.
My submission is, my lords, this cannot be decided in a writ petition. This is to be decided. If let him pass an order, then they can challenge it. Now at the threshold, they are telling, my lords, that is why, my lords, in one of the judgments, my lords, Supreme Court has very well held. You please don't come at the threshold to 226, para number 11. If you are questioning all these things, you may come. Otherwise, don't come. Para number 11, three-judge bench of the Supreme Court is very clear. Under what circumstances you are supposed to come before this honorable court under 226. For everything, if they come before 226, my lord, let them answer it. On that, let them.
This was 107.
No.
Yes, my
The
lord.
point is
And
the
I'm-
ratio, my lord.
Ratio,
The ratio, my lord.
four circumstances.
Four
you can
circumstances.
Yes,
settled
ma'am.
ratio.
Yes, my lord.
Therefore, my lord, my submission
But
is,
this
my lord,
was a case concerning
107.
alternative
I agree.
remedy under
I
107.
agree.
Yes, my
Agree.
lord.
My only submission is, my lords, let him pass an order, then they can come. At the threshold, my lords, if they come, my investigation is stalled, money is taken away. I don't have.
Is taken away.
No, my lords, if the money is again getting the refund.
Allah,
my
why
lords,
are they so
then-
scared about monies?
Ma,
They
this
are
is a
the
search
state, the
operation.
mighty state, my lord. They should not be
It is a
so
search
fearful of
operation, my lord.
recovery.
Election ಆಗದ ಹಂಗೇನೆ ನೀವು.
ಕೋಟ್ಯಾಂತರ ರೂಪಾಯಿ ಮೋಸ ಮಾಡಿದ್ದಾರೆ. That is our allegation, my lords. Kindly it may be taken into consideration, my lords, in terms of law.
20.1, place on record some material because they are making
I
so many allegations.
20.1 delink ಮಾಡಿ 20 reserved. Yes.
My lord, what just last submission, ಈ fake invoice what my learned counsel is
ಅದು
telling,
merit
ಅದೆಲ್ಲ
ಮೇಲೆ madam,
ಆಮೇಲೆ my lord, ಈ
investigation ಆಗ್ತಾ
stage
ಇದೆ.
ಏನು ಬರೋದೇ ಇಲ್ಲ.
ಎಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಷನ್
Yes,
ಆಗ್ತಾ ಇದೆ
my lord.
ಅದಕ್ಕೆ ಈಗೇನ್
Yes.
ಸಂಬಂಧ?
One observation we made.
No, that you must know. When you are this side, you will know it. Arguments in terrorism.
That's one observation we made. He's
Thank
not
you, my lord.
cooperating.
If you touch this case, it is going to be like this. Hello, Madhu.
ಅಲ್ಲ, my lords, ಇದ್ರಲ್ಲಿ ಏನಾಗತ್ತೆ ಎಲ್ಲ lords are aware, my
Either
lords.
way, it's all right. Because you are entitled to argue, why?
Alex,
You are
take us
entitled
1
to
year.
argue the way you want.
One more.
First, that notification may be relevant. I may be given a copy.
ಯಾವ್ದ್ರದ್ದು?
That 17, that DRC 03 what lords.
ಹಾಕಿದಿರಲ್ಲ?
ಇಲ್ಲ ಅದ್ರ ಎಲ್ಲೂ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ. ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಕೊಡ್ಬೇಕು ಅಂತ ಯಾಕಂದ್ರೆ ಆ ಜಜ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ, my lords, I'll just
ಯಾವ್ದ್ರಲ್ಲಿದೆ?
ಇದ್ರಲ್ಲಿದೆ, my lords. Para number 5 ಇದ್ರಲ್ಲಿ I was just seeking indulgence of this court. ಅದ್ರಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ಆ 17 of 2024 notification because of the GST Council amendment ಅಲ್ಲಿ ಡಿಸ್ಕಸ್ ಆದಾಗ para 5 against scrutiny or investigation.
This is DRC 03.
03. Right side, left side, my lords.
What is it?
10/7/24.
This side.
ಅದು ರೈಟ್ ಸೈಡ್ ಇದು.
ಆ ಪ್ಯಾರಾ ನಂಬರ್ 5 5 ಅಲ್ಲಿ ಎಡಗಡೆಗೆ ಮೇಲ್ಗಡೆ ಅಲ್ಲಿ they told against
Details of
investigation.
audit, so and so.
Please, my lords. Now their allegation is that during investigation I cannot pay, been coerced anta. They have paid under DRC 03 in terms of this challan. That notification ಅಲ್ಲಿ
book ತರ್ಸಿ ಮೇಡಮ್, ಇದೇ book ಇದೆಯಾ ಸೇಮ್?
because this was not discussed in other judgments, in all the judgments of Gujarat High Court as well as our
This also
discussed in my
mentions
judgment.
investigation.
please, my lords.
Yes. All right.
Serial number 20 state is a formal party.
Formal party. All right. Yes. Next, 21.
Yes, 20.1.
21, 20.1 delink will take it on 25th.
Update.
But serial number 21, it's a batch, my lords, pertaining to 2A, 3B issue, my lords, 16-2 issue. That requires some consideration, my lords. My lords may have it on 18th. We'll file judgments as well in this matter.
We'll take it on 25th.
25th. Please, my lords. Great.
Rest on.
Insofar as it relates to difference between GSTR 2A and 3B, my lords, there are judgments of this honorable court saying that, my lords, it can be, matters were sent back asking the
adjudicating authority to pass fresh orders in view of the circular issued by the GST Council.
That is to be done, we will do it. He wants
Please,
time. What?
we'll have it on 25th, my lords. I'll produce judgments of other high
Call
courts.
it, list on 25th.
My lords, interim orders to be extended. I'm grateful.
Yes.
22.
Please, my lords, I beg to appear online for the petitioner, my lords, incident number 22. My lords, this is a petition that we have filed for seeking waiver, my lords, for pre-deposit against under Customs Act. It touches upon section 129E. My lords, we seek some time to file our additional affidavit in this, my lords.
Objection second. Yeah. This is also relates to a pre-deposit, my lord. That morning your lordships were hearing this.
129E.
120.
Yes.
129E.
Exemption from pre-deposit.
You're seeking exemption. What's the duty imposed?
My lords, the duty imposed is equal to the amount of the confiscated goods, which is 12.5 crore rupees, my lords. And this penalty has been imposed on custom house agent, my lords. And the allegations are under section 112A and 117, my lords. There is really abatement has been alleged against.
No, are you seeking that pre-deposit should be exempted?
Exempted or my lords reduced? Actually, reduction is where I was.
Reduction, I don't understand.
Either it should be, my lord, dispensed with, or my lord.
Under 226, can we do that bargaining process?
My lords,
25%
226,
cut,
there
50%
are
cut.
my lords, that's exactly what I want to canvass. That
Yes.
it can be exempted or reduced to considerable extent.
Exempted or reduced also?
Reduced, my lords, as well.
We'll see. Yes, I'm hearing the other case. I posted it on 18th.
Please.
Yes.
Please, my lords. I'll file my additional affidavit as well.
Please do that. Yes. List on 18th. Next.
Oblige, my lords.
Yes.
Lord, the demand was issued under the service tax, my lord.
My lord, this matter gets covered by Chinmaya Seva Trust.
Correct. That's what.
And there is one more notification, my lord, where it clearly says that I am exempted for paying income tax, service tax.
Alle alla. Chinmaya follow mad will finish it. Yes.
Lordship judgment in writ petition 19409 of
ಇದೆ
2025.
ನಮ್ಮ ಚಿನ್ಮಯ ಎಕ್ಸ್ಪರ್ಟ್ ಇದ್ದಾರೆ.
I pass it on, my lord.
ನೋ
Chinmaya.
ಇಲ್ಲಿದೆ ಇಲ್ಲೇ
And to consider
Chetan.
this notification also, my lord. Page
ಇಲ್ಲಿದೆ
74.
ಚೇತನ್ ಚಿನ್ಮಯ ಹುಡುಕ್ಬೇಡಿ.
Please. Page 74 also, my lord.
To the stage of
Post show cause notice.
post show cause.
Reply to the
Reply
show
to
cause.
the show cause notice.
And the notification also, my lord. 74.
ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಅಲ್ಲ. Yes.
Please, please.
Next. Dispost.
24.
Goldman Sachs.
Your lordship, the short issue in this matter is interest on delayed refund.
Sir.
It's already covered by
Interest on delayed refund.
Lordship,
Yes, sir.
this matter has been renominated to Mr. Unnikrishnan.
ಉನ್ನಿಕೃಷ್ಣನ್ ಇದಾರಾ?
ಅವ್ರಿಗೆ ಬಂದಿದೆ.
ಆಯ್ತು. Registry to delete the name of Arvind Chavan and print the name of Unnikrishnan as M. Unnikrishnan as appearing for respondents 2 and 3. ನಾನೇ ಬರ್ದಿದ್ದೀನಿ ಮುಂದೆ. Interest.
Your lordship, there's absolutely nothing in the matter. It's already covered by the judgment of this honorable court in fidelity.
I have myself written last week, I guess.
LNT fine in
LNT
LNT
and
15714 of
Could you give that? Which is that? Give me.
Your lordship, fidelity is at serial page number 6, your lordship. Para
Yes,
5.
Unnikrishnan ನೋಡ್ಬೇಕಾ?
ನೋಡ್ತೀನಿ ಸ್ವಾಮಿ, ನಾಳೆ ಹಾಕೊಂಡ್ರೆ ಅಲ್ಲಿ.
ನಾಳೆ ಆಗಲ್ಲ. Tomorrow not possible. It's next Thursday.
Next.
We'll close it next Thursday.
Much obliged.
Plus Thursday, the next in preliminary hearing.
Much obliged.
Yes. Next.
25.
I appear for petitioner in this case.
ಆಮೇಲೆ after that.
Objection to IA.
Oh, yes.
IA
objection.
What
IA?
Learned counsel said the objection to the IA he will file in the next date.
Not to the IS.
Lord, they are seeking for remand of the matter, but what we are submitting is that they are also seeking for quashing of the bank attachment. This assessment order has been passed at annexure. Annexure A2, 34, page 34. No doubt it is an ex parte order.
No doubt expert ಇಲ್ವೇ ಇಲ್ಲ. ಅದೇ ಡೌಟ್ ಅಲ್ಲಿ will send it back.
ಅಲ್ಲಲ್ಲ, that is true. But ತುಂಬಾ ಮಸ್ತಿ ಆಗಿದೆ ಇಲ್ಲಿ.
ತುಂಬಾ
ಮಸ್ತಿ ವೆಂಕಟೇಶ್ ಮಸ್ತಿ ಆಗಿದೆ.
ಮಸ್ತಿ ಆಗಿದೆಯಾ?
ಮಸ್ತಿ ಗೌಡ್ರು ಶಂಕರ್ ಅಂತೇಳಿ ಪಾರ್ಟಿ.
ಓ ಇದು ಎಸ್ ಸರ್.
They have got 4 bars. And they have got multiple bank accounts. In all the bank accounts, you will not find any money.
ಬರೀ ಅಕೌಂಟ್ ಮಾತ್ರ.
ಬರೀ ಅಕೌಂಟ್. So the cash will only go to KSBCL and then come back in kind. So we will not get any cash. There is another in the bank attachment, there is an assessment order passed for 17-18 which has not been disputed since last 6 years. There is a demand of some 25 lakh in that also. We have not been able to recover that money also. So
yes, sir.
Let them first pay the 25 lakh and then talk about this assessment year for a subsequent assessment year.
In this assessment order, the issue is unexplained money. We are explaining everything, where is the money, and we have all the ledger.
What's your
accounts.
explanation?
Yeah, we have ledger accounts relating to loan. See, loan with unsecured loan was considered as
Loan.
Yeah, unsecured money.
Don't say yeah. You should not learn using yeah. Yes.
Unsecured loan was considered as the unexplained money, and then the tax has been made on it. So it was around
Unsecured loan is definitely unexplained money.
Yeah, but we have bank statements proving the unsecured how he has taken the loan, and ledger accounts, audited financials, and everything.
In bar and restaurant,
Yeah, it is right. Yeah. Yes, sir. Bar and restaurant. Another thing is license.
Expert iದ್ರೆ will send it back. Or ತುಂಬಾ ಹೇಳ್ದಂಗ್ ಮಸ್ತಿ ಇದ್ರೆ we will.
No, what I am submitting
License
is that.
fees and other things are also questioned. Even we have filed everything like.
First, let him say for the bank attachment. They are asking for quashing of the bank attachment. There is no money in the bank. We have to recover 17-18 demand. Let this matter for 22-23 remanded. I will see that later on.
But
how about 17-18?
Defreezing I will not permit in this.
But
how
Or
about the
detachment.
payment of the tax for 17-18, which is not at all disputed? Let them first come back with that payment, and then we will see about this.
the loan amount, it was around 3 lakhs. Now the loan is converted into
Unexplained money.
Unexplained money,
Correct.
tax and all. Now he has to pay as per the recent order.
Okay, now
He has to pay 7 crores.
17-18 admitted amount. What is it?
17-18.
17-18 assessment year admitted amount.
We are not aware of that.
You're not aware? Become aware and come.
17,
First you
18
pay that, I will answer this.
See this year, the question is relating to this assessment order.
No. You also sought for quashing of the bank attachment. Why don't you answer that for 17-18?
The learned counsel M. Tirumalesh representing the respondent submits that notwithstanding the challenge in the case at hand, the petitioner has admitted certain amount for the assessment year 2017-18 to which tax is determined at rupees 25 lakhs. Around 25 lakhs. And the attachment has sprung not only because of the subject impugned proceedings or even the proceedings of 17-18, which the learned counsel of the respondent submits that the SEC has admitted. In that light, instructions be sought and submissions be made by the petitioner on the next date, 25th. Don't learn, yeah.
Yes.
Yes.
26. Paper. Petitioner in this case kindly have it on 18-9, senior Usharila. 18-9.
Sir, it is an ex parte order, 380 days is delay is there. It may be relegated matter to at the stage of show cause notice with a cost, my lord.
ಅಷ್ಟೇ.
ಇಲ್ಲ ಸ್ವಾಮಿ, next day 18-9 ಸ್ವಾಮಿ, ನಮ್ಮ
Next
senior
date ಆದ್ರೆ ಕಾಸ್ಟ್ ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
ರೀಸನಬಲ್
ಪರವಾಗಿಲ್ವಾ?
ರೀಸನಬಲ್
ರೀಸನಬಲ್ ಆಗಿ ಸರಿ ಆಯ್ತು.
18th.
18th. at the request of the council appearing for the petitioner. We'll send it back next time.
Aye, sir.
Whether senior is there or not there, illa.
Aye, sir.
Yes, Raghavendra.
Lordship, in this matter, the proceedings for the tax period 2020-21 was initiated beyond the statutory period of limitation, Your Lordship. That for 2021, Your Lordship, they are supposed to issue a show cause notice on or before 30th September 2024, Your Lordship. But they have issued it on 14th November 2024. And
Yes, madam.
adjudication also
My
has
lord,
taken place
This-
beyond the.
They are challenging notification only, my lord. I will file a statement of objection.
All right, file.
This issue is
The
I'll take-
petitioner. But this don't take course steps on this till you file your objections.
They have already recovered, Your Lordship.
Already recovered. Angar objection.
This was an expert. So
The learned counsel, learned HCGP seeks 2 weeks time to file statement of objections. List
Matter is-
matter after 2 weeks, objections if.
matter is seized off before the apex court also, Your Lordship.
The list after 4 weeks, yes. Learned counsel, learned HCGP is directed to accept notice for the respondent. 4 weeks time to file statement of objections, list after 4 weeks. Next.
That's for the petitioner.
For respondent number 1, my lords.
This is a matter, my lords, where
Kindly-
the order
Kindly-
was.
Order pass agide by the respondent number 1. My lords had granted interim order, my lords, and it was observed that respondent number 1 can pass the orders, my lords. It has been passed now.
The matter pertaining to that AI. An order.
Oh.
Yes.
Please, my lords.
So we had sought for a special bench.
Correct. It is now transferred.
No, is a transfer agila. They've just
Order
placed
agide.
on record, my lords.
The
which says-
hallucination order.
Yes. My lords, they've just given me the copy now. If my lords.
The pass, my lords.
18th. This court on 19/8/2025 had passed the following order. The order did not, it was observed that the order would not come in the way of the
Class parameters.
president ಅದು
ಹೌದು, ಹೌದು.
come in the way of the president
parameter.
considering the application filed by the petitioner to transfer the proceeding to another bench of the tribunal. ಏನ್ ಮಾಡಿದೀರಾ?
ಈಗ ಆರ್ಡರ್ ಆಗಿದೆ. ಪೇಜ್ 8
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದೀರಾ?
Is that transfer agila?
ಬೇರೆ ಬೆಂಚ್ ಅಂತ ಹೇಳಿ ಇದ್ ಮಾಡಿದಿರಿ. ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಗಿದೆ. ಬೇರೆ ಬೆಂಚ್
ಅಲ್ಲ ಬೇರೆ ಬೆಂಚ್ ಆಗಿದೆ ಅಲ್ವಾ?
ಇಲ್ಲ ಆಗ್ಬೇಕು. There is a order passed, my lords. It has to be placed before a different bench, my lords. It will not survive now, my lords. In view of
ಇವಾಗ
this-
ಬಂತು.
Huh?
I just received it.
Order
my
is
lords.
there, my
No
lords.
problem. We'll take it next week, but it will go.
Yes, yes, it should. Well, that's interestingly, page 5 ಅಲ್ಲಿ. Probably again it's near. Page 5, bottom in middle quadrant, AK,
AK?
the citation which.
ಇದು again AI ಅದು. This is the problem. Cry park na bry park ಮಾಡಿದೆ. Yes.
My lord, citations have affected in a correct way at least.
Huh?
TB Venugopal versus Tumku Milk Producers Cooperative Society is my lord's judgment on the same issue.
Same issue.
On the bias saying.
Bias?
Not.
Lords, ultimately now it is. to the
I
different
just
bench.
place it before.
This was completely hit by apparent bias. Yes. 18th. We'll close it on
Yes,
that.
yes.
List on 18th in plenary hearing. Yes.
Much.
29.
Lordship, questioning Annexure B and Annexure C, Lords. Ex parte order has been passed. It is a GST or mining royalty. 17-18 ಗೆ ಈ ತರ ಆಗಿತ್ತು ಅಂತ ಸ್ಟೇ ತಗೊಂಡಿದ್ವಿ, ಅದು ನಾವು ಹೇಳಿದ್ವಿ. ಅದು they are not taken into consideration and they passed an order and also attached the bank accounts.
The state, that's why you can appear.
And my lord, there are other peripheral issues also which I need to give documentation for that. So it may be
Begin ಮಾಡಿ.
limited to
Ex parte
Showcase-
ಆದ್ರೆ ವಾಪಸ್ ಕಳಿಸ್ಬೋದು.
Showcase notice.
Yes, Hemkumar.
Let them appear on a particular date. ಯಾಕಂದ್ರೆ
That I will say.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಮನೆಗೆ ಹೋಗಿ ಕೊಡೋದೊಂದು ಬಾಕಿ ಇತ್ತು. ಅಷ್ಟು ಮಾಡಿದೀವಿ. For a moment turn to page number 35.
ಇನ್ನು ಎಷ್ಟು ಆಪರ್ಚುನಿಟಿ ಕೊಡ್ಬೇಕು ಬಿಕಾಸ್ ದೇ ಆರ್ ಪೀನಲ್
Showcase notice ಕೊಟ್ಟಿದೀವಿ, ರಿಮೈಂಡರ್ಸ್ ಕೊಟ್ಟಿದೀವಿ, ಟೆಲಿಫೋನಿಕಲಿ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದೀವಿ.
For this case, I thought I should be there.
ರೆಡ್ ಕಾರ್ಪೆಟ್ ಆಗಿ ವೆಲ್ಕಮ್ ಮಾಡಬೇಕಾಗಿತ್ತು ಅಷ್ಟೇ.
He should have been here to argue this matter.
ಇಲ್ಲ actually ಏನಾಗಿತ್ತು ಅಂದ್ರೆ ಮೆಲಾಟ್ಸ್ we had given the ಈ ತರ ಆಗಿದೆ ಸ್ಟೇ ಆಗಿದೆ ಅಂತ ಹೇಳಿದೀವಿ ಅವ್ರಿಗೆ Annexure D.
That is for a
They are not
different
considered
assessment
into-
here, Malaj. That will not have any bearing
We'll
because
send it and direct you to appear on a particular date.
Bank account
Bank account defreeze
Cash
ಮಾಡಿ.
ಆಗ್ಬಿಟ್ಟಿದೆ ಅದು.
Yes, as a consequence of quashment, the petitioner is before this court seeking the following prayer. Heard the learned counsel Madhu N. Rao appearing for the petitioner and the learned AGA representing the state. The petitioner has a certification for GST. It having been issued on 8/7/2018. After about 6 years, a show cause notice comes to be issued to the petitioner, and the petitioner does not appear to answer the show cause notice. Therefore, the impugned order is passed. The petitioner is now, impugned order is passed, and as a consequence thereof, the account of the petitioner is frozen. The petitioner is now before the court contending that it was an ex parte proceeding for the determination of penalty or the freezing of the account as the case would be. The learned counsel for the respondent submits that it is not once but on plethora of occasions notices were issued to the petitioner to appear before the authority, and they have failed to appear, and they appear before this court only when an order is passed and freezing and the account is frozen, but would submit that in the light of the order being ex parte, the court should direct them to, in the event that the court is considering the submission of the counsel for the petitioner, they should be directed to appear on a particular date. The aforenarrated facts are not in dispute. The petitioner, the proceedings are instituted against the petitioner, and pursuant to the show cause notice so issued, several notices are issued directing the petitioner to appear before the authority. This is an admitted fact. The petitioner did not appear before the authority, which led to the respondent passing an order and directing freezement of the account. Therefore, it is an admitted fact that the petitioner did not participate in the proceedings, and an order is now suffering an order. Though indulgence in the cases, though the petitioner has not bothered to appear pursuant to the notices, the fact remains that it is ex parte. In that light, I deem it appropriate to obliterate the impugned orders and direct the petitioner to appear before the authorities on a particular date. For the aforesaid reasons, the following order: so and so allowed, quashed, then petitioner shall appear before the authority on which respondent? First respondent on 24th of September at 2:30 p.m. As a consequence of the quashment of the impugned orders, the freezed account of the petitioner shall be defrozen and be permitted to operate in the normal way. The authority is at liberty to regulate its procedure on the appearance of the petitioner on 24/9/2025, ordered accordingly.
Please, Manoj.
Please, Manoj. Matter came up on Monday this week. This is a matter, my lords, where the appellate authority, I'll just take 2 minutes, my lords.
Yes.
In GST, my lords, in 2017, period is 2017-18. Initially, my lords, we were all getting used to the forms, procedures and all of that. There were a lot of transactions which were double reported. Same transaction reported twice, wrong column reporting, procedural infirmities, my lords. At that point of time, my lords, they did not have an option to edit the GSTR 3B forms and all of that. That came subsequently. Therefore, what happens, my lords, is show cause notice is issued to me. I give them a reconciliation statement. They allowed for a reconciliation statement. I give them a reconciliation statement. He passes an order, does not consider it, passes an order. I file an appeal. I give them some more documentation at the stage of appeal, my lords. The appellate authority says, yes, a verification of the reconciliation statement is required, but I am not able to do it at this stage, and I cannot remand the matter back to the original authority also. To an extent, the appellate authority is right, because 107(11) provides that the appellate authority may not remand the matter back to the original authority.
Yes, to decide
but he can still do the activity himself, verification activity himself. Our suggestion, my lords, is he can go back to the original authority, because what has happened is, my lords, at the time of the show cause notice, he puts out 4 issues to me. He comes out with some more allegations at the time of passing the order. To substantiate those allegations, I file more documents at the stage of appeal. He has not, I don't think, has the occasion to go through all of the documents. So it can go back to the original
Yes,
authority.
In fact, it has to go back before the first appellate authority, because the
Alla,
first
appellate
appellate
authority
authority,
or the original authority?
in fact, first up, they have produced the documents before the appellate authority. The appellate authority makes an observation that the documents have been produced, but he is not in a position to verify the
Because it's a
genuine.
statutory bar.
There is no statutory bar, Manoj. He had to verify it.
No, verification gala to send it back to the.
Send it back ಆಗ್ತಾರಲ್ಲ, let's send it to the original authority.
Heard. The petitioner is before this court seeking the following prayer. The petitioner files his return for the month of, in the month of July for the financial year 2017-18, and later files 2017-18. This becomes the subject matter of the present proceedings. And where notice issued, where is the notice?
Notice is at annexure.
And the respondent issues a notice on 12/5/2022, alleging short declaration of tax liability on inward supplies in the GST returns furnished by the petitioners. The petitioner then is said to have submitted a detailed reply while filing an appeal. The appellate authority though receives all the documents, and all the documents has a statutory bar to remit the matter back to the hands of the original authority to consider the issue. Therefore, the appellate authority passes an order which is impugned in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that once the GST comes about, GST regime springs in on 1/4/2017, correct, Aladu? 1/7/2017, the birth pangs of that legislation were yet to come out, yet to be cleared, or the teething problems that the legislation brought about was still at large. In those circumstances, the petitioner had filled in the forms erroneously and had not declared his tax liability, allegedly not declared his tax liability. That was to be done in a particular form for the assessment year 2017-18. This is noticed by the respondent in the year 2022, and a show cause notice is issued. Proceedings are taken further. All the deficiencies the learned counsel would submit had been placed before the appellate authority. The appellate authority, though was satisfied with the documents that were placed, since they were not placed before the original authority, it had to be rejected. It is therefore the learned counsel submits that the matter should be remitted back to the hands of the original authority, and an opportunity to that effect should be granted to the petitioner to produce all the documents that are placed now before the appellate authority. The learned IGA would submit that the documents, no doubt, there is no bar for the appellate authority to look into the documents that are produced. The bar is only that sending it back to the original authority. The appellate authority has himself looked into it and passed the impugned orders. Therefore, no fault can be found. I have given my anxious concerns. Therefore, narrated facts are not in dispute. The prima facie, the submission of the petitioner would merit acceptance, as the teething problems of GST loomed large at the time when the regime came into force on 1/7/2017, and the filling up of applications under the GST was indeed cumbersome when it springed in. The learned counsel for the petitioner has also rightly contended that there was no option to edit when the GST regime came about, and the petitioner was not able to edit or correct the tax liability that was projected in the form that was initially filled. This is noticed 4 years later in the year 2022 for the assessment year 2017-18, and the proceedings have sprung. The next paragraph. The petitioner appears before the appellate authority, produces all the documents to the satisfaction of the appellate authority. This is an admitted fact. But the original authority had to assess the documents and pass necessary orders. That power the appellate authority does not have, does not have in the light of subsection 11 of section 107, which only permits him to dismiss the appeal or allow the appeal, not remit the matter back to the original authority. In that light, the learned counsel submission of the learned counsel to the petitioner would merit acceptance that the matter should be remitted back to the hands of the original authority to consider all the documents that are now placed before the appellate authority to be placed before the original authority. The original authority shall then assess the claim of the petitioner and pass necessary orders in accordance with law. For the aforesaid reasons, the following order: the petition is allowed in part. So and so stands quashed. The matter is remitted back to the, which is the original authority?
Respondent one.
The
Respondent two.
the matter is remitted back to the hands of the second respondent to consider the documents in justification of the issue and pass necessary orders in accordance with law. It is open to the original authority to take proceedings, regulate its procedure, and take proceedings to its logical conclusion.
Just one submission, my lords. The date of the show cause notice is 13/9/2023, my lords.
Not even two.
22 is the audit proceedings. my
All right,
lords.
yes, 2023. Yes,
2023.
ಅದು correct ಮಾಡ್ತೀನಿ.
Just one
30th of September
2023. Just one maybe clarification, my lords. If we do intend to succeed, my lords, before the original authority, there is a pre-deposit amount that we have paid that may be refunded.
That will be subject to.
Subject to the outcome. Subject to the outcome.
That you
Let them
contend
be
there
directed to appear on a particular day, my lords.
ಇವ್ರಿಗೂ
And let them not taken on
Yes,
the period of
ಹಾಗಾದ್ರೆ ಒಂದು
limitation.
ತಗೊಳ್ಳಿ. The petitioner shall appear before the original authority with all the necessary documents and answer the allegation on 2:30 p.m.
And let them not take up the plea of limitation.
That's okay.
17.
The original authority shall answer the claim of the petitioners on its defense of the petitioner on its merit and not hinge upon limitation to reject the claim. Yes. Madam.
This number 2 for being spoken to, still number 1.
Look, two typographical errors and one, my lord, with regard to the TDS portion only, my lord, that has to be clarified because
Naik sir ಇದೆ.
Correction to the memo. Already started a copy.
Yes, Naik sir.
At the outset, my lord,
Ah.
what has been pointed out in paragraph 3, 4, we have no objection.
ಯಾವ್ದು ಸರ್ ಅದು? 3 and 4 ಅಂದ್ರೆ?
Yes, 3,
Where is the application?
Lord, mine, Lord, the memo for being spoken to, my lord, in that itself.
Where is that?
the year, instead of 2016, I think
May I just
2014,
pass this on
2016.
the, my lord? Signature ಇಲ್ಲ but just.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಇಲ್ಲೆಲ್ಲ ಕಾಣ್ತಾ ಇಲ್ಲ. ಇಲ್ಲರ ಇನ್ನೊಂದಿನ ಬರ್ಬೇಕಿದೆ
Judgment
ಅದಕ್ಕೋಸ್ಕರ.
ಎಲ್ಲಿದೆ ನಮ್ದು?
Para 17 and 18.
1 minute. Senior is submitting. Yes, Naik sir.
Para 17,
Ah,
paragraph 3 is what my learned friend has pointed out.
3
Yes.
will correct it.
Yes, that is to be corrected. That is a typographical error.
All right. 4,
Similarly, 4, my lord.
yes.
And then the unnumbered paragraph also,
Ah.
what has been withdrawn by him
Ah,
is 22.5
5 crores.
or
22.5, 25, my lord.
22.25 is it?
So
ಅಲ್ಲಿ
1.75.
22.5 ಅಂತ ತೋರಿಸ ಇಲ್ಲೂ
25.
Yes, sir.
with regard to first paragraph,
Ah.
second paragraph.
Yes, sir.
TDS, I don't know, my learned friend is referring to some report of the chartered accountant and all that with regard to the rate of tax. That your lordship may not go into that. Whatever is the rate, prevailing rate.
You can't claim refund there.
But it is
Yeah, they
1%.
can.
So what happens here is, my lord, it is 1%. So that 1.75, because 1.75 was kept aside, my lords had asked me to produce this CA's report.
Correct.
I had produced it also, it was on record. Then thereafter, my lord, 1.75 was kept as it is. Totally it comes
1.75 is in deposit here.
deposit
Yes,
here.
yes.
So I'm not
That
able to
remains
take
in
that
the
out.
deposit, my lord, let it remain because your lordship has given me 12 weeks' time.
That is,
12 weeks time.
Yes.
that gets over, my lord, in the
After
month
that,
of
we will see.
All right.
November. So 1.75 ಅಲ್ಲಿ, it's only 1%, my lord, totally.
ಆಯ್ತು
Comes up to
1.75 ಇರ್ಲಿ 12 weeks time ಇದೆ.
Please.
Later we move it if you want.
Just the clarification saying that the TDS is 1% because that 1.75 was kept aside that time because the TDS that time, my lord, was not determined. Now, my lord, it
Now
is
TDS is determined.
1%, my lord.
No.
Let 1.75 be here.
Stay.
Yes, Adirli. 1.75. Let it be in deposit. Let 12 weeks get over.
On 48
Senior
crores,
is
because
right. Yes.
I mean,
Where ally is
The
accepted.
petitioner
clarification
will have to
matra.
examine your lordship's judgment. Whatever is left to him, you'll have to take a call as to what is to be done. Your lordship has given an option.
Yes, sir.
This is there anyway on record, my lord. I just wanted to, it's there on record already, just to reiterate what.
But TDS is in the interest portion. And the interest portion, he's
Correct. Interest portion. Allah, interest portion is what is now.
10%.
Yes.
It's not 1%.
18%.
I thought deposit early, sir.
Early.
Well,
So the
deposit early.
clarification only to say that the TDS applicable is 1%. Let the deposit be as it is, my lord. I'll take it after the 12 weeks.
At that time we will decide what is the
My lord,
TDS.
then again we'll have to come back because that clarification is there that it's
Now
1%.
I won't clarify anything. Once when 12 weeks admele,
Please.
if anything for the withdrawal of the deposit when you move, we will pass orders avaga.
Then I may be
ಇವಾಗ್ಲೇ
permitted to move
ಮಾಡ್ಬೇಕಾ ಸರ್ ಅದೇನಿಲ್ಲ.
then I may be permitted to move then, my lord.
Yes, sir, move it, yes.
Please,
Being spoken
please.
to, I'll clarify those portions.
Please.
The typographical errors I will clarify, except clause 1,
Number 2.
paragraph number 2 will be dependent later.
One point, the learned senior counsel also, so there are 4 flats in the list, my lord. Actually, there are 9 flats.
You
in the
must
list.
don't re-argue the matter.
So it's part of it. They have said no objection to it. That was
No
not pointed
objection ಹೇಳಿದ್ದನ್ನ ಎಲ್ಲ we will do it, don't worry.
out. Please, please, grateful.
Yes.
Seal number 2 order.
Seal number 2 now.
My lord,
Seal number 2 is yours?
yes,
ಯಾವ್ದು, madam?
this does,
Wait. Being spoken. ಹೇಳಿ.
Swami, idralli, this doesn't warrant to get into the merits of the case.
ಅವರೆಲ್ಲಿ
Your
2:30 ಬನ್ನಿ, sharp 2:30 I'll take this. Yes.
Seal number 3.
Respond number 15, my lord. This is with regard to the YouTube channels, my lord. On last occasion, I submitted that I am not party to any of these suits.
ಪಾರ್ಟಿ ಅಲ್ವಾ ಇವರು?
My learned friend,
ಪಾರ್ಟಿ ಅಲ್ಲ ಅಂದ್ರೆ ಬೆನಿಫಿಟ್
I
ಆಫ್
am not a party in any of these suits. My learned friend confused and
Anyway, the entire thing is now diluted.
I am not a party in any of these suits.
Even other.
ಅಲ್ಲ ಪಾರ್ಟಿ ಅಲ್ಲ.
And otherwise, how?
That's not correct. Wait.
Please.
ಅಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡಬೇಡಿ.
Please.
ಅಲ್ಲಿ ಮಾಡಂಗಿದ್ರೆ ಆಚೆ ಕಡೆ ಹೋಗಿ.
No.
Yes.
ಅಲ್ಲ ಆಚೆ ಕಡೆಗೂ ಆಗಲ್ಲ ನಮಗೆ.
My lords, I appear for respond number 7 and 8 in writ petition 35158.
Wait, ಅದಕ್ಕೆಲ್ಲ he is not a party to any of the proceedings, so it would not bind him, that's all.
It appears, my lords, counsel Shri Rajshekar, my lords, appears to have made that submission that he is a party in one
No,
of
he is
the.
not on verification.
Of the suit.
ಅವತ್ತೇ ಬಂದ್ರೆ ಇವ್ರು ಮೂವ್ ಮಾಡಿ.
That is 225 matter, my lord. What he is submitting is
225 matter.
that is the OS filed, original suit filed in 2025. But my suits, 4 suits were filed in 2024 earlier.
All right, if you are not a party, that interim order will not bind you. That's all I will observe.
But my YouTube has been blocked, my lord.
Will unblock it.
It has to be unblocked.
Yes.
It has to be unblocked.
Yes.
Only one observation, my lords, that let them not, my lords, derogatory postings, my lords.
That is always there. Affidavit ಹಾಕಿದ್ವಲ್ಲ ಅವ್ರಿಗೆ.
ಅಲ್ಲ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ ಬಟ್
ಅಲ್ಲ ನಿಮ್ಮ affidavit ಇಲ್ಲೂ affidavit ಬೇಕಾಗಿಲ್ಲ. He is not a party.
I am
sir.
not a party.
If he is not a party, how can I bind him? All that.
why, my lords, we made him a party.
Where is it?
No, my lord.
Why he made him a party ಅಂತ
ಅಲ್ಲ
ಎಲ್ಲಿದೆ?
in the present proceeding.
ಇಲ್ಲಿ ಯಾಕೆ ಮಾಡಿದ್ರಿ? ಅಲ್ಲಿ ಪಾರ್ಟಿ ಇಲ್ಲ.
It is only, my lords.
This is not original proceedings
This is
for
not
him to be
original.
drawn in
Yes,
here.
yes.
Heard the
My-
learned counsel.
My
Learned
lords,
counsel. Yes, madam.
my lords, I
May I
appear
make
for
one request? May I make one
ರಾಜಶೇಖರ್ ಇವ್ರ
request?
ಪಾರ್ಟಿ ಇದಾರ ಇಲ್ಲಪ್ಪ?
My lords, in one suit, he is a party, my lords. 5185 of 2025, my lords, is a
The
party.
petition is filed against what suit?
My lords, my lords, in that petition, my lords, where my learned friend Subramanya filed, my
You
lords.
always beg
there
the
my-
question, why ಇದ್ರಲ್ಲಿ ಇದಾರಾ ಇಲ್ವಾ ಅಷ್ಟೇ?
ಇದ್ರಲ್ಲಿ ಇಲ್ಲ.
ಅಷ್ಟೇ ಬಿಡಿ. Yes. Other suit ಗೆ other orders ತಗೊಳ್ಳಿ.
Yes,
My
I
lords,
have one more submission, my lords.
My lords, one, if I may, I appear for respond number
One
7.
second, one second. Madam, one second. May I make
My-
one more request?
Please.
My lords, for having, my lords, issued legal notice, my lords, calling upon him to, my lords, adhere to the court order. Lords, he has gone to bar council and filed a complaint against me, my lords. This is the conduct of this particular
ನೀವಾ?
No,
You,
my lord.
they
That is
respondent.
different matter, sir. That is different
ಯಾಕೆ?
matter. He was forced to, though he was not a
Why do you go on councils? They are defending their parties, whatever. Why do you go on councils?
No, my lord.
What is this new trend?
That he approached, I am told that
Any
he has-
party appearing for any party, it becomes a problem?
he approached the bar council because see, during night time he was disturbing this learned
Night
council.
time,
During night time, my lord.
I have sent a legal
At
notice.
12 o'clock in the midnight, my lord.
ನೀವು
by email.
12 o'clock ಎಲ್ಲ ಫೋನ್ ಮಾಡ್ತಾ ಇದ್ರಿ.
Phone ಮಾಡೋದು, harassment ಮಾಡೋದು.
12 o'clock harassment
Phone ನಾಗ harassment ಮಾಡೋದು.
ಏನ್ ರಾಜಶೇಖರ್?
Why you are not
ನಾನು-
deleted? Why you are
ನಾನು-
making
ನಾನು-
allegations?
I'm sorry.
ಏನ್ 24/7 advocate ನೀವು?
And up to 2 o'clock, my lords.
Yes.
That is different matter.
My lord, this is-
that covers midnight also. 24/7. ಅದಕ್ಕೆ ಕೇಳಿ.
That is different matter. That suit is different.
My lords, if I may,
What's your problem, madam?
my lords, my IA to vacate 3 of 2025 in writ petition 35158 is listed, my lords.
351.
Please, my lords. I appear for respond number 7 and 8 Meta Platforms Inc.
ಈಗ ಆರ್ಡರ್ ಮಾಡ್ಲಾ? Or is not a party, I will pass the order. Vacating, we will see later.
Please, my lords.
ನಿಮ್ IA ಯಾವ್ದು?
But with the writer that, my lords, he should abide by the, my lords, directions issued in the at least connected.
Sir, if he is not a party, he will not abide by any direction. What is all this? Yes. Which is your application?
I filed objections to the main petition itself.
ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ sir. I filed
Affidavit ಏನಿಲ್ಲಲ್ಲ? R16 ಯಾರು? That ಅಕ್ಷತಾ ಅದು.
I filed it on 21st April 2025, ma'am.
The respondent 7 and 8 ಯಾರು?
Respond number 15, my lord.
7 and 8. my lord.
I am
7 and
concerned with
ನಿಮ್ದು
only
madam.
respond number 15.
ಆಯ್ತು, 2:30 ಆರ್ಡರ್ ಮಾಡೋಣ.
But my presence may be dispensed at 2:30 minutes.
ಈಗೇನ್ ಪ್ರೆಸೆಂಟ್ ಆಗಿದ್ದೀರಾ? ಡಿಸ್ಪೆನ್ಸೇಷನ್ಗೆ?
At least virtually also. my lords.
ಏನ್ ಇಲ್ಲಿ ನಿಂತು ಪ್ರೆಸೆನ್ಸ್ ಮೇ ಬಿ ಡಿಸ್ಪೆನ್ಸ್ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
I'm sorry, my lords, I will never miss, my lords.
ಪರವಾಗಿಲ್ಲ. ಇದು ದಿಸ್ ಹಸ್ ಬಿಕಮ್ ಅ ನ್ಯೂ ಟ್ರೆಂಡ್. VC ಅಪಿಯರ್ ಆಗ ಐ ಆಮ್ ಎ ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ಅಂತ.
ಇಲ್ಲ, ನಾನು ಪ್ರಾಕ್ಸಿ ಅಲ್ಲ.
ಅಲ್ಲ ನಿಮ್ಗೆಲ್ಲ ಹೇಳಿದ್ದು ಇದೆಲ್ಲ ಆಗ್ಬಿಟ್ಟಿದೆ ಈಗ. ಮೈ ಪ್ರೆಸೆನ್ಸ್ ಮೇ ಬಿ ಡಿಸ್ಪೆನ್ಸ್ ಅಂತ ಇರೋದು VC. Yes, sir.
Number 4.
Yes, please.
Withdrawal in terms of
5.
Respond number 1 to 8 have to be directed to unblock.
ಇದು ನಿಮ್ದೇನಾ?
No, my lord.
ಅದು 2:30 ಬನ್ನಿ ಸರ್.
Earlier.
Yes.
I am not party.
2:30 ಬನ್ನಿ.
5 interim order.
List after 2 weeks IO. ಇದೇನೋ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು ಮೇಡಮ್.
5 order.
PD ಸುರ ನೆನ್ನೆಯಿಂದ ಇವತ್ತಿಗೆ ಹಾಕಿರೋದು. ಗೊತ್ತಿಲ್ಲ, ಹೇಳ್ದೆ ಟೈಮ್ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
Bill number 6.
This is a suit filed before the commercial court by a tenant against a landlord, not to be
Seal number
dispossessed
6,
except
yes.
by due process of law.
ಹಾ.
ಏಪ್ರಿಲ್ ಇಂದ ಬಾಡಿಗೆನೆ ಕೊಟ್ಟಿಲ್ಲ, 53 ಲಕ್ಷ ಇದೆ ಬಾಡಿಗೆ.
ಎಂಟ್ರಿ ಮಾಡ್ರಿದೆ.
ಅದೇ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್
ಸ್ಟೇಟಸ್ ಕೋ.
ಸ್ಟೇಟಸ್ ಕೋ ಇದೆ, ಬಾಡಿಗೆ ಕೊಡಲ್ಲ ಅಂದ್ರೆ ಹೇಗೆ?
2:30 ಸ್ಟೇಟಸ್ ಕೋ ಅಂದ್ರೆ ಯಥಾಸ್ಥಿತಿ.
ಅದೇ ಅದಕ್ಕೆ
ಪ್ರಯರ್ ಟು ದಿ ಆರ್ಡರ್ ಬಾಡಿಗೆ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ಕೊಡಲ್ಲ ಅದು.
ಕೇಳಿದ್ರೆ ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ಇದೆ, ನೀವು ನಮ್ಮನ್ನ ಮುಟ್ಟ ಹಾಗೆ ಇಲ್ಲ ಅಂತಾರೆ.
Correct. 2:30 I'll take all this. Yes. 7.
Recommendation of Justice Keshana and Committee.
Adharda, I
Proceedings.
heard on the last
Yes,
occasion.
my
Yes, sir. Yes,
Order
Vachan.
dated 1/9 may be kindly produced.
2:30 ತಗೊಳ್ಳೋಣ?
The file-
127. We
Very good.
continue 2:30. No time. Last time I ಹೇಳಿದ್ದೀನಿ no time.
ಇಲ್ಲ, we don't want time, my lord. The file is,
You want pass over?
no, the file is with the Deputy Commissioner Land Acquisition.
Why?
She has to now place it before the board, my lord.
No, this is a specific order. ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ. What file?
There are several officers who have to sign a report and place it before the board. That report, my lord, is now with the Deputy Commissioner, is what I'm instructed to
Since
say.
when is it before the Deputy Commissioner?
2 days, my lord.
2 days?
Few days.
Few days. What is the order here?
We were required
The
to,
operative portion, may be- last
For
portion of the
which
order.
time
may
is
be
granted
kindly produced.
resolution.
I've written a letter, my lord. I've appraised
4
the,
ಆಯ್ತು, 6 ಆಯ್ತು.
I've appraised the authority.
Don't worry. I will observe what is to be observed and close it. This ಜಾಸ್ತಿ ಆಯ್ತು.
The,
Court order again, Deputy Commissioner, what is that? Who is the Deputy Commissioner?
by name, my lord, Srimati Suma.
Well, ಕೊಡಿಯಲ್ಲ. 2:30.
Hello. Please, my lord.
Serial number 65.
B group, if somebody wants time, please take. Court
4 or
observer.
5 matters, 26 says,
ಯಾವ್ದು
26
ಯಾವ್ದು?
says. Income tax return based, lordship's order is there, 4 or 5 matters are there.
ಆಯ್ತು, ಅದು ಮಧ್ಯಾಹ್ನ ಹೇಳಿ.
Lordship, serial number 65, it was argued on the other occasion, the rejection of the Vivad Viswa scheme.
Ah,
Lordship
yes,
had
correct.
asked. That may be taken up at 2:30.
I'll take.
Your lordships,
My lords, I
serial
had
number
moved-
86, your lordships, some more matters are to be tagged, your lordships, I'll give the.
Can you mention that at 2:30?
Yes, sir.
My lords, I had moved a matter for 2:30, my lords. Memo has not gone because I had not written the FR number.
FR number ಬರ್ದಿಲ್ಲ.
Please.
What memo?
Appraised.
Just like this.
Delivery warrant has been issued, my lords.
ಅದಕ್ಕೆ ಈ ತರ ಕೊಡೋದಾ?
Lordship 96 serial number, stay is not been granted, your lordship is requested for.
Wait, we'll take it. ಈಗ ಲಂಚ್ ಅವರ್ಲಿ ತಗೊಳಕ್ಕಾಗತ್ತಲ್ಲ?
My lords, my memo.
ತಗೊಳ್ಳಿ.
But to continue ಆಗತ್ತಲ್ಲ 2:30.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಲ್ಲ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಎಲ್ಲ afternoon, sir.
Madam, 33 B group, time next.
ಕೋರ್ಟ್ ಆಫೀಸರ್
Second,
Court officer? Sir, court officer?
Sir, court officer? Court officer? Court officer? Court officer?
ಸರ್ ಒಂದೇ ಒಂದ್ ನಿಮಿಷ ಇರಿ ಸರ್.
Madam, madam, list number 2, serial number 2 ಏನಿತ್ತು madam? Madam?
ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
Okay. Court is muted, my lord.
Today's list or to be listed? Kodi. Yes, Arvind?
Please.
Chinmay,
Chinmay sir.
serial numbers ಬರ್ಕೊಂಡಿದ್ದೀರಾ ಮೇಡಮ್?
ಇದೆಲ್ಲ
BKP ಮೇಡಮ್ ಅಲ್ಲಿ ನಂಬರ್ಸ್ ಇದು ಮೇಡಮ್ ಎಸ್ ಕವರ್ಡ್ ನಮ್ಮದೇ ಐತೆ. ಎಸ್ ಚಿನ್ಮಯ 84.
Please, madam. Same matter.
Huh? Interim order you want? Wait, yes. We'll see. Let me finish that second list. Yes. Tax list little later I'll take. I'll finish the second list and come back to tax list.
List number 2, passed over seal number 2.
For the petition, seal number 2.1, my lord.
2.1 ಗೂ ನಿಮ್ಗೆ ಇದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ?
My lord.
2 ಅವ್ರು ಎಲ್ಲಿದ್ದಾರೆ? ಅವ್ರು ಬರೋದೇ ಇಲ್ಲ ಕೊಡಿ.
Milords, I'm appearing for Shivraj's Baloli.
Yes, sir, start.
Milords, kindly pass on, Milords, since senior is held up in
ಯಾವುದು sir?
court on. List 2, serial number 2, Milords.
2, I'm not passing it over. Yes, start. Yes. You want to start. I will vacate the interim order now. ನೀವು ಮಾಡ್ತೀರಾ ಇಲ್ವಾ ಅಷ್ಟೇ?
My lord, the respondent has filed IA, my lord.
ಸೀನಿಯರ್ ಅಂತ ಈಗಲೂ ಅದನ್ನ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ನೀವು ಮಾಡದೇವ್ರು ನಾನು ವೆಕೇಟ್ ಮಾಡ್ತೀನಿ.
My lord, respondent has filed 2 IAs, my lord. There is objection, my lord. He has not served the copies, my lord.
What copy, sir?
He has filed 2 IAs, my lord. They
You
have not
don't
served
forget
the
about the
copies to my lord.
come on merits. What is merit? ನಿಮ್ ಕೇಸ್ ಹೇಳಿ. ಅಯ್ಯ ಬಿಟ್ಟಾಕಿ. Why are you surprised? Argue ಮಾಡಿ.
Saying he has entered a particular meeting wherein he was not a member, he is not an executive body member, he is not an executive council member, and whatsoever. He entered the meeting and the chairperson, the presiding over the meeting, says him, it is not the right place to come over here, you should not be here. And later on, the whatever conversation went on, the complainant was recording it in his mobile, which is not allowed at all. First of all, he should have not entered the premises at all. Then he should not have entered he should not have done the video recording. That kind of a thing it has taken place. Later, it is purely a civil matter. Because one, Mrs. Dr. K.A. Netravati is the owner of the said premises on flat number B8404 of Kailash VDA apartment. She is the member. She is a professor supported by All India Council for Technical Education scale of pay, which is more than UGC scale. She is working in RV Engineering College. She is the owner of the premises. But the monthly fixed maintenance charges is meager 2,000. Meager 2,000 is for electricity, common water, common gardening, common security services. Like earlier, she was used to pay and she has set a precedent to that effect. Later, she did not pay. Her arrears today are more than 5 lakhs.
ಯಾರು ನೇತ್ರಾವತಿ?
Netravati, Dr. K.A. Netravati.
Who is that Netravati?
Netravati, one lady is the owner. Then this person saying all such things, he quotes the complainant. I mean, the complainant quotes SC atrocity provisions in the complaint. And NCR is given for that.
Hmm.
Earlier to that, who is the executive body member?
Hmm.
They resolved their resolution saying to the, they asking the station house manager, station house officer, that a complaint would definitely come. You should not accept it because the fact the station of who is the executive council members of the Resident Welfare Association. We are duly elected and ours is a registered body wherein the one Dr. K.A. Netra is a signatory to the bylaw and she has given a deed of declaration.
ಈಗ ನೇತ್ರಾವತಿ complainant
Netravati is not a complaint, but the total fact is like that. The actual presentation I am making.
Oh, makes.
Then Mrs. K.A. Netravati, she did not pay the total maintenance just as on today, which comes to 5 lakh.
Oh.
The total residence there, only 308 flats are there. It's built by vide on turnkey project. Like people like us, 308 families are there. But Dr. Netravati is not paying it up. But on behalf of Dr. Netravati, the complainant has come to the, he has filed the complaint and he approached the civil sessions court. Yeah, through PCR, he has filed a PCR fast track. In the first track, the PCR was rejected. Then the complaint is referred to the ACP Kangeri police station. They also filed the summary statement. Then he approached the court of law saying protest memo.
Correct.
He has approached. Okay, there is a provision in the law.
Okay. What okay? Not okay. Really?
Then the protest memo, based on the protest memo, the honorable court has directed the ACP. He asked for a different ACP, not that particular ACP. He has already filed the summary report. Therefore, the DCP has been appointed towards the inquiry. Then the DCP of Chitpet division has filed his report. His summary report -2, wherein he has clearly mentioned, it is there in the file. It is clearly mentioned that no such event has taken place.
Now, what have you challenged?
I have challenged the same. The FIR in the FIR it is there, the complaint it is there.
ಅಲ್ಲ ಏನ್ ಪ್ರೇಯರ್ ಒಂದ್ ನಿಮಿಷ ಪ್ರೇಯರ್ ಕಂಪ್ಲೀಟ್ ಪ್ರೊಸೀಡ್
I have sought by this court to quash my criminal case instituted against me.
All right.
We are 3.
You are 3.
We are accusers are 3. Warrants are 3. Witnesses are 3. I mean, one is Ramaya, the other is MP Nagaraju, and the other is Ganapati Hegde.
Who are they? ಮತ್ತೆ ಹೇಳಿ ಪೆಟಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 2 3 ಅಂತ ಹೇಳಿ ಓಕೆ ಈ ಓಕೆ ಯಾಕೆ
one Mr. MP Nagaraju, wherein there are atrocity cases have been instituted against him. He is a person belonging to scheduled caste community, which the Act provisions will not apply at all to him. Nevertheless, the complaint is taken based on the sworn statement. The complainant has gone through sworn statement wherein he has said whatever he has said in the PCR, and the complainant approaches Civil Rights Enforcement Cell, which inquires atrocities on SSC and ST. Wherein that particular time, one Mrs. Sindhu Potadar was a presiding officer, and he approached the Civil Rights Enforcement authorities and the Minister for Social Welfare Department, seeking that action should be taken against the presiding officer. She is not handling my cases properly. Therefore, in addition to that, he has quoted many things like other 5 PCRs he has filed, he has taken money for that from the scheduled caste department. That is, there is a provision in it. 75,000, 75,000, 75,000, he has taken the money. In your lordship has a past in the Loknath case, wherein all the monies which have taken on false complaint should be refunded to the department. In Loknath was the state of Karnataka. There is that order you have only passed.
You only,
Your lordship has passed. Then, my lord, I apologize for it.
yes, sir.
Then, in one particular case, in this honorable court, Eric petition was filed. The other one, Srimati Karnataka, Ramalingaya and others. All these people who were on whoever he had filed a complaint, they are the office bearers of the Kailash PDA Apartment Welfare Association. And the mistake only they did is they asked for 2,000 maintenance charges. Even he is not ready to pay that. Therefore, all these taken back 10 complaints. In one particular case, this honorable court in Aruna Kannur and state of Karnataka has dismissed his complaint imposing rupees 25,000 towards exemplary cost. And the sessions court, quotal number 71, they have imposed 5,000 rupees cost against it, which he has not paid. Honorable High Court for Honorable Court, he has not paid. Then he went to Supreme Court of India, Appeals Court. There also, they imposed 30,000 rupees cost. He did not pay. Later, the Appeals Court appointed an amicus curiae. Through that, the court has the case was handled like it has taken place. Likewise, he is giving false complaint against everyone, and that's too very serious, heinous sections like scheduled caste and scheduled atrocity provisions. He claims himself as an advocate. He claims himself as a software engineer in particular complaints, wherein he says, I am the practicing advocate. So this kind of atrocity has taken on me, and nobody is allowing to go stay over there in the premises. 308 apartments.
ಅದು ಹೇಳಿದ್ರಲ್ಲ, ಕೌಂಟ್ ನನಗೆ ಗೊತ್ತಾಯ್ತು.
All people are there very friendly, they are cohesiveness and all that. But only thing is he quotes simple reasons. Very.
ಈಗ ಒಂದ್ ನಿಮಿಷ. ಈ ಜಸ್ಟಿಸ್ ಬಿ ಎ ಪಾಟೀಲ್ ಅವರೊಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ರಲ್ಲ ನಿಮ್ ಎಗೇನ್ಸ್ಟ್, ಗಣಪತಿ ಹೆಗಡೆ ಯಾರು? ಕರೆಕ್ಟ್.
FIR ಆದ ನಂತರ ಗಣಪತಿ ಅವರು ಈ ಕೋರ್ಟ್ನ ಅಪ್ರೋಚ್ ಮಾಡಿ,
ಕರೆಕ್ಟ್
ಅಪ್ರೋಚ್ ಮಾಡಿ FIR ವಾಶ್ ಮಾಡಿ
ಆಗ್ಲಿಲ್ಲ. ಬಿ ರಿಪೋರ್ಟ್ ಪ್ರೊಟೆಸ್ಟ್ ಪೆಟಿಷನ್ ಬಿ ರೀಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರು. ಹೌದಾ?
ಬಿ ರಿಪೋರ್ಟ್ ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು.
ನಾನು ಏನು ಹೇಳಿಲ್ವಲ್ಲ ಈಗ, ಹೇಳಿ.
I approach this. They took the flux of time and it went on infructuous. That's all.
ಬೈ ಇನ್ಫ್ರಕ್ಷನ್ಸ್ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬಿಟ್ರ ಕೋರ್ಟ್?
Flux of time and infructuous.
ಅಲ್ಲ, ಇನ್ಫ್ರಕ್ಷನ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರೆ
because that time the B report was
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ, ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಅಂತ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರ? ಪೇಜ್ 45ಕ್ಕೆ ಬನ್ನಿ ಸ್ವಲ್ಪ, ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ. ಅದು ಆ ತರ ಎಲ್ಲ ಅನ್ಕೋಬೇಡಿ ನೀವು. ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದೀನಿ ನೋ ಮೋರ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಅಂತ. ನೀವು 308 ಫ್ಲಾಟ್ಸ್ ಅದನ್ನ 616 ಮಾಡಿದ್ರು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಇಲ್ಲ. ಎಸ್, ಪೇಜ್ 45 ಕೊಡಿ ಆರ್ಡರ್.
ಯಾವ್ದು?
ಜಸ್ಟ್ ಬಿ ಎ ಪಾಟೀಲ್ ಅವ್ರ ಆರ್ಡರ್ ಅಲ್ಲಿ
ಇದ್ರಲ್ಲೇ ಇದೆ ಸೊಮ್ಮೆ. At annexure number, annexure C, D, at page number 39.
ಅದಿರ್ಲಿ. 39, ಈಗ ಪೇಜ್ 45 ಬನ್ನಿ. ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರು ಅಂದ್ರಲ್ಲ, ಅದು ಪೇಜ್ ತೋರಿಸ್ಬಿಡಿ.
Swami, that is at.
ಕೇಳಿದ್ರೆ ಮಾತ್ರ ಉತ್ತರ ಕೊಡಿ. ಬಸವ್ರ ಯಾಕೆ ಅಬ್ಜಿ ತಗೊಳ್ಳಿ, ತರಿಸ್ಬಿಡಿ. How did you presume such things? Then we'll vacate the interim order.
Well, submission, my lord.
Who are you, sir?
I am the second petitioner, my lord. Another
Second, will come second later. Yes.
What is the submission made by the council in this case, my lord? It was B report was filed. Before filing B report, the petition was pending. Therefore, it was infructuous and taken withdraw that matter. my lord.
Elli infructuous antilla sir illi petition being devoid of merit is liable to be dismissed and is accordingly dismissed. ಅವಾಗ prayer ಏನಿತ್ತು ನೋಡಿ ಇಲ್ಲಿ ಎಂಟೈರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕ್ವಾಶಿಂಗ್ ಕೇಳಿದ್ರು ಅವಾಗ್ಲೂನು.
ಹೌದು ಸ್ವಾಮಿ.
ಮತ್ತೆ
ಅದರಲ್ಲಿ
ಒಂದ್ಸರಿ ರಿಜೆಕ್ಟ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
B report pending ಇತ್ತು. B report once first in this case first B report filed by the investigating officer. Thereafter the complaint seeking further investigation by the higher officer.
Further investigation order ಮಾಡಾಯ್ತು. Even then come to paragraph 9 of the just B.A. Patil's order.
Order sheet dated
order sheet ಅಲ್ಲ ಸರ್, ಆರ್ಡರ್ ಗೆ ಹೋಗಿ.
ಅಲ್ಲ, when the petition was filed before filing B report. So after filing B report, the petition is infructuous. Second B report filed by the investigation officer. In this case, two B reports filed.
ಅಲ್ಲ, ಇವಾಗ ಯಾವ ಸ್ಟೇಜ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಲ್ವಾ?
ಇಲ್ಲ, ನನ್ನ
PCR he was challenged the PCR in protest petition.
One minute. ಈಗ ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
ಪೊಲೀಸ್ ಅವರು ಎರಡನೇ ಸತಿನೂ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರು. Thereafter
sworn state protest petition.
Protest petition.
Thereafter my sworn
cognizance taken by the magistrate.
ಒಂದ್ ನಿಮಿಷ, ಇಬ್ರು ಹೇಳಿದ್ರೆ ಆಗಲ್ಲ, ಒಂದ್ ನಿಮಿಷ ತಾಳಿ.
All the documents, Swami, kindly look at.
ನಾನು ಏನ್ ಸ್ಟೇಜ್ ಅಂತ ಕೇಳಿದ್ದೆ ಅಷ್ಟೇ.
It is in the inquiry stage. Court cognizance ತಗೊಂಡ್ಮೇಲೆ
ಇನ್ನು cognizance ತಗೊಂಡಿಲ್ವಾ?
ತಗೊಂಡಿದೆ. That order is there at annexure E.
Page
47
of objection.
Of my objections. Malad, last para, I would like to read last para.
Oh, this is the order taking cognizance, is it?
Yes, cognizance taken by the court, my lord, and that order is challenged before this honorable court. This is the stage of the second petition.
Seventh para. I have 61 documents mark ಮಾಡ್ಸಿದ್ದೀನಿ. Thereafter MO1.
ಆಯ್ತು, ಒಂದ್ ನಿಮಿಷ.
I'll just read para 7.
I have read. Yes. Yes, sir. Anything else, sir?
I'll show even the flat is the name of one.
ಅದೆಲ್ಲ ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್. ಮತ್ತೆ ನೇತ್ರಾವತಿ. You ask ನೇತ್ರಾವತಿ.
More than 5 lakh amount is pending.
Yeah, that also you ask ನೇತ್ರಾವತಿ. Yes.
The total complaint by the complainant is.
Complaint is not ನೇತ್ರಾವತಿ. Complaint is that you have hurled abuses.
You don't have any relation with him.
ನೇತ್ರಾವತಿ ರಿಲೇಶನ್ಶಿಪ್ ಹೇಳಲಿಲ್ಲ ಸರ್ ಇಲ್ಲಿ, ಇವ್ರಿಗೆ ಬೈದಿದ್ದೀರಾ ಅಂತಿರೋದು. ಅದು ಎವಿಡೆನ್ಸ್. ದಟ್ ಈಸ್ ಎವಿಡೆನ್ಸ್. ಅದು ಆಮೇಲೆ ಅಲ್ಲಿ ಎಲ್ಲ ಕಾಗ್ನಿಸೆನ್ಸ್ ಆರ್ಡರ್ ಇಸ್ ಡೀಟೇಲ್ಡ್. ವಿ ವಿಲ್ ನಾಟ್ ಇಂಟರ್ಫಿಯರ್.
That's true. You must have taken the permission of the chairperson sitting in the chair for to record the video. That also he did not do it. Prima facie, that is a very mistake is committed by this person. Why he should enter a particular premises?
That we'll see. Yes.
This kind of a mistake is done, and the citation. Earlier case.
ಕೊಡಿ ಸರ್. ಈ ಕಡೆ ಕೊಡಿ.
In earlier case, this court has passed strictures against him. And it is a purely a matter of civil in nature. Not have done anything like that. Simply enters. All the association people, like 10 complaints, 10 cases, that's reporting this thing, registration provisions. He takes money from department, my lord, which is meant for innocent persons and which are subjected to this thing, all kind of exploitation. No kind of exploitation is taken against him. Then he takes the money from them. It's a big burden on the exchequer. ರಾಜ್ಯದ ಖಜಾನೆ ಮೇಲೆ ದೊಡ್ಡ ಹೊಡೆತ ಅದು my lord.
ಇದ್ರ ಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗಿದ್ರಾ? ಯಾವುದು ಜಸ್ಟಿಸ್ ಸೂರಜ್ ಗೋವಿಂದರಾಜ್ ಅವರ ಆರ್ಡರ್ ಮೇಲೆ ಏನಾಯ್ತು ಅಲ್ಲಿ?
Yes, my lord. That was also discussed by the Supreme
Wait, sir.
ಎಕ್ಸ್ಟ್ರಾ ಕಾಸ್ಟ್ ಹಾಕಿದ್ರು 30,000.
ನಿಮ್ಮೇಲೆ ಇದಾದ್ಮೇಲೆ ಏನಾಯ್ತು ಅಲ್ಲಿ?
ಅಲ್ಲಿ
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕ್ವಾಶ್ ಮಾಡಿದ್ರು.
SLP ರಿಜೆಕ್ಟ್ ಆಯ್ತು.
ಇದು ಬೇರೆ ಕ್ರೈಮ್ ಆಯ್ತು?
ಬೇರೆ ಕ್ರೈಮ್.
ಬೇರೆ.
He has approached SCST Commission. He has approached SCST Civil Rights Enforcement Cell through very many petitions. Wherein he files affidavit to say that I have not filed any complaints before any court of law like that. All such mistakes he does and he creates a nuisance with the total campus, my lord. That has been taken consideration by this honorable court, my lord. If you provide me some time, I'll file.
No time, sir. No time illa bidi. Yes, ಹೇಳಿ ರವಿಕುಮಾರ್.
Swami, this honorable court linked with another case that is 3870. ಅದರಲ್ಲಿ ಅಕ್ಯೂಸ್ಡ್ ಬೇರೆ, ಇನ್ಸಿಡೆಂಟ್ ಬೇರೆ.
ಅದನ್ನ ಕೇಸೇ ಬೇರೆ ಮಾಡೋಣ. ಇದ್ರದ್ದು ಹೇಳಿ ನೀವು.
Swami, I'll just ಎರಡು citation.
ಎರಡು ಕಾಪಿನ ನನಗೆ ಕೊಟ್ರೆ ತೊಗೊಳ್ಳಿ.
Swami, the Supreme Court in Jairam versus BDA.
ಆಯ್ತು, ಅದು ಫ್ರಾಡ್ ಬಗ್ಗೆ ಹೇಳಿ ಆಮೇಲೆ.
ಅಲ್ಲ, ಕನ್ಸೀಲ್ಮೆಂಟ್ ಅಂಡ್ ಸಪ್ರೆಷನ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ಸ್.
ಏನ್ ಕನ್ಸೀಲ್ ಮಾಡಿದ್ದಾರೆ?
That previously ಎರಡು 482 petition ಇದೆ.
ಅದು ತೋರಿಸ್ಬಿಡಿ ಯಾವುದು ಅಷ್ಟೇ.
Swami, it is there in my objection.
ಅದಕ್ಕೆ ಎಲ್ಲಿದೆ ತೋರಿಸಿ ಸರ್.
The orders.
ಹೌದು, ಆರ್ಡರ್ಸ್.
At annexure number D and F.
ಒಂದ್ ನಿಮಿಷ.
D page number 39.
D 39. F ಯಾವುದು?
At 56. ತಾವೇ ಮಾಡ್ರಿ. At 56, 2 pages order.
ಅದು ಇನ್ಫ್ರಾಕ್ಚರ್ಸ್ ಆಗಿದೆ ಅಷ್ಟೇ. ಅದಿರ್ಲಿ, ಡೋಂಟ್ ವರಿ ಅಬೌಟ್ ದಟ್. ಈಗ ಕ್ರೈಮ್ ನಂಬರ್ ಯಾವ್ದಿದು?
264 of 2018.
2019.
18.
Filed memos dismissed on the ground that rendered infractions by reflex of time.
Same crime number.
ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇತ್ತು ಅದು ಹಾಕ್ದಾಗ?
ಫಸ್ಟ್ ಹಾಕ್ದಾಗ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರು ಫಸ್ಟ್ ಟೈಮ್. ಸೆಕೆಂಡ್ ಟೈಮ್ ಹಾಕ್ದಾಗನು ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ 2 days ಈ ಫಸ್ಟ್ ಆರ್ಡರ್ ಏನ್ ಪಾಸ್ ಆದ್ಮೇಲೆ ಇಮಿಡಿಯೇಟ್ಲಿ 2 ದಿನ ಆದ್ಮೇಲೆ ಮತ್ತೆ 482 ಹಾಕ್ತಾರೆ. ದಟ್ ವಾಸ್ ಇನ್ಫ್ರಕ್ಚುಯಸ್ ಅಂತ ಡಿಸ್ಪೋಸ್ ಆಯ್ತು.
ನೀವು ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಂಡ್ಬಿಡಿ, ಬೆಟರ್. We'll leave all contentions open. You file discharge. In case you don't get discharge, you can come back. Details ಎಲ್ಲ ಅಲ್ಲಿ. Because cognizance order is reasoned. Nothing ಇದು other offenses, not that ಇದು, but the para 7 at page 54. It is on the strength of so many documents.
I have video evidence as well as audio evidence.
ಯಾಕೆ ತೆಗೆದ್ರಿ?
ಸ್ವಾಮಿ,
ಯಾಕೆ ವಿಡಿಯೋ ತೆಗೆದ್ರಿ?
ಅಲ್ಲ, if ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನ್ ಹೇಳಿದೆ,
ವಿಡಿಯೋ ಯಾಕೆ ತೆಗೆದ್ರಿ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನ್ ಹೇಳಿದೆ? ವಿಡಿಯೋ ತೆಗೆದು ಕೇಳಿದ್ರ ಸುಪ್ರೀಂ ಕೋರ್ಟ್?
ಸಪೋಸ್ it was in the public, it was a public meeting. ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ತುಂಬಾ irregularities ಆಗ್ತಾ ಇದೆ. So I have taken a video. I have recorded my video.
ಅದೆಲ್ಲ ಮ್ಯಾಟರ್ ಆಫ್ ಎವಿಡೆನ್ಸ್. Yes. We'll file discharge or we'll reject it. Yes. ಅದು connected matter ಆಮೇಲೆ ನೋಡೋಣ.
Connected matter, my lord, one short accommodation, my lord. I have met a small accident. I could not able to come to court. That is the reason I am saying. One next week any date may be fixed.
Discharge ಆಗ್ತೀರಾ ಹಂಗೆ?
Which one?
Yes. the petitioner, after arguing the matter at length, would seek leave of this court to approach the concerned court by filing an application seeking his discharge from the area of offences as obtaining under section 227 of the CRPC. In the event the petitioner would approach the concerned court by filing an application seeking his discharge, the concerned court shall answer all the contentions that is raised by the petitioner in the said discharge and pass necessary orders in accordance with law. The aforesaid observations, the petition stands disposed, leaving open all the liberty to the petitioner as is available in law.
Abdul, but that is.
Why are you worried?
Criminal petition number 3870 short date may be separate.
ಇಲ್ಲೇ ತೀರ್ಮಾನ ಮಾಡ್ಬೇಕು ಅಂತಿದ್ಯಾ?
ಅಲ್ಲ
ಮತ್ತೆ
ಇಲ್ಲಿ ಕೇಸ್ ಇದ್ಮೇಲೆ 482 ಅಲ್ಲಿ
ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಂತೀನಿ ಅವ್ರ ನಿಮ್ದೇನ್ ಪ್ರಾಬ್ಲಮ್? ಎಸ್
my lord, another
this is the problem. Next.
My lord, second petition, my lord, 3870 it may be
criminal petition 2.1 list after 3 weeks. Yes.
Number 3.
ಎಲ್ಲಿ ರಾಜಶೇಖರ್ ಗೊತ್ತಾಯ್ತು, ಅವ್ರದ್ದು ನೇಮ್ ಇಲ್ಲ ಅಂತ ನಿಮ್ದೇನಿಲ್ಲಲ್ಲ ಮೇಡಮ್?
ನಂದು ಒಂದು ಸಬ್ಮಿಷನ್ ಇತ್ತು, ನಂದು ಓಪನ್ ಆಗ್ಲಿಲ್ಲ ಇನ್ನು. Google LLC has not complied the order.
Lordship, I appear for Google LLC. We are in process of complying.
Why, sir?
Lordship, the order we have received, we have conveyed it to them as well. They are in process of complying, Your Lordship.
Why you need somebody else's order, is it?
No, Your Lordship. No, Your Lordship.
We are not going to unblock this by the evening of today.
Yes, yes, sir.
ಯಾವತ್ತಿನ ಆರ್ಡರ್ ಇದು?
22nd August, Your Lordship.
22/8.
14/8.
22/8.
Affidavit ಹಾಕಿದ್ರಿ 22/8, correct. This court on 22/8/2025 had passed the following order. Learned Counsel Srimati Akshata Shetty submits that the channel of the which respond number 16 is yet to be unblocked by Google. It is ununderstandable as to how Google is now taking 1 month to comply with the order which happens with the click of a mouse. The action of Google fringes on the borders of contempt of the order passed by this court. Therefore, in the event the same is not complied with by the Google LLC, in the next 24 hours, appropriate orders would be passed on the next date of hearing. Yes. Then ಇದು ನಿಮ್ದು ಯಾವ ರೆಸ್ಪಾಂಡ್ ನೀವು? Respondent number 15 in the subject petition has filed a statement of objections. In the statement of objections, the 15th respondent would contend that he is not a party to the proceedings before the concerned civil court, against which the present petition is preferred. It is trite that if a particular respondent here is not a defendant before the concerned court, without the leave of the court, the respondents who are not the defendants cannot be added. Therefore, any order that is passed by the civil court or this court would not become binding upon the 15th respondent. Nonetheless, the respondent would submit that his YouTube channel is also blocked. Google.
I will comply.
Therefore, which respondent is Google?
19.
Therefore, the respondent 19 shall forthwith unblock the YouTube channel of the 15th respondent as well.
I apologize, Your Lordship. It's respondent number 6 in this.
Google.
Yes, sir.
6. Google is respondent number 6. Yes.
And item number 10 in the schedule.
The 15th respondent hyphen item number 10 in the schedule.
Please.
ಇವ್ರದ್ದು ಎಷ್ಟು ಹೇಳಿದೀವಲ್ಲ ಆಲ್ರೆಡಿ ಮೇಡಮ್?
ನಾನು 16 ಮಾತ್ರ ಹೇಳಿದ್ರಿ ತಾವು, ಇನ್ನೊಂದರಲ್ಲಿ ನಾನು 10 ನನ್ನ ಐಟಮ್ಸ್ ಎಲ್ಲ ಹೇಳಿದ್ದೆ.
ಐಟಮ್ಸ್ ಹೇಳಿದಿರಲ್ಲ ಅದು?
I shall comply, Your Lordship.
Yes, sir. If taken 1 month, it's just a click.
Yes, sir. Bow down.
Because I appear for responding 7 and 8, which is Meta and Instagram. One of Your Lordship's interim order directs taking down only of YouTube links, which we have no control over. May I request Your Lordships to just restrict the order to.
No, it's my order. No.
That's Chandan Gowda's order, of 20th December 2024, the very first order.
Then we'll expand the order to all other links.
The other links, my lords, even in the schedule to the prayer, no, only YouTube links are there. The prayers only need to take down channels. None of these channels are with us.
You appear for Meta and Instagram.
Please, my lords. 7 and 8, my lords.
Yes.
7 and also YouTube LLC ಅಂತನು ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ. They are not the necessary parties. It is only concerned with
Google ಸಾಕು, YouTube LLC, Google LLC ಅಷ್ಟೇ ಅದು. ಅದೇನು ಕೈಯಲ್ಲಿ ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 16 ಇನ್ನು ಅನ್ಬ್ಲಾಕ್ ಆಗಿಲ್ಲ ಅಂತ ಇದ್ದಾರೆ ಅವರು. ಇದು ಲಾಸ್ಟ್ ಟೈಮ್ ತೋರಿಸಿದ್ರು.
ಕಾಪಿ ಕೊಡಿ.
Akshata madam, what is this?
I'll file objection. I have to verify it. ನಂದು ಓಪನ್
ಅನ್ಬ್ಲಾಕ್ ಆಗಿದೆಯಾ ಇಲ್ಲ?
ಇಲ್ಲ, ಅನ್ಬ್ಲಾಕ್ ಆಗಿಲ್ಲ.
ಹೊಸ ಚಾನೆಲ್ ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿಲ್ಲ, ಅವರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ದೇ ಹ್ಯಾವ್ ಮೇಡ್ ದ ಸಬ್ಮಿಷನ್. ಇನ್ನೊಂದು ಚಾನೆಲ್ ಇದೆ. ಮೈ ಚಾನೆಲ್ಸ್ ಆರ್ ನಾಟ್.
ಎಷ್ಟು ಸ್ಟಾಕ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಈಗ?
ಇದೆ ಈಗ ಇರೋದು
ಇದೊಂದೇಯಾ?
ಫಿನಿಕ್ಸ್ ಒಂದೇ ಇರೋದು. ಇದು ಇನ್ನೂ ಓಪನ್ ಆಗ್ಲಿಲ್ಲ.
ಅದು ಮಾಡ್ತಾರೆ. ಸಾಕು, ಎಷ್ಟು ಚಾನೆಲ್ ಬೇಕು ನಿಮ್ಗೆ?
ಇದು ಓಪನ್ ಆದ್ರೆ ಮತ್ತೆ 3 ನಡೀತದೆ ಅಷ್ಟೇ, ಮತ್ತೆ ಎಕ್ಸ್ಟ್ರಾ ಮಾಡೋದು.
Affidavit. Why do you do this? I'll direct not to unblock now.
I have to verify.
What verify? 39.
Not following his YouTube.
You should, madam, your client's thing you should follow. There, how do you answer?
I'll verify with him. This is regarding ಹೊಸ ಚಾನೆಲ್ ಬಗ್ಗೆ. That is not under challenge. ಅದು ಬ್ಲಾಕ್
ಆಗಿದೆ. ಯಾವ ಚಾನೆಲ್ ಆಗಲಿ that ಮಾತಾಡಬಾರದು ಅಂತ ಹೇಳಿದ್ರು.
Undertaking is undertaking.
ಮತ್ತೆ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟು not only this, through any channel you will not do ಅಂತ ಇರೋದು. Why do you want? I'll take this on Tuesday, on Wednesday. Verified.
Unblocking.
Subject to that.
May I request your lordship?
Yes. Then that will pass on Tuesday. Yes.
Please.
Ask Rajshekhar to come. 3 point. Mike, mute ಮಾಡಿ sir.
3.1, my lords, regarding furnishing of PF, my lords, I'll do the needful.
By then, yes, needful be done.
Office note 3 and my lords 5 does not survive, my lords. That already interim order has been.
ಯಾವುದು?
IA regarding office objection, my lords.
IA what? IA number?
Vacating, my lords. 13 and my lords 16. Already.
ಅವ್ರದ್ದು ಅದು?
ಅವ್ರದ್ದು modify ಆಗಿದೆ already.
IA2. Well, mail order on IA2 already passed ಅಂತ. Order on IA2 is already passed. Therefore, the application is spent itself. Yes.
1 and 2, my lords.
1 ಯಾವುದು?
1 by 13, my lords.
13 ಆಗಿದೆಯಾ?
13 ಆಗಿದೆ.
Lord, IAPF respondent number 13. Order is already.
IA 1 and. Yes.
Lords, regarding office notes, R14 has been served, my lords, is unclaimed. Will be held sufficient. Office note
13 or 14?
14.
The postal shara indicates R14. Service to R14 is left unclaimed. Therefore, register to print the name of R14 and show the person is served. Yes. Next. Wednesday. 17th.
Passport still number 6.
Respondent babe.
Yes, sir.
The petitioner is the tenant of a 4th floor portion of a mall. After the expiry of tenancy, there were talks between the parties for extension of lease. And the extension of lease, the period is also fixed. Kindly turn to page 115. Para 13 ಅಲ್ಲಿ 37,50,000 was the advance amount. We were required to enhance the advance amount by 7,58,125, which we have done it. We have paid it. Then the lease deed was not executed from some reason. Thereafter, they said we are going to renovate the mall, and the entire mall was become vacant at their instance. Now finally see the photographs are produced before the court.
No, why
Kindly
are you
tell the-
before the court now? ಇಲ್ಲಿಗೆ ಯಾಕೆ? ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೆ?
The trial court has not granted the injunction in my favor, therefore I am before the court.
Then now that it is there, you go before the court and they will consider pass now necessary
now.
orders. 2 weeks, commercial voice, huh?
Commercial.
2 weeks.
Commercial AA.
Whatever, 2 weeks I'll continue this.
Yes.
The petitioner is before this court.
May I just make one
Yes, sir.
request to the court, my lord? Lord, he is carrying on business in the property. He has not paid rent from April, my lord. He is not.
I'll only make that observation, the court will pass orders.
Please.
So for rent is concerned, there is understanding till the renovation work is over.
No, no,
We
what
did
is
not
this?
pay, we did not pay the rent.
I have a list of the amount of money that he is getting from. this.
Understanding, misunderstanding ಎಲ್ಲ ಅಲ್ಲಿ.
ಅಲ್ಲ, ಹಾಗಲ್ಲ.
Please kindly,
After
kindly turn
April-
to page
one minute.
123.
Wait one ನಿಮಿಷ.
After April 2025, there was an agreement that you will pay me the higher of either the minimum rent or 10% of the revenue that you are generating. Lord, I have, and
ಈಗ
your
arrears ಎಷ್ಟು?
arrears 54 lakhs,
Our
55
help
lakhs ಇದೆ.
That I will only note, let the court consider.
Please. From April, it has not been
The
paid, it is
petitioner
55.
is before this court.
123 they say, will waive off the minimum guarantee rent. Brilliant.
ಅದೆಲ್ಲ ಅಲ್ಲಿ ನೋಡ್ಲಿ ಸರ್.
He can't have the benefit of an equitable order unless he pays rent.
The petitioner is before this court seeking the following prayer. The petitioner is said to be the tenant and the defendant before the, in commercial appeal ಇದು? Commercial AA.
Section 9 application.
Section 9 application. Commercial A 303 of 2025. The dispute between the two is regard to payment of rent, inter-alia. The petitioner knocks at the doors of the concerned court seeking an order of injunction or restraint against the respondents with interference with the possession of the petitioner of the scheduled premises. The concerned court does not grant injunction but only issues notice. Therefore, the petitioner is before the court seeking grant of an injunction. The projection was that the petitioner would be evicted. Therefore, this court, in terms of its order dated 11/8/2025, had granted an interim order of status quo. The said order is subsisting as on date. The respondent has now entered appearance. The learned senior counsel GL Vishwanath, appearing for the respondent, would submit that the petitioner is in arrears of rent to the tune of 55 lakhs, which is disputed by the counsel for the petitioner, contending that there is an understanding between the two. When the mall gets functional, rent becomes payable. Be those submissions as they are, arrears of rent or the claim of rent, all of which are now at large before the concerned court. The only protection that was granted to the petitioner was still the appearance of the respondent, which was status quo to be maintained by the parties. In the light of the appearance as observed herein above, I deem it appropriate to direct the concerned court in commercial AA 303 of 2025 to consider the application seeking injunction or restraint against the respondent from entry into the scheduled premises in accordance with law, bearing in mind the observations made in the course of the order, both of the petitioner and the respondent. Since the interim order is operating, I deem it appropriate to extend the same for a period of 2 weeks and bind the concerned court to consider the application within 2 weeks from the date of receipt of the copy of this order. Yes, ordered accordingly. All contentions remain open.
2 weeks from date of issue of certificate copy.
ಅದೇ ಸರ್ಟಿಫೈಡ್ ಇಲ್ಲ, ಆರ್ಡರ್ ಕಾಪಿ ಆಫ್ ದಿ ಆರ್ಡರ್ ಅಪ್ಲೋಡೆಡ್ ನಾಳೆನೇ ಆಗುತ್ತೆ.
Your lordship may say uploaded copy.
ಅಪ್ಲೋಡ್ ವೆಬ್ ಹೋಸ್ಟೆಡ್ ಕಾಪಿ ಆಫ್ ದಿ ಆರ್ಡರ್.
Hosted copy.
ಇಲ್ಲರ ಆ ಕೋರ್ಟಲ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಇಲ್ಲ ಅಂತ
ಇಲ್ಲ, web hosted copy, your
Yes.
lordship.
Unless we give the copy, they will not hear it.
ಹಾ
Unless we give some copy there, they will not take up the matter.
ಕರೆಕ್ಟ್, ಅದಕ್ಕೆ ವೆಬ್ ಹೋಸ್ಟೆಡ್ ಕಾಪಿ.
Password 7.
ಹಾ ವಚನ್.
Lying with the DC, my lord.
Huh?
File is with the deputy commissioner.
We'll
Land
see,
acquisition.
we'll impose exemplary costs because it has been in violation of, ಯಾಕೆ ಪರ್ಸನಲ್ ಫೈಲ್ ತರ ಇಟ್ಕೊಂಡಿದಾರ? What's the problem? Why is the lady holding on to the file? Extraneous reasons? This court has passed 3 orders to pass an order on the resolution. I'll record that the file is with the lady. And definitely make observations on that.
My instructions were that, my
ಹಾ,
lord.
ನಿಮ್ ತಪ್ಪಲ್ಲ.
I'm just,
ನಿಮ್ ತಪ್ಪಲ್ಲ sir.
I've intimated to the
Yes,
BDM, my
yes,
lord. what-
that will order, heard reserved.
Allah, may I request this, my lord?
Merits ಮೇಲೆ ಕೇಳಾಗಿದೆ.
ಇಲ್ಲ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಇಲ್ಲ. ಮೆರಿಟ್ಸ್ ಮೇಲೆ the recommendation of the BDA will have to be now placed before the issue, my lord, is this.
Correct.
The Justice Keshav Narayan Committee, my lord, says this land can be used for acquisition for the formation of the layout. Now, my lords, the denotifying authority is the state, my lord. The BDA will have to put up a report to the government saying that, my lord, that whether we need this land or not, based upon which the state takes a decision.
Now, what is the recommendation of the committee? In his favor.
Committee is in its favor, my lord.
Correct? Committee ಆದ್ಮೇಲೆ BDA has to pass a resolution, correct?
BDA, my lords, correct.
You are dilly-dallying to pass a resolution for reasons known to you or best known to you.
May I request this, my lord? I may be directed, my lords, to make a statement, my lord, from the relevant officer on this issue, my lord, because
Not
we have,
necessary, sir.
the reason is
We
this,
need not wait for the officer to come here and do it.
may I
Court,
submit this? May
I
submit this?
have direct first 4 weeks, next 4 weeks,
I understand.
finally 2 weeks.
Allah, there is,
No, ಇದು when the pinch is felt, it is only then they will act.
becomes a very heavy precedent for me. The reason is this,
For
I'm
you.
sorry, my lord. No, my lord, not for me. for
Then?
BDA. What I'm trying to say, my lord, is this. His lordship's order was that once the committee gives its report, that the BDA has to consider it and place it before the
Correct.
state.
ಹೌದು.
Place it before the state. No, my lord, if I suffer a precedent to the contrary, it has a cascading impact on several other matters. For one erring official's mistake, it should not be a case, my lord, where the BDA
Help, sir.
suffers.
We should we'll take care of the erring official and peculiar facts al ಬರಿಯೋಣ, ತೊಂದ್ರೆ ಇಲ್ಲ.
If the,
But erring official will
that
bear
is,
the brunt.
I'm not
Yes.
for a moment, my lord, talking for anyone, my lord, who is
Yes.
not following the orders. I'm not on that, my lord. What I'm trying to say, my lord, is that the BDA, my lord, should not be at the receiving end of the erring official's mistake.
What cadre? Deputy commissioner, huh?
Deputy commissioner. My
Since when
submission,
is the officer deputy commissioner there?
I do not know the posting date, my lord. I'm sorry, but may I request this,
Now
my
we'll
lord?
pass the
Lordship,
order.
lordship may kindly observe in today's daily order to an extent that the concerned official may be present or something, so that, my lord, it is
Unnecessary,
understood.
sir.
ಇಲ್ಲಾಂದ್ರೆ ಏನಾಗುತ್ತೆ, the BDA, my lord, any
Unnecessary,
order.
sir. It is not that we should go on giving them opportunities to act to our orders.
There are several, my anxiety is only
No,
this
no,
much.
several ilva illa. We have passed some orders. 10 weeks in I am asking to pass a resolution. Resolution is not being passed. I could have passed an order on day 1
Understand,
itself.
my lord. My anxiety only I'm expressing, my lord. Only anxiety, my lord, is that we have several matters, my lord. It's a very, several villages, the committee is looking into the matter, several villages, several reports are coming in. It should not be a
ಈಗ
case, my
ಈ
lord, that-
ರಿಪೋರ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂತಾನೆ ಹೇಳಿದ್ದು ಏನದು?
Also, ಇದರಲ್ಲಿ similar orders are produced
Ah,
before.
that's
ಅದ್ರಲ್ಲಿ ಏನಿದೆ, ಅದ್ರಲ್ಲಿ ಏನಿದೆ?
They have dropped the acquisition proceedings,
I-
relying on the
ಅದ್ರಲ್ಲಿ
recommendation of the committee.
that matter of the two matters,
ಈಗ
I handled one matter. my lord.
Justice Keshav Narayan committee's recommendation is only in tune with those, nothing else.
What order my learned friend is producing, my lord, I handled one of those cases. In that case, my lord, the BDA had taken a decision pursuant to which it was sent to the state. State still went ahead with what BDA had recommended. That was quashed by the honorable single judge. It is not a case, my lord, where the
Now
file
you
was still with the BDA.
paraphrase the state with the committee, that's all.
Allah, it will alter, materially alter the observations, directions issued by his lordships, my lord.
We'll
That's
see.
my,
We'll
that's,
see.
may I request this?
We
my
will
lord?
not do all that.
I understand, my lord, for a moment, my lord.
No,
if
no
I may
more
say-
chance to this officer.
No, may I say this, my lord? May I say this?
We will definitely make observation, no more chance to this officer.
If I may, my lord, say this. Lordship may kindly consider this, my lord. BDA, my lord, does several other works for this entire layout. Now, with one official's, what I would not say, I do not know, wooden hands, my lords, it would entire BDA might suffer an order, and that will have cascading impact on so many other things, my lord. I might not be able to say.
What choice?
But my lord, if my,
You have
if my-
intimated everything.
ನಾನು ಹೇಳಿದ್ದೀನಿ
ಆಯ್ತು.
the letter is also there.
ಆಯ್ತು.
ಏನು ಅಂದ್ರೆ ತಾವೇನಾದ್ರು, if your lordship directs the officer to be present,
Not
might be, my
necessary.
lord, that might suffice, my lord.
Not
That might take
necessary,
care of the
sir.
entire matter. So
Not necessary at all. Now not necessary. After giving so many chances. Yes.
ತುಂಬಾ cascading impact ಆಗುತ್ತೆ ಅಂತ ಅಷ್ಟೇ,
ಏನ್
ಇನ್ನೇನಿಲ್ಲ.
ತೊಂದ್ರೆ ಇಲ್ಲ.
ಬೇರೆ ಎಷ್ಟೊಂದು ರಿಪೋರ್ಟ್ಗಳು ಬರುತ್ತೆ ಅದಕ್ಕೆ.
ಬೇರೆಯವ್ರಿಗೆ ತೊಂದರೆನೇ ಆಗಲ್ಲ. ಆಫೀಸರ್ ಮಾತ್ರ ಕ್ಯಾಸ್ಕೇಡಿಂಗ್ ಎಫೆಕ್ಟ್ ಆಗುತ್ತೆ. Yes. Yes, yes. Next.
ಅಲ್ಲ, ಇನ್ನೊಂದ್ ಸತಿ ತಾವೇನಾದ್ರು
ಬೇಡ ಬೇಡ ಸಾಕು. Enough is enough. Next.
at my
ನಿಮ್ದೇನ್
hands,
ತೊಂದ್ರೆ ಇಲ್ಲ.
at my hands it should have happened ಅಂತ ಅದಷ್ಟೇ.
No, don't worry about that. Nothing against you.
I
Nor
understand, my
there
lord.
will be anything against you.
I understand that, but nothing. I've intimated the BDA. It is not that I'm not.
No problem. We'll do it.
Every officer is aware of the order. ಅಷ್ಟೇ,
You will get aware of the order. Don't. Effect will be felt.
Leave it to me.
Yes.
Obliged.
Yes.
Right?
Doing for the.
I filed Wakalar for the respondent. Wakalar
Not,
is not put up. Copy of the writ petition is not served.
Coming for the first time, my lord, they are not even KVT file.
They have informed before the trial court that the matter is.
It is strike.
A matter in
But-
Edison.
ಆಗಿ ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ I am the tenant, my lord, defendant in a suit for eviction filed by the respondent. Now suit is filed in the year 1918. Subsequently, my lord, an application is filed. 2018, my lord.
1918.
Subsequently, my lord, an application is filed by them saying that I have to pay rent from the date of filing this suit. I have filed objections. Now, I produced the documents showing that I have paid, my lord, 20 lakhs as property tax. Now, I have produced the documents marked in the evidence. Now, I produced the even the BBMP receipts also I produced. I produced the bank statements also, my lord. In the cross-examination, my lord, the respondent admit that they have not paid the property tax. My lord, the property tax is paid by me subsequent to filing the suit. That is about 17,40,000.
What is the challenge, sir?
My lord, the court passes an order, my lord, ignoring the payments paid by me to pay the rent from the date of filing the suit. But I have no objection regarding, my lord, regarding paying the rent. My only, my lord, the grievance is that the amount paid of 19 lakhs will be deducted, my lord, while calculating the amount. That's all is my grievance before your lordship, my lord.
I'll file my
Lieutenant
respective
Counsel
objections.
so and so undertakes to enter appearance for the respondent registry to print the name of so and so as appearing for the respondent.
Wakalat is already filed.
Filed,
IN number 15 is now
submits
filed.
that is entered appearance.
Now, IN number 15 is filed, my lord. It is posted tomorrow for hearing, my lord, wherein they want my defense should be struck off because I did not follow this order, my lord.
Yes, when do you want?
I have sought, my lord, in three
Next week.
stages.
Wait,
Please.
That's next week, my lord.
next week, list the matter on 26th,
Much obliged.
22nd. Further proceedings before the concerned court
My
shall
lords,
remain
with
state.
respect to further proceedings may not be stayed, my lords.
ಮತ್ತೆ ನಾಳೆ ನೀವು ಸ್ಟ್ರೈಕಿಂಗ್ ಆಫ್ ಡಿಫೆನ್ಸ್ ಮೇಲೆ ಆರ್ಡರ್ ತಗೊಂಡ್ಬಂದ್ರೆ ಇನ್ನೊಂದು ಪಿಟಿಷನ್ ಹಾಕ್ಬೇಕಾಗುತ್ತೆ.
First will not, he is not tendering his appearance to evidence, my lords.
That will bind him,
Cross
don't worry.
examination
But
ಆಗಿದೆ.
the only
ನಾನು document
problem
ಕೂಡ
is-
ಹಾಜರುಪಡಿಸಿದ್ದೀನಿ.
Will not press till 22nd, my lords. Further
Let there
proceedings
be
may
Court
not be
will not
stayed.
listen to you, sir.
My lords, because the
No, I have seen this. Whenever respondents say we will not precipitate, there is no order of stay anta, they will not grant.
My lords, I
No,
am
sir.
ready to undertake that we will not precipitate to tomorrow. My lords, the date, the trial court,
22nd, yes, yes.
my lords, further proceedings may not be stayed, my lords. It will
Yes, next.
cause great
Our
prejudice to me, my
22nd will
lords.
close it.
As in case, my lords,
22nd preliminary hearing.
maybe listed in the fresh matters on the top list, my lords.
Fresh matter antilla, preliminary hearing. Yes. There is no
My lords,
classification as fresh
With
matter.
respect to IA number 11, it may be stayed, my lords. But with respect to proceedings, it will
Nale,
not-
if that order is passed,
hearing, my lords, they have not filed their objections also. Hearing should go on. Hearing will not happen, my lords.
ಹಾಕಿದ್ದೀವಿ, hearing ಕೂಡ ಆಗಿದೆ. ನಾವು ಟೈಮ್ ಕೇಳಿದಾಗ ಅವ್ರು ಅಪೋಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅದ ಕಾರಣ ರಿಟ್ ಹಾಕಿರೋ ಸ್ವಾಮಿ ನಾನು.
Will not
in
press the
Barkode,
hearing, my
the
lords.
impugned order shall remain stayed. The learned counsel for the respondent further undertake not to precipitate the matter before the concerned court.
Till next date.
Till next.
9.
Petitioner, my lords, a money recovery suit was filed based on a check, my lords. My lords, the date of the check and its presentation, both are subsequent to death of the.
Separate decree.
Both, my lords, the date of the check and its presentation, both are subsequent to death of the issuer. Issuer, my lords, has died.
It is not different.
My lords, there was no content, my lords, I have
ಮತ್ತೆ?
suffered a decree. Thereafter, I have filed appeal after receiving notice in the execution
Appeal
petition.
ಏನಾಗಿದೆ?
Appeal, my lords, because there is delay, notice has been issued.
ಈಗ
Now the-
execution ಹಾಕಿದಾರಾ?
Execute, the problem is arrest warrant has been
The
issued.
petitioner is before this court calling in question a warrant of arrest in the execution proceedings. The petitioner is a judgment debtor, suffers a decree of money, of payment of money. Payment of money is on account of two checks. The learned counsel for the petitioner prima facie demonstrate that the two checks that were issued or signed were long after the death of the signatory to the check. Therefore, would submit that the decree itself is in doubt. The learned counsel further contend that he has preferred a regular appeal in RA 26 of 2025 against the said decree. In the light of the application for delay, no stay is granted. In the interregnum, arrest warrant is issued in the execution proceedings. Therefore, the execution proceedings shall remain state till the next date. Yes, next.
The serial number 10, my lord.
10.
Yes, madam.
What, madam?
This too, my lord. That is a covered by judgment, my lord, co-accused statement, my lord.
Oh, Jagdish sir.
Not co-accused statement. This is the examination scam, my lord, where accused number 2 was running a center.
ಯಾವ examination?
PSI, sorry, police constable recruitment.
ಯಾವ್ದು ಅದು PSI scam?
ಅದರದಲ್ಲ, ಕಾನ್ಸ್ಟೇಬಲ್. ಇವರು ಎಲ್ಲದರಲ್ಲೂ ಬೇರೆ ಕೇಸ್ ನಲ್ಲಿ ಇನ್ವಾಲ್ವ್ ಆಗಿದ್ದಾರೆ. This particular case is a constable.
PCI scam.
Constable.
ಅದೇ PCI.
Correct.
ಅದು police sub inspector, police constable.
Constable.
ಏನ್ covered ಏನೋ?
According to me,
It is a my lord, the only these petitioners, my lord, arrest, my lord, only on the basis of accused number 1 to 5, my lord, accused number 1 statement.
Corroborative material ಏನಿಲ್ವಾ?
we have recovered the all ticket. We have recovered the material which is impersonated.
ಇವರಿಂದ?
ಇವ್ರ ಕಡೆಯಿಂದಾನೆ.
ಇವ್ರ ಕಡೆಯಿಂದ, ಸರಿ.
Accused number 7, my lord, the person.
Section 27, of course, earlier Evidence Act ಪ್ರಕಾರ corroboration ಇದ್ರೆ ಬರಲ್ಲ.
Accused number 7 is the person who actually altered the ID cards and everything to manipulate and allow.
He is accused number?
No, here accused number 2, 3, 4, 5, 7 are before this court.
7 is here.
7 is here. And accused number 1 is the person who was impersonated. Accused number.
ಆಯ್ತು ಬರ್ಲಿ ಬಿಟ್ಟು. ಅಲ್ಲೇ ತಗೊಳ್ಳು. List after 4 weeks.
My lord, interim order of stay, my lord, because my lord, this court is already passed, my lord, same ratio, my lord. I
Yes.
filed the, my lord, I filed the memo, my lord, along with.
Oh, no, sir. Yes.
11.
ಯಾವ ನೆನ್ನೆದ ಸರ್?
ನೆನ್ನೆದು.
ನಾರಾಯಣ ಸ್ವಾಮಿ ಯಾರು?
Respondent.
ಅವ್ನು ನೆನ್ನೆ ನೀವು ಇರ್ಲಿಲ್ಲ. ಮಧ್ಯಾಹ್ನ 2:30 ನೀವು ಇರೋದು ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಇವತ್ತಿಗೆ ಹಾಕಿದ್ದೀನಿ ಅಷ್ಟೇ. ಆರ್ಟಿಕಲ್ 58. ನಿಮ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಬಂದ್ಬಿಡಿ. ಪೇಜ್ ನಂಬರ್ 67 ಅಲ್ಲ?
41 ಮೇಲೆ.
41. ಪೇಜ್ 40. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ ಸರ್?
ಕೊಟ್ಟಿದ್ದೀವಿ. ಅಲ್ಲ, served copy.
Page 41.
Allot, in this matter, the earlier suit was decreed. Allot, this honorable court remanded the matter to the trial court for disposal of the matter within 3 months. Allot, there is a issue in respect of.
ಅಲ್ಲ, ಇಶ್ಯೂ ಪ್ರಶ್ನೆ ಅಲ್ಲ. ನಿಮ್ಮ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ನೋಡಿ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ.
Allot, 2002 cause of action. Up to 2009, they filed suits and the respondent was a party in those suits.
That's a different matter. Now you have sued, you have called for cancellation or whatever relief, declaration. You have sought, so you have filed suit for declaration.
Recovery of possession and injunction.
Simultaneous ಆಗಿ ಹಾಕ್ಬೇಕಾಗಿತ್ತು, ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ?
Two suits are pending against the very same party in respect of the very same property.
Article 58.
Date may fix.
ಆಯ್ತು, ವಿಲ್ ಫಿಕ್ಸ್ ಅ ಡೇಟ್, ಬಟ್ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡ್ಬೇಕಾಗತ್ತೆ. ಆಮೇಲೆ ನಿಮ್ಗೆ ಕೇಳ್ಬಿಟ್ಟು ಮಾಡಿ.
Please.
ಹರ್ಡ್ ದಿ ಲ್ಯಾಂಡ್ ಮೇಡಮ್, ನೆನ್ನೆ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ. ಆಯ್ತು, ಎಸ್, ಸೇಮ್ ಆರ್ಡರ್.
Please.
ಅಲ್ಲಿ ಹರ್ಡ್ ಸೋನ್ಸ್ ಅಂತ ಮಾಡ್ಬಿಟ್ಟು ಮಾಡಕ್ಕೆ. ವಿಲ್ ಪೋಸ್ಟ್ ಇಟ್ ಆನ್ ರಿಓಪನಿಂಗ್ ಡೇ ಹಾಕೋಣ.
Please.
10th October.
Please.
Yes. Yes, Virupaksh.
Serial number 12, my lord. Page 36, my lord, is a similar order, my lord, passed by this honorable court.
ಯಾರಿದ್ದಾರೆ? ರಾಜ್ಕುಮಾರ್? Central government.
Railways, my lord, acquisition of land.
Page?
Page 36, my lord.
Page 36 ಇದು.
That's annexure D, my lord. I'm sorry.
ಯಾವ್ದು ವಿರೂಪಾಕ್ಷ ಇರ್ತಾನೆ?
That's writ petition 16672, my lord.
16672.
Please. My lord, order in WP number 4600 of 2022, my lord.
Which page, sir?
Lord, I'm sorry, my lord. It is at annexure D, my lord.
Page 41.
Please. Sorry.
This is Kamal ಅವ್ರದಾ?
Please.
ಏನ್ ಮಾಡಿ, ಏನಿದು?
Lord, the award, my lord, in respect of very same notification, my lord, was set aside and directed, my lord, to award compensation under the new act, my lord, in terms of section 24, my lord, following the
same order will pass. ಯಾರಿದ್ದಾರೆ? ಶಾಂತಿ ಭೂಷಣ್. ಶಾಂತಿ ಭೂಷಣ್ ಹೇಳಿ ಈ ತರ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ. ಅಕಸ್ಮಾತ್ ಅವ್ರ ಪ್ರಾಬ್ಲಮ್ ಇದ್ರೆ ಅಲ್ಲಿ ಪೋಸ್ಟ್. ಎಸ್ ಮೇಡಮ್, ಫ್ಲಾಗ್ ಹಾಕಿದ್ದೀನಿ, ಕವರ್.
both matters. Read.
On A13,
ಯಾವ್ದು?
13 law.
ಹಾ.
13, my lords, you should have it on some other day. 13, in 13 I represent the petitioner, it's a plaintiff's.
13.1 ಏನೋ ಇದೆ.
13.1 is by the defendant whose application.
ಇದು ನೆನ್ನೆ ಇತ್ತಾ?
ಇಲ್ಲ. Some other day your lordships may have it. 13 is, my lords, on admission I had sought for decreeing the suit. That IA is rejected.
12 rule 6.
13.1, they had filed an application under order 7 rule 11 to dismiss it on limitation.
That is rejected.
That is also rejected, both of us.
ಎಲ್ಲ ಅಲ್ಲೇ ಆಗ್ಲಿ ಬಿಡಿ.
On admission, my lords, I have said anyway.
ಆಯ್ತು, list on 22nd. Heard the learned senior counsel Ken Panindra and so Raju sir. List on 22nd. Next.
Same stage.
Same stage.
That is the most important.
ಆರ್ಡರ್ ಆಗುತ್ತೋ ಇಲ್ವೋ ಸೇಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಅಂತ ಬರ್ಬೇಕು. ಇಲ್ಲ ಅದು ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಬಂದ್ರೆ ಆಗತ್ತೆ. Still hypermart.
Yes, my lords.
Start.
My lords, the matter has been argued by learned senior counsel for their reply.
Yes, sir. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ಕಳಿಸಿರೋದು ಸುಮ್ನೆ ನಮಗ್ ತೊಂದರೆ ಕೊಡ್ತೀರ. ಇವ್ರು ಹೋಗಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇನ್ನೂ ಆಗಿಲ್ಲ ಅಂತಂದ್ರೆ ಮತ್ತೆ.
My lords, we shall be arguing today. My senior is on the way.
You shall be.
Today we will complete our.
Today there is some inconvenience. My lordship may fix a date next week.
ಇದೇನ್ ದಿನ ಬರ್ತಾನೆ ಇದೆ, ಏನ್ ಫಿಕ್ಸೆಡ್ ಡೇಟ್? It's Supreme Court remitted matter, sir.
Next week, any date will argue the matter, my lords.
ಲಿಸ್ಟರ್ ಇಲ್ಲ, ಅವ್ರು ಮುಗಿಸ್ಲಿ ಬಿಡಿ.
Please.
ಮಾಡೋಂಗಿದ್ರೆ ಮಾಡಿ. ಅವ್ರು ನಿಮ್ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಇಲ್ವಲ್ಲ ಇವತ್ತು? ನಾಳೆನಾ?
ಇಲ್ಲ, Monday or Tuesday, any date.
ಆಯ್ತು, ಮಂಡೇ ಅದಕ್ಕೆ ಬರ್ತಾರಲ್ಲ ಹೆಂಗ್ ಮಾಡಿ. ಮಂಡೇ.
Please.
Monday will not adjourn it further.
Please.
Yes. Vipin sir.
My lords may kindly fix a time, my lords.
Time 2:30.
Deeply obliged, my lords.
There are many matters at 2:30. ಇದು ಇರುತ್ತೆ.
We'll see.
Yes. ಇದೇನು?
3 matters, my lord, your lordships had reserved it in respect of the Lodha committee.
Oh, correct.
Committee matters, my lord, one matter which was.
Next ಅದಾದ್ಮೇಲೆ ತಗೊಂಡ್ನೋ ಹೆಂಗೆ ಇದು?
ಅದಾದ್ಮೇಲೆ ಇದನ್ನು ಹೇರ್ ಮಾಡ್ಬೋದು.
Tuesday or Wednesday will take, by then I'll pronounce them.
Yes. ಅಲ್ಲ ಇದು application, my lord.
In fact,
yes.
In 15.1, I filed a memo of retirement. And my lord, there is one Pratik Kumar who has sought to
entered
include
appearance.
himself. Please, my lord.
That was allowed, my lord. That is not reflected.
History to delete the name of Harsha D. Joshi as appearing for the second respondent, print the name of Pratik
Chetan
Kumar.
Kumar, my lord, appearing on behalf of R2.
Chandra Kumar.
Chetan Kumar.
ಅಯ್ಯೋ ಅದೇನೋ ಒಂದು ಕುಮಾರ್ ಹೇಳಿ.
And my lord, that impleading application may kindly be listed.
Impleading application ಇದೆಯಾ?
ಅಲ್ಲ ಅದು ಎಲ್ಲೋ ಆಗಿತ್ತು.
ಅದೆಲ್ಲ ಆಗಿರ್ಬೇಕು, ಆರ್ಡರ್ ನೋಡೋಣ ತಡಿ. Yes. ಇದು I'll take this on next Friday. By then I would have pronounced it. Yes.
Obliged.
19th.
At 2:30.
Yeah, further in 2:30 ಎಲ್ಲ ಆ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಇರುತ್ತೆ.
I appear in one of the criminal petitions, my lord. This is that landmark mall case.
Sir, you are not well, and how are you now?
I am better, my lords. I'm better. I had 8 long days of fever. I'm fine now. I don't have any temperature.
No problem. You can argue.
Yes, my lords. I can argue online if your lordship indulges.
Of course, yes. Is there the?
Bank, my lord, the complaint against the chairman and the same thing. But
stay ಮಾಡಿದೀನಲ್ಲ.
Stay ಆಗಿದೆ, but my lord, in one matter, the professional resolution has filed an application.
ಅದೇ RP ಮೇಲೂ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರು.
Permitting him to pay the security charges and other things. That can be allowed.
ನನಗೆ if that
my
application.
Their application is for granting of the permission to pay the security charges and other things has to be allowed, because security, unless they pay the security charges, I don't think any security agency will be providing the security.
Your lordship may kindly see, Learned Senior is arguing, lords, it's in my favor. Your lordship would kindly see.
Respondent
in the PCR.
Really, Shankarappa is not there, is it?
No, no, he was there, my lords.
ಆಯ್ತು,
My
next
lord,
week.
kindly see the complaint. Just one submission, my lords.
No, I have
Kindly
seen,
see
I
the
have heard
complaint.
also. Nitin sir,
on
you
30
complete, you come
on-
get,
on
recover
30
completely.
on
We'll
30
take it on 19th.
My lord, allala, withdrawing the money, my lords. Money withdrawal, my lords. I am in
ಇಲ್ಲ ಅಂದ್ರೆ
a suit.
Monday or
In the
Monday or
complaint
Tuesday.
said,
Monday or Tuesday, yes.
my
15th
lord,
or
from
16th.
out of my pocket, I am paying, my lords. I am a chartered accountant, my lords. For the responsibility given by the court.
Respondent
I am
is
being-
not here.
My lords, every time this happens, my lords, I was informed by my
ಆಯ್ತು.
colleague, he was there in the court.
Heard the learned senior counsel G.
maintain your-
Krishnamurthy and Nitin Ramesh appearing for the petitioners in all these cases. Learned counsel for the complainant remains absent. Awaiting his appearance, list the matter on 16th, 19th. In the event the respondent could not be present, appropriate orders would be passed on the plea of the petitioner for release of funds to maintain the property. Yes. Next.
Lords, may kindly continue the interim order, my lords.
Interim order subsisting will continue. Yes. Next.
All the matters.
All the interim order time ಬೇಕಾ?
Matter. This one.
2:30, 19th, yes.
17?
My lord, we are appearing for R1. My colleague is not able
Yes,
to
sir.
appear today, my lord. We have filed a written statement. If we can, if the court may grant a short adjournment.
No,
it will be
sir.
helpful, my lord.
This has been repeating. Eli, you tell what is the
My
matter?
lords, we had filed a memo along with the judgment of a coordinate bench, if your lordship sees, my lords, pertaining to the same issue.
Same issue?
My lords, what the petitioner, my lords, was in the internal complaints committee, my lords, was an external member.
Internal complaints committee, external member.
External member.
All right.
My lords, so inquiry was held against the first petition, the first respondent hearing. They found him guilty of some sexual report was given. It was an unanimous report. There were other members. On the unanimous report, my lords, there was an order of termination passed by the employee. That he challenged before the Labour Commissioner. The Labour Commissioner set aside the termination order, but passed certain adverse remarks against the petitioner herein, saying that there was collusion and she had misconducted herself. That, my lords, we challenged it by filing a writ petition before this honorable court.
What happened to that?
Please come to the order, my lords, of 19th April 23, along with the memo dated 14/7.
Same month.
Yes. In that, the first petitioner conceded that those remarks were uncalled for at para 4, my lords.
After this, what happened?
That remarks went on.
This order has become final?
Yes, yes, because it's a consent order at para 4.
All right.
He said those remarks could be eschewed. I mean, before this was happening, when we had challenged it, he had filed a complaint before the Bar Council alleging misconduct on behalf of.
Oh, this Bar Council complaint.
Bar Council complaint put it. In the writ, my lords, there was an interim order. Nobody should precipitate even before the Bar Council. Now, Bar Council, my lords, issues notice and takes up and does not drop the proceedings. I have challenged that, saying that this is nothing to do with my professional misconduct at all. I have participated as a member, my lords, in an internal complaints committee under the POSH Act. In fact, your lordships, my lords, in one of the judgments in Paras Jain's case, my lords, I've held under the Advocates Act, misconduct should relate to professional misconduct in the discharge of duties as an
although
advocate.
he had appeared for someone other.
Here, my lords, I have not even performed my duty as an advocate for somebody. I am only performing my duty as a thing. And now once he concedes.
This has become final?
Lords, I think it has, I have checked. Yes. Now here, once he concedes, those adverse remarks made against me could be eschewed. Now to say I will still prosecute you.
All right, we'll see. Yes, counsel.
My lord, there are 2 or 3 contentions which you have on this, my lord. One,
Yes.
in their averments, the petitioner, as mentioned, she appeared in the ICC on a personal capacity, and she has not taken any kind of honorarium or any kind of payment from the company which she appeared in the ICC committee. However, in the written statement, my colleague has submitted the invoices which she has raised. That is one averment, my lord. Second is the manner in which the ICC proceedings was conducted is where the whole contention is, my lord. That is what we had submitted in the labor court. and Labor Code extensively went through the entire proceedings, and they figured out it was not, as per the ICC norms, and also my client was also exonerated from the entire thing, my lord. This is what we have kind of filed in the Bar Council, which is what is challenged here. My lord, if you may give us some time, the actual
No,
counsel on this
carry
case
on.
will come
Why?
and
No
argue, my lord.
problem. You argue the matter. Yes.
My lord, I request you to give a passover because I'm not fully aware of the statements in the written statement as well. If he
You're
is
not
allowed
holding
to,
one with, you're not holding one with you?
my lord, I just appeared to assess the court stating that he is not available, or rather he is not able to appear today. So if there
No
may,
problem. I'll pass it over.
yes, my lord, that will be helpful.
We'll recall this at 5 o'clock.
That will be helpful, my lord. That will be
Yes.
helpful. Much obliged.
ನೀವು 5 o'clock ಬನ್ನಿ.
I appeal for the petitioner in this matter.
ಇದು ಡಿಕ್ಟೇಟಿಂಗ್ ಆರ್ಡರ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಕೂತಿದೆ.
Yes, sir.
CBI ಕೊಡ್ಬೇಕಾ ಬೇಡ ಅಂತ.
CBI ಅಲ್ಲ, CID
Asking
to
for reopening of
reinvestigate.
investigation.
ಹಾ.
Lordship, I have Friday, my lord, there is some document which I need to place, I'll place this.
ಅದಕ್ಕೆ ಇದು ಫ್ರೈಡೆ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
Lordship, the allegation in this is the sister of the daughter of the deceased is the petitioner before your lordship. Mother was murdered by 3 accused. Then son registered a complaint against those 3 accused. They were arrested. Recovery was also effected at their instance. And then they were in custody for 2 months. Subsequent to which, the brother of accused number 3, who's in the police department, traffic police department, takes the son, the de facto complainant, along with him, makes him drunk, records a video saying that he himself killed his mother and lodged a false complaint. And based on that, he gives a complaint, and the very de facto complainant becomes an accused in this case. And basing that, bail was granted to all the other 3 accused, and then he was charge sheeted as an accused. And then later on, when the trial was on against him, even he was murdered.
Now who is remaining?
Now the sister, that's the mother.
All right, Friday ಮುಗಿಸ್ಬೋದು. We'll take it on 19th. Finally, ಅವತ್ತು ಮುಗಿಸ್ಬೋದು. We'll dictate. ಇದು ಬಂದೇ ಇರಲ್ಲ, ನಾನು ಹಾಕಿಸ್ತಾ ಇದ್ದೀನಿ. Yes. Next.
Further hearing, number 19.
My lord, we have filed writ of
Division bench stay ಆಯ್ತಾ?
My lord,
stay ಮಾಡಿದಾರಾ?
ಇಲ್ಲ my lord, ಇದು actually ಇವತ್ತು ಎಲ್ಲ ಕ್ಲಿಯರ್ ಮಾಡಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ಒಳಗಡೆ ಬರೋ
ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ಒಳಗಡೆ.
ಅದು ಜಸ್ಟ್ 5 days ರೂಲ್ ಇದಲ್ಲ my lord, ಅದರಿಂದ ಬರೋದು. Moreover, the senior is also stuck in quota number 2.
ಮತ್ತೆ ಅದನ್ನ ಹೇಳ್ಬೇಡಿ, ಪರವಾಗಿಲ್ಲ. ಎಸ್.
quota number 2 ನಲ್ಲಿ.
ಸೀನಿಯರ್ ಹೇಳ್ಬೇಕಾಗಿತ್ತಾನೆ.
ಅದನ್ನ ನೀವು ತಾವು ಏನ್ ಹೇಳ್ತೀರೋ ಅನ್ನೋದು ಗೊತ್ತಿಲ್ಲ.
ಅದು ಗೊತ್ತಿಲ್ಲ. ಆಗಾರ ತಗೊಂತೀನಿ ಈಗ ಕೊಡಿ. ಪ್ಲೀಸ್.
ಥರ್ಸ್ಡೇ
ಮೊನ್ನೆ I learned that they have filed the appeal on the 8th. Matter came on the 9th when they took an adjournment. When I came in the afternoon, so your lordship was gracious in saying that the matter would come today. They did not show me the courtesy of telling me. I would not have come to at least on phone. Today also, this is
my mistake, my lord.
This is totally unfair to me. Of course, parties may litigate, but we are brothers at the bar, and there should be a minimum courtesy shown towards me.
ಹೇಳ್ಬಿಟ್ಟಿರೋ ಬರ್ತಾ ಇರಲಿಲ್ಲ.
ಆಯ್ತು, ಅವ್ರ ಅಪೀಲ್ ಹಾಕೊಳ್ಳಿ. ನಂದು I have no more submissions to make in the matter, mother. I conclude my submissions with the only 2 judgments which I am marked, mother. My submission.
ಅವ್ರಿಗೂ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ.
ಅವ್ರು ಕೊಡ್ತೀನಿ. ನಾನು
ಅಲ್ಲ ಅಲ್ಲ ಅಂದ್ರೆ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ.
ನಂದು I have no more argument to advance.
ಸರಿ, ಕೌನ್ಸಿಲ್ ಇನ್ನು ಏನಿಲ್ವಂತೆ. ಸೀನಿಯರ್ ಯಾವಾಗ ಮಾಡ್ತಾರೆ ಹೇಳಿ. ಅಪೀಲ್ ಸ್ಟೇ ಆದ್ರೆ ವಿಲ್ ನಾಟ್ ಟೇಕ್ ಇಟ್, ಇಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಟೇಕ್ ಇಟ್.
In your lordship's file, the order made on the 1st of July probably is ತಮ್ಮ ಮುಂದೆ ಇದೆ. Kindly go to the 95th page, mother.
19th page.
95. That is the kindly see the penultimate para to para 21.
95.
95 is the last page.
95.
Either
My
judgment.
Judgment alla.
I'm sorry, I should have told it.
Yes, sir.
Para 21, the preceding analysis is undertaken to decide the issue on maintainability and entertainability of the subject petition. Therefore, this court has travelled on the periphery of the appointment orders and discharge orders. Counsel will now have to be heard on the merit to the orders. For the said reason, hold so and so. List the matter and third on the third, of course, the copy had not been released. I find justification for not. Even though, in the order, particularly page numbers 74, 84 and 93, your lordship has quite clearly held that they cannot be treated as chattel and that this is violative of natural justice. If it is violative of natural justice as it is, firstly I have pleaded so. Secondly, the orders demonstrated it is not in dispute that they did not give me any opportunity. Now, only on the two aspects, Justice Rajendra Babu's judgment, the Supreme Court judgment, and the two judgments I'm referring to, I have given copies. In addition to Jagmohan's case, which is the most leading case on the aspect, I don't want to carry cold to this.
No, Jagmohan has reiterated in 2024.
So with this matter, I conclude my submissions on the merits also.
S.L. Kapoor, Jagmohan has reiterated.
That does not appear to be a justification.
Learned counsel appearing for the respondent submits that against the order dated 1st September 2025, the respondent institution has preferred a writ appeal. In writ appeal?
1515 of
writ appeal 1515 of 2025, which is yet to be listed before the division bench. Therefore, the learned counsel submits that the matter would be listed before the division bench on the
next week.
In the week commencing from Monday, the next, and would seek time to next Thursday. List the matter on 18th at 3:30 p.m. In the event, the 3:30 p.m.
17th.
17th.
18th, we have some difficulty.
17th at 3:30.
Senior counsel has also said Thursday because his timings adjustment, that is the problem.
I'll barkoli. Learned senior counsel Sri Subramanian Joyce submits that he has no further submissions.
And has filed a memo with the two documents.
Learned senior counsel Sri Subramanian Joyce has filed a memo along with two documents. The same is taken on record.
25th.
Particular
because Thursday is free, I have to ascertain.
18th. Thursday is 18th.
ನಾನು ಏನು ರೂಲಿಂಗ್ಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ ತಮ್ಮ ಫೆಸಿಲಿಟೇಟ್ ಮಾಡೋಕ್ಕೋಸ್ಕರ even the particular paragraphs which are relevant from that, your lordship need not go to the other aspects. Only those paragraphs also given. So it will facilitate very easy. I have no more submissions to make on this.
My lord, both the cases will come up on the same date. Therefore, one day.
Which both the cases?
This
Thursday ಒಳಗೆ ಬರುತ್ತೆ ಅಂದ್ರಲ್ಲ.
It may be up to.
ಅವತ್ತೇನಾದ್ರು ಬಂದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಿ. ನಂದು 3:30 ಅದು ಬೆಳಗ್ಗೆನೇ ಆಗಿರುತ್ತೆ.
18 has some difficulty. Pitar Paksha, mother's ceremony.
Yes, sir. ಆಯ್ತು. ಅಲ್ಲ ಪರವಾಗಿಲ್ಲ, ನಿಮ್ದು ಆಗಿದೆಯಲ್ಲ ನೋಡಿ.
17th ಆಗ್ಬೋದು.
ಅವತ್ತು ಬೇಕಾದ್ರೆ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ತೀನಿ, ಇರ್ಲಿ ಅದು. ಯಾವ್ದು ಮೇಡಮ್ 4 o'clock? AG ಅವ್ರದಲ್ಲ, AG ಮ್ಯಾಟರ್ ತಾನೆ, ಬರ್ಲಿ ಅವರು.
Number 20.
Swing back to the list. Madam. ವಾಪಸ್ ಧಾರವಾಡದಲ್ಲಿ ಧಾರವಾಡ. ಕಾಲ್ ಔಟ್ ಮಾಡ್ಬಿಡಿ. ಇಲ್ಲ ಅದೇ ಮುಗಿಸ್ಬೋದು. ಆಯ್ತು ಕರೆಕ್ಟ್ಬಿಡಿ, ರಿಮೈಂಡ್ ಮಾಡೋ ಮ್ಯಾಟ್ರ್ ಕರೆಕ್ಟ್ ಮಾಡಿ.
List 1. 85.
ರಿಮೈಂಡ್.
No, my lord, this is a case where penalty order has been passed during the pendency of appeal. Such a penalty order couldn't have been passed because it has to await the outcome of the appeal.
I think it's.
Judgment ಇದೆಯಾ?
Please.
At page 70, my lord.
ಕೊಡಿ.
When appeal was pending before the commissioner, my lord, it was.
The petitioner is before this court seeking the following prayer. Heard so and so. The respondent passes an assessment order on 143(3) of the Income Tax Act determining assessed income at so and so against the returned income as against returned income of nil. A show cause notice and consequential penalty order is passed under section 274, read with section 271(1)(c). The petitioner then prefers an appeal before the Commissioner of Income Tax Appeals, which also comes to be disposed. Again, a show cause notice is issued. The petitioner then files ಇನ್ನೊಂದು appeal ಹಾಕಿದ್ರಾ?
No, my lord. ಏನಾಯ್ತು, we filed appeal before the tribunal, which restored the appeal before the commission.
Against the appeal, which was disposed on 31/5/2023, the matter was taken up before the tribunal. The tribunal, on hearing the parties, restores the appeal, filed appeal before the Commissioner of Income Tax Appeals, which was pending consideration. At the stage when it was pending consideration, a further notice was issued by the first respondent, passing the order of penalty under 271(1)(c). The issue is whether during the subsistence of the appeal before the Commissioner of Appeals, the first respondent could have passed an order of penalty. The issue is considered by the coordinate bench and held it was impermissible in law. The coordinate bench has held as follows. Page 73 in the end. 73 to 70. In the light of the learned counsel appearing for the respondent, Dilip would not dispute the position as is considered by the coordinate bench. In that light, the following order, same operative person. Yes.
Grateful. Only the order goes, my lords. Only the penalty order goes, my lords.
Only penalty order.
A1, A2, A3, my lord. Basically,
penalty orders ಯಾವ್ಯಾವುದು?
Computation and the demand notice. A1, A2, A3.
All right. Yes. Annexures A1 and A2.
Penalty notice, my lords, has to be there, my lords, awaiting the order of Commissioner Appeals.
ಅಲ್ಲೊಂದು ಬರೀರಿ. The notice, the show cause notice and further proceedings would await the decision of the appeal pending before so and so on the last clause application.
Yes.
Grateful.
89, my lords.
My lords. In this case, my
Also
lord.
covered. Your lordships will get at page 63, my lords, are covered. My lords, we've recovered more than 20%, my lords. Excess to what, as per circular, my lords, 20%, my lords, is the deposit for grant of stay, over and above. My lords, the excess amount can, the lordships
Refunded.
can lead.
Amount in excess of 20% may be refunded.
In the same order.
Same order.
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that he is similarly placed with that of the petitioner in writ petition, page 63, wherein the coordinate bench has held as follows. The learned counsel M. Dilip would not dispute the position of law. In that light, the petition deserves to succeed with the same order, page 73. Yes. Next.
101.
That's not infructuous.
Infructuous.
No, not infructuous, my lords. They passed the. My lords.
If you are aggrieved.
My lords, my prayer is refund also should be granted. They quantified the refund on 30 July. Almost 40 days are over. They've still not granted me refund, my lords.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
3 months.
My lords, 3 months. Already 40 days are over, my lords.
40 days are over. We'll grant you another 50 days. 3 months ಆಗುತ್ತೆ.
4 weeks.
8 weeks, my lords, will within 8 weeks.
ಇರ್ಲಿ ಬಿಡಿ, ನಿಮಗೂ ಬೇಡ ಅವರು 6 weeks.
Yes.
Yes. Petitioner is before this court seeking the following prayer. The learned counsel appearing for the respondent M. Dilip would submit that during the subsistence of the petition, an order is passed by first respondent.
Please. Yes,
Order
ma'am.
is passed by the first respondent,
First
determining refund. In the light of the said order, the learned counsel would submit that a petition is rendered infructuous. The learned counsel appearing for the petitioner submits that the order is 40-day old and no refund is yet reached the coffers of the petitioner. In that light, he would submit that a direction be issued for release of refund within a timeline. In the light of the order being passed of refund, what remains is only the release. Therefore, the refund amount that is determined shall be released in favor of the petitioner with an outer limit of 6 weeks from the date of receipt of the copy of this order, if not earlier. Yes. Ordered accordingly.
106.
Lords, in this also, my lords, 154 application was pending. My lords, we passed a rectification order. My lords, a refund.
Same order mites. Refund is determined on same 31st July. Let them give it within 6 weeks.
6 weeks, same order.
Same
So
order.
petitioner is before this court, same, even the words are same. Yes.
Obliged.
Obliged.
ಇನ್ಯಾವುದಿದೆ?
Lords, faceless.
ಫೇಸ್ಲೆಸ್ ಯಾವುದಿದೆ ಕೊಡಿ?
Lords, 4 matters we have given.
ಕೊಟ್ಟಾಯ್ತು. ಫೇಸ್ಲೆಸ್ all disposed.
We have few more matters. I'll give the list.
Give.
Serial number 147, ma'am.
Faceless.
Please.
Same. We've given the list.
List ಆಗಿದೆ. All disposed faceless.
My lord, serial number,
Faceless.
no, my lord. My lord, serial number 36, it has to be remanded back, my lord. It's a very small case.
No, which can be disposed, you tell me. There is one matter at 4 o'clock.
My lord,
Small case.
this is the 5th time it is come and
Hey,
it is
ಆಯ್ತು
still not reached.
ನೀವು ಮತ್ತೆ
my
ಮೆಮೊ
lord.
ಮಾಡ್ತಾರ ಹೇಳ್ಬೇಡಿ.
No, my lord.
Yes. 5th time before me,
Yes, my lord.
seriously, then I allowed to dispose it. Yes.
My lord, the order was passed under section 39.
Okay.
Order was passed under section 39 of the KVAT Act, my lord. Then the exemption and deduction was disallowed by the audit authority. Then the appeal was filed before the appellate authority. They've dismissed the appeal. Subsequently, I mean, in the meantime, L&T has filed for the winding up of the company. The petitioner requested for the notice to be sent to the official liquidator. The notice was not sent to the official liquidator and they've dismissed the appeal.
This 2019 matter?
Yes, my lord.
Or then it should be disposed. Yes, sir.
Subsequently, it was the winding up order was recalled, my lord.
Okay. Same, similar order.
Yes, my sir. It can be remanded back, my lord.
Kumar. L&T. Go back to the appeal liquidator.
Yes, my lord.
I will do it. At the expiry
We'll
order is
appear, my
admitted.
lord.
You
We'll
appear and
Yes, my
when do you appear? 25th?
Later date, my lord, because the petitioner is bedridden, so. My lord, first week of October will do, my lord.
ಈಗ will do. They have to get the documents. I'll do it on 3rd October. Yes. Heard the learned. That you can. This order will revive. Yes. The petitioner is before this court calling in question so and so. The learned counsel appearing for the petitioner submits that the company petition in 256 of 2018 in connected cases was pending at the time when the subject order was passed by the respondent. The assessment concerns, the issue concerns the assessment year 2009-10 in VAT regime.
VAT regime.
2009-10 of the VAT regime. The petitioner, learned counsel contends that the proceedings are drawn ex parte against the petitioner, which is an admitted fact, and would further submit that an identical order that is passed by the coordinate bench in the company petition in the concerning case of L&T Finance be passed in the case at hand, as they are all similarly placed. The learned counsel appearing for the respondent, learned AGA, would submit that the petitioners be directed, though would admit the fact that the proceedings are drawn ex parte, but direct the seeks a direction to the direction that the petitioner should appear before the authorities with all the necessary documents, as the assessment that is in question is of the year 2009 and 10. The learned counsel for the petitioner would accept the fact that that the petitioner would appear on a particular date fixed by this court with all the necessary documents. In that light, I deem it appropriate to pass the following order. The so and so allowed in part, quashed. What are the annexes? So and so quashed. The matter is remitted back to the hands of the respondent to consider the issue afresh.
Annexure G, my lord.
One nimisha. Consider the issue afresh. The petitioner shall appear before the respondent authority on 3rd October at 2:30 p.m. with all the necessary documents. In the event the petitioner would not appear and furnish necessary documents, the order that is now quashed will get revived. Yes. Ordered accordingly.
Much obliged.
Yes.
Serial number 55.
Vivad se Vishwas. Wait. That will close. Vivad se Vishwas, you argued, which is that matter? All right.
Serial number 55. This was disposed on Monday, less than 7 days, but inadvertently the wrong number has been taken.
Refund of interest on the
Instead of 212,
it's corrected.
The other one should be revived.
No problem, it is corrected.
Please, my lord. 72, it's a 143.3.
You don't worry about the court officer. Even if I forget, she will not. Yes.
I've given her the list, my lord.
No problem.
Serial number 72, I'm praying for a remand at the stage of 143.2. We have filed documents in entirety. But the
I am holding serial number 55.
Please, my lords. I may just clarify, my lords. Serial number 55.
271, 272 proceedings?
Please.
271.
No, my lords.
Yavude?
Nagendra Credit Cooperative. ATA 14873. This is the one which is less than 7 days. Annexure A.
This is to be allowed.
Please.
Where is the order? Covered anta.
Order, your lordship has to release.
Avu dictate madidini ansuತ್ತೆ madam.
My lords may page 46, my lords.
Idu dispose agbeka, dealing ಗಾಗಿ dispose ಆಗಿದೆ ಎಲ್ಲ.
This had to be disposed, but the other number which was supposed to be dealing is showing as disposed.
Now this ಮತ್ತೆ list ಆಗಿದೆ.
The other matter.
We'll take it as this as disposed.
Please, my lords.
The other matter can be brought here and then we'll dispose it.
That also.
Yes, my lord. Right now we can dispose it.
Right now, we'll do it. Yes.
It can be listed on 18, my lord, next week.
No, we'll do it now.
I'll wait, my lord.
We'll get it
Because
listed.
that is already technically disposed of, so we'll just dictate an order.
I'll wait, my lords. My lords, can 72B also be disposed?
What is that?
We have filed submissions. Assessing officer says that
If you have filed submissions, you can't dispose it.
it has to go back to the stage of 143.2.
We'll do it on 18th.
Please, please, I'll wait.
MVT. Tax dispose ಮಾಡಕ್ಕಾಗಲ್ಲ.
My lord, serial number 119.
ಎಲ್ಲ 18th ಬರುತ್ತೆ.
With your lordship kindly, serial number 78.
ನ್ಯೂಸ್ ಕೇಳ್ದಂಗೆ ಆಗ್ತಾ ಇಲ್ವಾ? Yes.
Serial number 78, your lordship. That has to be adjourned and the stay has to be continued because Tirumalesh is appearing for me and for the respondent, he has yet to file the statement of objection.
Maybe extended, stay may be extended.
ಅವರೇ ಎಲ್ಲ ಹೇಳಾಯ್ತು, ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಾಗಿದೆ.
Much obliged.
ಅದು ಆಯ್ತು. I had to say much obliged. Yes.
But serial number 119, my lords, is a faceless matter. There's just one submission, your honors, that the 148AB also
someone
has
said
to be...
there is some urgency and interim order is required, some matter in the afternoon at 1:30. Madam Nimda, what is that, madam? It had to come in preliminary hearing, it has come in B group. Yes, what's the matter?
Actually, GST matter, Your Lordship, in this matter, the order was passed under section 74 and show cause notice issued under section 74 of CGST Act. In this case, the 73 order has to be passed. So the matter has to be go back in that stage for the assessment to issue the show cause notice, Your
74
Lordship, under
notice, because
section
there is a
73.
suppression. Notice has been issued, order has been passed.
I will
There
take
are
it
two
on
more they're
18th.
asking for to convert.
We'll take it on 18th. 18th in preliminary, list the matter on 18th in preliminary hearing.
Please.
Stay, Your Lordship.
ಅವತ್ತೇ ಕೊಡುವ.
Your Lordship.
ಕೇಳಿ.
My lords, serial number 114, if I may submit, my lords.
141. First time coming?
Yeah. Your Honor.
Then no case for stay. But he didn't reach.
Yes,
there.
Your Honor.
18th preliminary hearing? Yes.
My lords, serial number 114.
74 also.
Interim order ಕೊಡದೇ ಇರೋದು reach ಆಗದೇ ಇರೋದು ಕೇಳಿ.
In fact, Your Lordship, after notice, it started listing in B group.
No. After notice, B group.
No, no. For consideration of interim prayer, it is pending, Your Lordship.
We'll see.
It's a consolidated show cause notice.
That's covered.
Yes, Your Lordship, that is.
Number ಯಾವ್ದು ಕೊಡಿ.
Serial number 74, Your Lordship.
ಯಾರು ಅರವಿಂದ? Bunching?
Bunching of
Yes.
show cause.
Bunching order?
Yes, Your Lordship. Period covering 17-18 till
ಅದೇನ್
2020,
ಬರ್ಕೊ
21.
serial number 74
Yes, Your Lordship.
74. The issue in the list concerns bunching of assessment years and issuing a solitary show cause notice. This court in plethora of cases has granted an interim order of stay. Therefore, there shall be an interim order of stay as prayed for in the subject petition till the next date of hearing. Learned Counsel Arvind Chavan is directed to accept notice for the ಆಗಿದೆಯಲ್ಲ?
ಆಗಿದೆ.
ಇನ್ಯಾವ್ದಾರು bunching ಇದೆಯಾ?
Your Lordship, serial
My
number.
lords, serial number 114.
That is.
ಅದು 18th ಅಲ್ಲಿ ಟೇಕ್ ಮಾಡಿ. ಅಷ್ಟರೊಳಗೆ ತೊಂದರೆ ಇದೆಯಾ?
ಇಲ್ಲ. That actually is a direction has been given to Sanmati, that rectification whether
Which
they have
serial
passed-
number?
56, Your Lordship.
You are there in 56 also.
Yes.
18th ತಗೊಂಡು.
Your Honor, Your
Interim
Honor,
order ಯಾರ್ದಾರು ಇಲ್ಲ ಅಂದ್ರೆ ಕೊಡಿ ಅಷ್ಟೇ.
Your Honor, 95, Your Honor, it's an application, ex parte order asked for remand back in that matter, Your Honor.
Can we take it on 18th in preliminary hearing?
Third time it's coming up for.
We'll
not
finish it
reached.
on the fourth time. Yes.
18th, Your Honor. Thank you.
18th in preliminary hearing, we'll take it.
Thank you, Your Honor.
Yes.
My lords, serial number 114.
Serial number
my lords,
119, Your Honors. This is the faceless matter.
Faceless, give it.
Faceless, the number is given, my lord. My only prayer is that along with 148, 148A, B and AD also has to be quashed, Your Honor.
Whatever prayer you have sought, it will be quashed subject to revival of apex court. That's the order that I have passed. It's already done.
Obliges.
My lord,
Serial number 114, my lords, if I may.
It's
Serial number
GST
114.
remand matter. Serial
PC,
number,
please wait, sir.
serial number 133, my lord. It's a remand matter regarding GST.
Remand
my lords.
ಇರ್ಲಿ ಆಮೇಲೆ.
It's come up for the first time on Monday, my lords. Kindly,
ಅಂದ್ರೆ it has gone to
maybe-
B group, my lord.
it's gone into B group. Kindly,
ಬಂದ್ರೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಬಹುದು ಅಂತ ಅಷ್ಟೇ.
ಯಾವ್ಯಾವ್ದು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದು ಕೊಡಿ ಮೇಡಮ್.
My lord, ಇದು I have a benefit of interim arrangement. Inadvertently that has not been recorded last date of hearing, my lord. Serial number 105 ಮೇಲ್ ಬರ್ದಿದ್ದೀನಿ.
ಆಮೇಲೆ ಹಂಗೆ ಯಾವ್ದು ರಿಮಾಂಡ್ ಮಾಡೋದಿದೆ ಎಲ್ಲ ಕೊಡಿ ಮೇಡಮ್.
Yes, yes.
Submission is placed on till next date of hearing ಅಂತ ಇದೆಯಲ್ಲ?
ಅದಾದ್ಮೇಲಿಂದ it's not extended, my lord. ಅಷ್ಟೇ.
105 ಅಲ್ಲಿ interim order subsisting, interim order granted earlier stands extended till the next date of hearing ಅಂತ 105 ಅಲ್ಲಿ.
my lord.
Item 116, my lord. We are challenging the extension notification stay in other
ಮಿಕ್ಕಿದೆಲ್ಲ will have it on 18th in preliminary hearing. ಯಾವ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕು will dispose it.
Serial number 114, if I may, my lords.
Fourth time it will get over, don't worry. Yes.
My lord,
Serial number 114.
I am also trying to take the cases and dispose it. What else can be
my
done?
lord,
ಎಲ್ಲ 18th sir.
my lord.
Serial number 114, my lords, kindly.
18th before we begin the session, all of you please indicate which are the matters that are to be remanded. I will take those matters at whatever stage they are and finish it off. And then go to preliminary hearing. That should be all right?
Item 139, I have only one mention to make. ASD is also appearing in that matter.
ಯಾವ್ದು?
Apparently they want Uber is that e-com operators, Facebook, Uber and all those OIDR matter.
Uber, Meta and Nest services.
All right.
That's OIDR services.
All right.
So that's all together.
In two matters, pleadings are complete. In one matter, they are.
Meta, we have to file the objections.
ಆಗುತ್ತಾ ಮಧು 18th ಒಳಗೆ? We'll take it on 18th.
18.
My lord,
Interim order to be extended in.
Interim orders, don't worry, wherever it is, it will be extended.
In preliminary hearing.
No, ಯಾವ dispose ಮಾಡಬಹುದು preliminary hearing ಅಲ್ಲ, otherwise I will take it.
No. Next, we are on the maintainability. My lord's order is covered in that. It's about filing of writ petition through a power of attorney executed abroad.
My lord, we filed a very
That time,
detailed
yes.
affidavit on that.
You can't sit there, you can't sit.
Order is there on
Yes.
that basis. Next is there, my lords.
Yes.
Lords may have it on 18th.
ಆಯ್ತು ಸರಿ.
My lords,
You can't sit somewhere and execute power of attorney in penal proceedings.
Exactly.
my lord, serial number 112. The show cause notice is,
18th, can we take it on 18th?
my lords,
All right. What, serial number?
112, my lords.
112.
Yes.
Interim order ilva?
Yeah.
The learned counsel appearing for the learned AGA representing the respondent seeks 3 weeks time to file statement of objections. Therefore, till the filing of the statement of objections, no coercive steps would be taken against the petitioner on the strength of the orders impugned. Sakala?
Serial number 114, my lords, if I may.
Serial number 81, my lord. The validity of section 16(2), my lord, subject to payment of 10%, my lord, that may be granted, my lord. Because
Same interim order, huh?
interim order, my lord, subject to payment of 10%, my lord, that. Serial number 81, my lord.
Ah.
81, serial number 81, my lord.
81, same interim order.
10% subject to 4%.
Serial number 102, my lords.
Interim order ಇದ್ರೆ ಕೇಳಬೇಡಿ.
There's no interim order, my lords. Matter is covered by the.
Covered ಅಂದ್ರೆ 18th ತಗೊಳ್ಳೋಣ. We'll take it on 18th.
Lordships.
Serial number 114 is covered, my lords.
ವಿವಾದ್ se ವಿಶ್ವಾಸ್.
65 year answer.
Lordships.
No, can we take it on 18th? Why orders? Preliminary hearing alert. Yes.
Lordships,
Serial
number 46 and 48, your lordships, it's covered. Can be listed on 18th and preliminary hearing, lordship.
Covered by what?
By the decision on this.
Which judgment?
Of the same assessor, your lordship, same petitioner.
Which judgment, sir?
MK Agrotech, your lordships.
All right. We'll take it on 18th.
Serial number 144, my lord. 144, my lord. GST matter. Already 100% tax is recovered, my lord. It's also covered by the judgment of RS marketing assets, my lord. 180
We'll take it on 18th. ಇವಾಗ ಸಾಕು. 18th we'll take. There's one.
Preliminary hearing, please.
ಎಲ್ಲ preliminary hearing 11. Yes.
May I make a request, my lord?
Covered by Rajiv Bansal's order, not on the limitation, but on other points in Rajiv Bansal.
Other points of, I have only considered limitation. Other points of Rajiv Bansal, I will reread Rajiv Bansal.
They covered, my lord. They covered.
ಬರ್ಲಿ. 18th or 25th ಬರ್ಲಿ.
Please, interim orders can be extended.
ಇದೆ ಅಲ್ವಾ interim order? Interim order ಇದ್ರೆ ಬರ್ಲಿ later. 25th.
Serial number 88, my lord. This bank recovery. Serial number 88. It's a bank recovery.
Matter?
Parallel proceedings.
My lord, item 130, I wanted to make a mention.
25th.
18th preliminary.
18th, so many are there. Yes.
Lordships, one more thing.
Whatever is possible to be disposed, will dispose on 18th. Remaining on 25th.
Lordships in serial number 48.
My lord.
Charitable trust.
ಯಾವ ಚಿನ್ಮಯ?
No, my lord, it's income tax matter. Delayed.
ಆಯ್ತು ಇರ್ಲಿ ಕೊಡಿ. ಇದೆಲ್ಲ all 18th.
You're on a serial number 65.
My lord, 130 I wanted to mention.
Madam, 149 matters 18th. There are already 150 matters on 18th.
My lord.
All the remaining on 25th. There are already 150. See, 149 cases already listed. Now I think I have posted 50. 25th.
Serial number 114, my lord.
We'll do it on that day.
May I make a submission, my lords? Serial number 114 may be taken to 25th, my lords.
Yalla 25th.
Serial number 114 may be taken to 25th as a preliminary hearing, my lords.
Vivad. Wait, you wait then. Yes.
My lord, serial number.
Yes, Choda sir.
Harvard bench matter.
Harvard bench matter is ASG.
Further hearing was there.
Wait, we'll get the ASG. ASG career.
Order number 2 for a copy.
Let him finish and come, because Girish Huldmani, that has been pending for a long time, I have to finish it. Ask ASG to come. He's already briefed in that time told, because Girish Huldmani told that.
My lords, may I make a mention?
Adiri, Shivdas sir, you just wait, let him. Yes.
Lord, serial number 128, my lords, it can be disposed of in the
Not
next.
now, sir.
Not now, next time.
Lordship,
25th.
18th preliminary hearing.
25th.
Preliminary hearing.
serial number
Yes,
25th, that is preliminary.
25th. Preliminary hearing, yes.
132.
25th only preliminary hearing.
Lord, item number 132, my lord. I'm from Kerala. So,
You're from Kerala?
yes, my lord.
Ah.
So item number 132, my lords may kindly give a convenient date.
You're not staying here today?
Today I'm not staying, my lord.
Not staying?
Yes.
Why?
I came yesterday.
All right. No problem. Bangalore is also good, weather-wise and otherwise. Yes.
So my lords will take up tomorrow?
48.
My lords will take up tomorrow?
Next week.
So can a date be granted, my lord?
18th.
18th. Obliged. 132, my lord. 132.
My lord, 130, I wanted to make a mention.
Ella chaos ಆಗ್ಬಿಡುತ್ತೆ madam. Both of them will run away now. Court officer and
Maybe listed under preliminary
it
hearing.
will come, madam.
Lordship, serial number
You
40.
take the list, how many matters are there on 18th? 149. How much can I take?
Interim stay illa adukku.
Ilva? Ilder Bharat. Preliminary hearing alle Bharat.
114 and 131.
ಆಯ್ತು. ಎರಡು preliminary hearing alle.
18th September.
ಆಯ್ತು.
Obliged.
16th, 67 as well.
My lord,
Interim order ಇಲ್ವಾ?
my lord,
18th.
30, I wanted to make a mention.
Lordship,
Yes,
serial
sir.
number 48. Name of Jeevan Generalgi to be added, the Lordships. Amit Deshpande's name is there. Has to be removed and Jeevan Generalgi.
48.
Your Lordships.
Local councils.
Learned registry to print the name of Jeevan, delete the name of Amit Anand Deshpande and print the name of Jeevan Neralgi.
Much obliged.
All right.
My lords,
Serial number 64.
No,
There's
now-
no stay, my lord. Bank account have been attached.
There is no stay.
No stay, my
There
lord.
is no stay.
Kindly post it on next
25th,
week, my lord. 18th.
No, 25th.
my lords,
Rest of the matters 25th, yes. Other close ಮಾಡ್ಬಿಡಿ. Same model.
my lords, serial number 123 and 125.
After vacation.
My lords, 25th, my lords.
Ready.
My lords, great.
ಯಾಕೆ ಬೇರೆ ಅದೇನಾಗುತ್ತೆ? ಸರಿ, ಇದನ್ನ ರಿಟೈನ್ ಮಾಡಿ ಅದನ್ನ ಡಿಸ್ಪೋಸ್ ಅಂತ ತೋರಿಸ್ಬಿಡಿ. ತಿರುಮಲೇಶ್ ಸರ್ ಇಲ್ಲಿ.
इसको किसी और नेटवर्क पे करो ना.
Serial number 58, that is also covered by this honorable court decision.
25th will take it.
Serial number 135, 25th.
ತಿರುಮಲೇಶ್ ಸರ್, ಈಗ ಎರಡು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದು ಅಂದ್ರೆ ನೀವು ಇವ್ರದ್ದು ನಿಮ್ದು.
Lordship, if I'm permitted to mention 98, I'm apologizing for appearing online. Lordship, 98, the request is on 18th, if my lords may tag it with the remand matters. My lordship was mentioning that all remand matters will be taken up on the top of the board. So my prayer is also for the same. So if it can be serial number 98 along with remand matters can be tagged, my lord. That's my limited prayer.
ಆಯ್ತು. ಹೋಗ್ಯಾ?
Serial number 98, my lords.
My lord, my lord, item 130, I wanted to make a mention.
Yes, sir.
130, my lord. These
Tirumalesh sir, now these two matters are here. Both are the same?
No, no, he'll say one by one.
14686 ಒಂದು, 14873.
73 is less than 70. 14686, what has happened is?
We'll restore this.
My lords, my submission is that let it be disposed today so that we'll take it for the old date.
Oh.
Because it is already technically disposed of.
No, by mistake, wrong number was given and it is disposed.
Yes, but this is already taken as disposed, so let a order may be dictated for the old date.
Yes.
What has happened? The order is passed on a pan which is already surrendered. I could not appear because it is only faceless. If a direction were to be given that it has to be.
So I have disposed it faceless? Yes.
Can be done this faceless. Please,
ಏನ್ ಮಾಡ ತಿರುಮಲೇಶ್ ಏನ್ ಮಾಡೋಣ ಹೇಳಿ?
ಅಲ್ಲ, let it go back to the.
By what reason ಏನು?
They have to verify the PAN number. Because
that's the only issue?
That is the only.
ಈಗ faceless ಯಾವುದು ರವಿಶಂಕರ್?
Faceless ಯಾವುದಿಲ್ಲ.
faceless
ಎರಡು ಅಲ್ವಾ?
873 is less than 7.
873 is less than 7 days.
7 days. This, there is no faceless.
873 less than 7 days, which is the judgment? Division bench.
Venkatala for Ajana.
That's
Division bench.
Chief Justice, sir.
Please.
Same order. 873 disposed, same order. ಈಗ this was disposed on the other day, 14686.
Yes, yes.
What is that to be disposed now?
Page 85, my lords, but to see, I have surrendered this PAN as early as 2019.
This has to be verified.
Physically verified. A clear direction is saying that JO only has to do, because I am filing under a new PAN, it is not permitting me to log in. I cannot file a reply.
I will direct the JO to verify, physically verify the earlier PAN.
Bank account is already offered in a different PAN. That is the short direction, please.
Income has been declared in that another PAN, new PAN.
So all these orders will go?
All these orders will go. Let it go to the stage of reply to the notice.
Annexure A may be retained, 148 AB.
Except Annexure A, everything else will go. You will give a reply to Annexure A. Correct?
Yes, sir.
Disposed. Avatin date ke disposed. Sorry. Yes.
One matter.
Saku, I am myself getting what is this, what is happening here? Yes.
Madam.
124 and 149. Short point is on the sanction being unsigned.
Unsigned. 18th, preliminary hearing 18th.
Not going to fix it. I will be ready and argue.
10:30. Yes.
Serial number 1.
ನಿಮ್ದು ಇದೆ ಮಧು?
330 matter.
330 matter.
ಅದು that parallel proceeding 62B.
And any convenient date, madam.
330 ಗೆ ಹಾಕಿದ್ದೀನಾ?
149.
ಅದೇ ಪ್ರಾಬ್ಲಮ್ ಯಾವ್ದು?
ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇತ್ತು.
62.
Suddenly it's a very short point, my lords, in that, because my it is in favor of
62 ನಿಮ್ದು ಒಂದಲ್ಲ ತುಂಬಾ ಕೇಸಸ್.
ನಂದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ, it is ಅವರು state government has issued the.
I think Raguraman sir has, Chaitanya sir has, ಅವ್ರದೆಲ್ಲ ಇದೆ. ಎಲ್ಲರದು ಮಾಡಿ will hear.
Any convenient date.
ಅಲ್ಲ, that is important. It's an important thing, we'll hear it.
My lords, ನಲ್ಲ ಅದು ಬೇರೆ, my lords. ನಂದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ, my lords, show cause notice passed by the state authorities. Thereafterwards, we have filed a prosecution also, and there is an audit based. Ours is by intelligence based. We have given summons. So, in terms of the armor security judgment, the Supreme Court judgment says he is supposed to come.
I know, I heard you.
I have to. That's the only point. Other things.
ಆಗ ನಾಳೆ ಹಾಕಿರ್ತೀನಿ. In case time ಆದ್ರೆ ನಾಳೆ finish.
Please.
ನಾಳೆ ಹಾಕಿ.
Please. Please.
Yes, now we'll get to the ಎಲ್ಲ AG went away.
This two, seal number 20.
Girish, Iri,
Please,
get the SG and come. We should finish it today.
Please, madam.
Yes.
List number 2.
My lord,
All tax we will meet on 18th. Yes.
all.
Oh, you wait. Yes.
Well, it's that matter also on. We have some
ಅವ್ರು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟು. We'll pass some order. Wait.
difficulty today, Manoj.
So ವಿವಾದ ವಿಶ್ವಾಸ ಅರ್ಥ ಆಗಿ ವಿಶ್ವಾಸ ಇಲ್ವಾ ನಿಮ್ಗೆ?
Well, the appeal only was not pending.
At length, your lordship, every time it's the matter.
No, the only issue is
Whether
in
appeal was.
after the remand on a particular aspect, whether that would amount to appeal pending or not. Ashte, that's all.
And also, my lord, one factual aspect, that miscellaneous application filed, it was dismissed
Miscellaneous application is filed after the order,
after the order, after the specified date.
after the last date of the scheme.
And
That
that
I am
is,
aware.
that is dismissed also.
There are two things, Raviraj. One is matter is remanded on a particular aspect. Whether that particular aspect will amount to a remand on all aspects, because two aspects are covered where they have not challenged, is what you said. First. Next is miscellaneous application is filed to recall not only that order, the entire order.
That I'll come.
Entire
and
order.
That is dismissed also.
No, that was filed and at the time when you have closed the scheme, that was pending consideration.
not. It
No,
was not.
it was filed after that.
Please.
All right, these matters will have to, I'll do it. I remember what she's arguing.
Even the prosecution.
My lord, item 130 I tried to mention earlier.
Yes, sir.
My lord, 130 are again VSV rejection orders, 5 of them. My lord, on a there are some.
We'll take it on 20, sir. We'll take it on 25th.
All right,
Lord,
Yes,
I'll
all
make a
right,
synopsis
25th.
file of the date.
ಇದ್ರಲ್ಲ?
ಹೌದು, ಇದ್ರಲ್ಲೇ ಕ್ಲಿಯರ್ ಆಗ್ಬಿಡುತ್ತೆ ಹಾಗೆಲ್ಲ.
ಇಲ್ಲ, submission ಕ್ಲಿಯರ್ ಆಗಿದೆ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. Yes. But time will last.
Thursday.
No, he wants to file a synopsis.
Next Thursday we'll complete. There is nothing, you know.
No requirement only to file the synopsis, Your Lordship.
ಆಯ್ತು ರವಿರಾಜ್.
Yes, Your Lordship.
ಇರಿ ವಿಲ್ ಸಿ.
Next Thursday.
ಇವತ್ತು ಬೇಡವಾ?
Milord,
No, Your Lordship.
we have a official meeting, Milord, and
It says-
all the standing.
ರವಿರಾಜ್ ನೀವು ಕಂಪ್ಲೀಟ್ ಮಾಡಾಗಿದೆ, ಅವರು ಕಂಪ್ಲೀಟ್ ಮಾಡಾಗಿದೆ.
ಆಗಲ್ಲ ಇವತ್ತು.
ಆಗಿಲ್ವಾ
I'm
ಇನ್ನು?
sorry, Milord.
No, Your Lordship.
Today some difficulty, Milord. All the all the standing councils have been, we have a meeting, Milord, in the,
Lordship, argument has already concluded, Your Lordship. Even
all the, Milord, all the,
Yes.
present, Your
that's why otherwise, Milord,
We'll take it on Thursday.
Lordship, even Monday also it's.
No, Monday or Tuesday. Tuesday.
Your Lordship, please.
Tuesday.
Connected matter, it is not heard, my lord.
ಆಯ್ತು ಅವತ್ ಮಾಡಿ. ವಿವಾದ್ ಸೆ ವಿಶ್ವಾಸ್.
Connected, it is different, my lord. It's not a on
We
same
will
set of facts.
if needed, we'll dealing because I've spent so much time on hearing the
please,
counsel. Yes. Tuesday, madam.
Preliminary hearing. Preliminary hearing.
Yes.
each server number
ಅಲ್ಲ ಎಜಿ
each server number ಅವರು ಕೊಡ್ಲಿಕ್ಕೆ ಕೆಲವರು ನನಗೂ ಹೇಳಿದ್ದಾರೆ.
ಒಂದೇ ನಿಮಿಷ 230 ಮೂಡ್ ಮ್ಯಾಟರ್ ಇದೆ.
230 more matters.
ಎಜಿ ಅಲ್ಲಿ
You been to court late for mentioning.
ಆಯ್ತು ಅಷ್ಟರಲ್ಲಿ 230 ಮೂಡ್ ಮ್ಯಾಟರ್ಸ್ ತಗೊಂಡ್ಬಿಡಿ.
Orders, seal number 1, Naveen GS. We have filed the memo for withdrawal this morning.
Seriously. With costs will permit to withdraw. Dispose as withdraw. Yes.
Seal number
Two
two,
also same.
two.
Yes.
Seal
Arun
number
Govindraj.
3.
Lord, I'm the managing director of a company against which
You are not a party?
I'm not a party
You said in the morning while moving a memo.
to these proceedings.
And now arrest warrant attachment.
Arrest warrant. My lord will find the impute order.
The petitioner is before this court calling in question the order dated 7/8/2025 hyphen an arrest warrant against all the defendants or against all the judgment debtors. The petitioner is not a judgment debtor. Even then, his name.
I'm the managing director of the company. The judgment debtor is a company.
Matte.
I'm the managing director.
The petitioner is said to be the managing director of the company, which is the judgment debtor and is not arrayed as a defendant in the suit or in the or as a judgment debtor in the execution petition. Owing to the said submission and in the light of the fact that the warrant of arrest is hanging on his head, there shall be an interim order of stay of the warrant of any kind hanging on the head of the petitioner.
It wasn't a suit, it was an arbitral award. That is
Suit arbitral award. Yes.
Seal number 4, Aditya D.
in this case. The petitioner was chairman of one among the 39.
ವಿವೇಕ್ ರೆಡ್ಡಿ ಇದಾರ? Next.
Petitioner was the chairman of Karnataka Bowie Development Corporation. Defendant number 1 some made some wild allegation. Pursuant to wild allegation, I have submitted my papers which have been accepted. In support of his allegations, he had made some TV interviews and newspaper reports which are defamatory.
Which is? Newspaper report?
Newspaper report and TV interviews by the defendant number 1. Per se defamatory allegations he has made. Agreed with that, I have filed a suit before the CH-14 seeking interim order of injunction. That order was not allowed by the trial court, Annexure G, my lord. Annexure G, page 79. Issue suit summon and emergent notice in IA number 1 to defendants call on 88/10/2025. I filed suit against about 35 different channels and newspapers. And every fraction of second, my honor has been defamed without any basis or without any complaint or anything, only in media. Hence
You are what, chairman?
I was the chairman. I was the chairman of the Karnataka Bowie Development Corporation.
Defendant number 1 yaru?
Defendant number 1 claims to be a president of some communal or community organization, and he called the press conference. He called the press conference and made wild allegations. Based on that, adverse publicity has been given in the media, my lord.
You serve on the first defendant. Tomorrow we'll take it.
No, I am unable to track his address also.
Howda?
I even in this thing, I made an attempt. Even before when the matter was before the civil court.
2:30 move ಮಾಡಿದ್ಯಾಕೆ?
No, because interim or today afternoon also some TV has covered a item stating that at 7 o'clock we'll publish something adverse against me. Page 71.
We'll see. We'll take it tomorrow morning. List tomorrow and preliminary hearing.
Much okay.
Yes.
Number 5.
The execution case. Sham is not well, therefore I am deputed. Viral fever ಬಂದು admitted to hospital. So he requested me to appear.
No problem, sir. ನಾನು ಏನು ಹೇಳಿದೆ?
ಅಲ್ಲ, ತಾವು ನಕ್ಕದ್ರೆ
ನಗ್ಬಾರ್ದೆ.
ಹಂಗಲ್ಲ. How is that I am appearing in Sham's case ಅಂತಂದು ತಮಗೆ
ಅಲ್ಲ ಆತರ ಅಲ್ಲ.
The order is one for execution. If I don't comply with the order, tomorrow the warrant will be issued. The rent is fixed at.
We are supporting the petitioner because we also have independent petition.
ಎಲ್ಲಿದೆ ಅದು?
ಅದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಇವತ್ತು.
ನೀವು ಮೂವ್ ಮಾಡಿದ್ರು ಲಿಸ್ಟ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ, ಮೂವ್ ಮಾಡಿಲ್ಲ.
There are two registered lease deeds executed for 2 lakhs and 3 lakhs. The landlord judge don't want to look to it. Fixes the rent at 30,000 rupees without any basis.
On what basis?
No basis.
No, there was a decree earlier. Compromise decree.
Correct. Rent fix
after I rebuild the structure, the rent of the adjacent premises should be taken as a basis.
ಆಯ್ತು, ಸರ್ವ್ ಮಾಡಿ on the your ಇಲ್ಲೇ ಇದಾರಲ್ಲ.
My lord, they have not given the possession for more than 6 years. Your lordship will kindly fix up the date so that your lordship can dispose of the
Monday.
Monday, madam. Friday, next Friday.
Next Friday, all right. ಅಲ್ಲಿವರೆಗೂ no precipitation.
No. We are execution. They have to give possession. I have no.
Don't take the warrant tomorrow. That's all.
Warrant ಯಾವುದು warrant?
ಆಯ್ತು.
26ನೇ ತಾರೀಕಿಗೆ ಇರೋದು ಕೇಸ್.
26 September.
ಇಲ್ಲ, ಹೌದು.
60 days expires today.
ತೊಂದ್ರೆ ಇಲ್ಲ.
ಆಯ್ತು, they have to give the possession.
ಆಯ್ತು, ಒಂದು ನಿಮಿಷ. Heard the learned counsel P.D. Surana appearing for the petitioner and the learned ನೀವು ಯಾರಿಗೆ ವೇಕ್ ರೆಡ್ಡಿ ಸರ್?
He has filed separate petition.
Oh, separate. So and so.
All three has filed.
So and so for the caveator. List the matter on 22nd. The status quo where the property be maintained till the next date of hearing. ಎಲ್ಲ ಹಾಕ್ಬಿಡಿ ವಕಾಲತ್ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಅಷ್ಟೊತ್ತಿಗೆ. ಸತೀಶ್ ಚಂದ್ರ.
But our petition could be tagged along with.
ನಂಬರ್ ಕೊಡಿ ಸರ್.
ನಂಬರ್ ಇದು ತಗೊಳ್ಳಿ, ಇದೇ ನಂಬರ್. WPLB.
I am the plaintiff, Your Honor.
ಆಮೇಲೆ
I am the commercial court, Your Honor. Only one time I am now absent in the trial court in the class examination, and the court is to be going for the judgment, and my IA was dismissed, Your Honor. 6 times defendant was absent, Your Honor. I cooperated. Only one day due to
why
my
did you cooperate? You should not have cooperated.
Only one time my personal inconvenience. I am not cross-examining.
What is personal inconvenience?
I'm stated. It is a personal convenience. It's my inconvenience.
Close ಮಾಡಿದಾರಾ?
Close ಮಾಡಿ posted for judgment ಅಂತ ಹೇಳಿದ್ದಾರೆ. Stay ಮಾಡಿ ನಾನು one time ಕೊಟ್ಟರೆ ಸಾಕು, ನಾವು cross examine ಮಾಡ್ತೀವಿ.
This is the matter on 22nd and preliminary hearing. The impugned order shall remain stayed till the next date. The petitioner shall serve on the counsel representing the respondent before the commercial court and file an acknowledgement. Yes.
ಅಲ್ಲ, stay maybe, otherwise pass any.
ಆಯ್ತಲ್ಲ ಸರ್, ನೀವು ಆಮೇಲೆ ಕೇಳೋದೇ ಇಲ್ಲ. Yes.
7. ಸ್ವರೂಪೆ.
ಗುಲಾಮ್ ಮುಸ್ತಫಾ ಎಲ್ಲಿದೆ? GM ಹೋದ್ರು ಬರುತ್ತೆ, 482 ಇದ್ರು ಬರುತ್ತೆ, CPC ಲೂ ಬಂದ್ಬಿಟ್ಟಿದೆ.
Your Lords is going to take page 19, my lords.
ಒಂದು ಯಾವ್ದೋ ಕೊಟ್ಟನಲ್ಲ ಅಷ್ಟೇ ನಿಮ್ಗೆ ಅದರಲ್ಲಿ.
After the decree is passed for 2 crores 12 lakhs, which is inclusive of the interest. 72 lakhs is the principal, with interest is 2 crore 12 lakhs. Even before the execution is filed, they have stated themselves that 1 crore 40 lakhs was already paid. After the execution is paid, another 40 lakhs is paid. So 1 crore 80 lakhs is paid out of 2 crores 12 lakhs. That's what they are now saying. saying that there is still a due of 60 lakhs. It's a matter of calculation because what error they have committed is.
Heard the
they have-
Leonard Senior Counsel, they are Ravi Shankar appearing for the petitioner. Petitioner to serve on the respondent, counsel appearing for the respondent before the concerned court, 22nd preliminary hearing till such time for the proceedings.
Please.
Iವ್ರೇನ್ ಕೊಡಲ್ಲ ಬಿಡಿ.
Allah, in the execution, they have paid 40 lakhs. Before execution, 1 crore 40
ನಂಗೆ
lakhs.
482 ಫಾಲೋ ಆಗೋದು ಗೊತ್ತಿತ್ತು. ಗುಲಾಂ ಮುಸ್ತಫಾ ಎಲ್ಲೋದ್ರು ಬರ್ತಾ ಇದ್ದಾರೆ. So much so name.
I know.
It started with GM.
GM, correct.
Allah, it started with criminal case where it goes to the Supreme Court.
Correct.
Atrocities Act. only. Supreme Court wrote an order. Then I followed it. Then this case is following me. Yes. A RERA complaint
Also.
in every jurisdiction. Yes,
No,
sir.
we appreciate such litigants.
Of course.
Of course.
You should otherwise. ಇಲ್ಲಿಗೆ ಆಗ್ಬೇಕಲ್ಲ. ಹಂಗಿದ್ರೆ ತಾನೇ ನಿಮಗೂ ನಮಗೂ ಕೆಲಸ.
Grateful.
Yes. Yes, ಇನ್ನೂ ಇಂದಿದ್ಯಾ? ಇನ್ನೊಂದಿದೆಯಾ?
The petitioners are JDR number 1 before the execution court.
ಏನಾಗಿದೆ ಈಗ?
OS is sued for possession, my lords. We are the defendants. It was dismissed, my lords. First appellate court allowed. Adar mele RSA hodi, my lords. RSA was dismissed, my lords. In the meanwhile, before the limitation period expired to file, especially, my lords, they filed an execution case, my lords, and delivery warrant has
Very
been.
weak ground.
Please, my lords. But, my lords, petitioner's family and petitioner resides there, my lords, and there are many tenants.
Attachment warrant.
Delivery warrant, my lords. Many shops are also there, my lords.
Aye.
Properties near.
Petitioner to serve on the counsel representing the decree holders before the concerned court. There shall be an interim order. Delivery warrant shall remain state till the next date.
Grateful.
Serve ಮಾಡಿ ಇಲ್ಲರ ವೆಕೇಟ್ ಮಾಡ್ತೀನಿ.
Please.
Yes.
Also, hand delivery.
ಅಪ್ಲೋಡ್ ಮಾಡಿ. ಇದೊಂದೇ ಅಲ್ಲ ಕೇಳಿದ್ದು ಹ್ಯಾಂಡ್. ಹೇಳಿ ಸರ್.
20.
Just want to point out a few aspects in the objections and the additional statement of objections.
ಪ್ರಭು ಸರ್ ಇಲ್ಲೇ ನೋಡ್ತಾ ಇದ್ದೀವಿ. Yes.
In fact, code copy could be. Insofar as each one of the case, my lords, we have made a separate note.
Yes.
I also prepared, my lord. Each server number. Served it.
Each case ಇದೆಯಾ ಇಲ್ಲಿ?
Each case is there, my lord.
ಕೊಡಿ ಸರ್.
Insofar, the only, my lord, the fact that notices have been issued is not in dispute. Filing of objections is not been dispute. Hearing is not in dispute. Only point is how they have been considered is the whole question, my lord, in all these cases. So therefore, my lord, in terms of principle of law, my lord, each objection need not be separately considered, my lord. Ultimately, the objections are all of similar nature, my lord, so which were sought to be considered. Basically, most important point is, my lord, is a contiguous block. The land is required for the project, my lord. No special circumstances are sought to be made in so far as dropping of the acquisition is concerned. And in so far as two submissions made, my lords, in so far as the two circulars 2003 and 7, which speaks about agriculture land is concerned, they say that if it is part of the project, my lords, it can be acquired as long as it's not affecting. In any event of the matter, my lord, that is not the law. I produced judgment. Even an agriculture land can be acquired on first principles.
Eminent domain, I said nothing, but parameters, conditions in government orders, circulars or whatever.
So therefore, the circular also, my lords, which subsequently sought to be modified, which says that, my lords, as far as possible and as long as it doesn't affect the contiguity of the in question. My learned friend's case is, my lords, agricultural land can never be acquired. That principle may not be.
It's not never. It's not
never ಅನ್ಲೇಲ್ಲ ಅವರು.
Okay, it cannot be acquired. Not
yielding fertile lands of farmers ಒಂದು. And if it is not required for the purpose of the scheme that you have envisaged, then those things should be dropped on the basis of the circular, residential, agriculture, all that should be dropped.
Therefore, my lord, as I said.
ಮಾಡಕ್ ಬರೋದೇ ಇಲ್ಲ ಅಂತ ಅವ್ರು ಯಾವತ್ತೂ ಹೇಳಿ.
No, okay, not, it cannot be acquired is his submission. Not never, it cannot be, the whole
cannot,
case,
alright.
his case is.
Never is not, cannot, yes.
It cannot be acquired, it's not because of, two things, my lord, the lordships are point, circular is not binding power of any, 28(4) does not take away. Even the circular is diluted, my lord, to say that it can be acquired. 2003 said it should be avoided, 2007 or 13 subsequently says, as long as it affects the contiguous, my lord. Ultimately the, please, my lord.
And I asked for what is the report, inspection report ಅಲ್ಲಿ ಎಲ್ಲ barren lands ಅಂತ ಹೇಳ್ತಿರಲ್ಲ, ಅದರದ್ದು ಏನ್
So
reply?
therefore there are two things. I just, initially, my lord, I should concede, my lord, it said the question of considering individual cases comes only at the point of 28(3), my lord. So therefore, my lord, mainly insofar as two of the landowners or three of the landowners who say there's agriculture land and development, my lord, that has sought to be answered saying that those lands are also required for the purpose of the project because it forms contiguous block. That is the reasoning given, my lord. So therefore, my lord, I'll put it this way, my lord. Just because it's agriculture land, it cannot be said that it cannot be acquired as long as as long as it is required for the project in question and it is in the middle of the project, my lord. To put it in other words, my lord, it is not a case where every extraordinary case has been made out for the purpose of deletion of the or dropping the land in question just because it is fertile or an agriculture land, my lord. For example, my lord, the state government itself would have come up with the policy to promote agriculture and it has promoted based on the state government policy. It has been developed as an agriculture.
Those lands cannot be.
Those lands having held out and things like that, having developed and under this.
Yes.
Under those special circumstances, my lord, otherwise, my lord, if your lordship sees any to get vacant land or vacant barren land without the land, some sort of construction or the land being cultivated, is virtually impossible to form an industrial corridor, my lord. And it will be virtually impossible. Now, what we are looking at, that's why I requested my lordship to take the additional statement of objection which you have sought to be filed, my lord. We have explained in that.
Additional statement. Madam.
Cool. So, can I give one more copy, madam?
ಇಲ್ಲ ಇದೆ ಇಲ್ಲಿ.
ಇದೆ.
ಇದೆ.
I thought the file. My learned friend is ready for the reply also.
Definitely. Never ready, sir.
I'll complete it.
ಶಿವ ಪ್ರಕಾಶ್ ಸರ್ ಇಲ್ವೇ ಇಲ್ಲ. ಎಲ್ಲಿದ್ದೀರಿ? ಎಲ್ಲ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆ?
ಇಲ್ಲ.
Though is an advocate is holding some agriculture land.
Sorry?
Though is an practicing advocate in Anekal, he holds agriculture property. That's why.
All right.
That's why.
ಆಯ್ತು ಇರಿ. ಎಸ್.
ನೀವು ಆ ಕಡೆ ಇದ್ಬಿಡಿ, ನಮ್ಮ ಜೊತೆನೆ ಬಂದ್ಬಿಡ್ತೀರಾ?
ಪೆಟಿಷನರ್ ಗೋಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೋಲ್ಲ ಅಂತ ಮಧ್ಯದಲ್ಲಿ ನಿಂತ್ಕೊಂಡು ಹೇಳಂಗಿಲ್ಲ, ಈ ಕಡೆ ಬನ್ನಿ.
Yes. Your lordship may kindly see page para 3, my lords. I'll just quickly run through a few paragraphs of my pleading. Para 3.
Objections, huh?
Additional objections, my lord, which was filed on 20th March 2025. No, sorry. When was it filed? 20th March 2025. Yes. Court of 20th March. Last year, can we give both? Court officer. First, on top is objections. Behind that is the second one is the additional statement. I'll go through the additional statement of objection.
Yes.
Para 3, my lords. para 3, madam. It is submitted that in consonance with the object of the Act, Government of Karnataka has initiated plans for project ranging from Bangalore Metro Rail Corporation, Indian Railways Airport Authority, National Thermal so and so, so and so, so and so. Para 4, madam. It is submitted in view of the same. The Government of Karnataka has identified various sectors, GDP accelerator, employment generators, innovative drivers. GDP accelerator include aerospace, defense, coal, steel and cement goods, warehouse, logistics. The employment generations are textiles, electronics, manufacturing and services, R&D centers and manufacturing support service. Finally, innovation centers of future mobility, green hydrogen, drones, industrial routes, semiconductor manufacturing, smart devices, space tech. It is submitted as stated above. Based on the resources available and the demand, the acquisition of all these sectors are initiated. A booklet connoting the industrial vision and initiatives is herewith produced and marked as Annexure R11. It is submitted that the terms of the demand for industries and commensurate the availability of resources and raw materials, including manpower to support the industries, lands are acquired across the state of Karnataka. It is submitted that some of such instances are acquisition for cement industry in Kalburgi, acquisition of mining industries at Bellary, acquisition of pharmaceutical industries in Chikbalapur, and Kolar acquisition for national thermal plant, and Raichur and Bijapur acquisition for airport and various emerging cities, and acquisition for information center, tech industries in Bangalore, urban and rural industries. It is submitted in terms of the aforesaid acquisition of lands and formation of industrial area across various districts of Karnataka has been initiated. The tabular column connoting ongoing acquisition in various districts of different industries and various industrial areas is enclosed here with Annexure R12. It is submitted the map connoting the acquisition in Bangalore urban from 1998 till date is here with produced and marked, and it is to be noted that the present acquisition under challenge in these proceedings are on the border of Karnataka state abutting Hosur and Tamil Nadu. It is submitted there Hosur industrial area in the state of Tamil Nadu commences from the border of Karnataka state. It is to be noted that the said urban district and Jingri industrial areas are being one of the most successful areas as no land is available for allotment. It is submitted the present acquisition about the said land area and connotation by STR Road, NHAI, Highway to all the rural districts in and around Bangalore and Bangalore city. It is to be mentioned that the displacement from the present acquisition to the Bangalore International Airport is 28 kilometers, whereas the travel distance from the present acquisition to International Airport is around 20. Again, repetition. It is further submitted the map connoting the industrial area in Bangalore, rural and adjoining districts.
Yes.
So ultimately, my lord, what we are trying to say is, it is not that we are acquiring only this, but industrial development throughout the state is taking place. These are the lands which are developing, which industrial area, what has to come. Again, most of the places, industrial people are going towards Hosur. This is bordering that, so therefore we need this land in question for public purpose. And after application of point, this is sought to be done. So we have taken note of every aspect before the acquisition. Therefore, ultimately, unless it is shown, it is favoritism, pick and choose, malified, arbitrary, it is not required, then the scope of judicial review insofar as acquisition is very limited.
Okay. Yes. ಏನಿದೆಯಾ ಇದೆಯಾ ಸ್ಪೀಚ್ ಅಲ್ಲ
ಇಲ್ಲ ಸ್ಪೀಚ್ ಬೇಡ the list of survey numbers and the existing crop I have furnished just
ಅಷ್ಟೇ ಬೇಕಾಗಿರೋದು ನನಗೆ ಕೊಡಿ
ಅಲ್ಲ ಕೊಟ್ಟೆ ತಮ್ಮ
ಈ ಕೊಟ್ಟಿದ್ದು ಅದೇ
ಕೊಟ್ಟಿದ್ದೀನಿ ಅದಕ್ಕೆಲ್ಲ ಅದರಿಂದನೇ my humble request is that original records whatever they have recorded now on paper they say that these are the things we have
yes,
made
where are the records? Place all the records.
All those records is the first thing. And now the second point is, one another paper publication, of course, it is little, I'm deviating. In my memo, my lord, may I kindly request my lord to look into that? I am deviating, God, to take into consideration all these aspects, how this statutory authority is functioning and what is the public view that
ನಾನು ನೋಡಿದೆ
ಇದೆ. ಆಮೇಲೆ ಈಗ now, my learned advocate and advocation state that there are various developments and the various companies have come up throughout Bangalore, in and around Bangalore. Malad, that's what right from day one I insisting land auditing. And these land auditing and also the statistics, how they are functioning and how they have developed. Recently, the statistics has been taken from the department and then the newspaper, that's a Prajavani, a detail, no one is disputing. May I kindly place that paper just now?
they say that ಘೋಷಣೆ ಅಗಾಧ ಹೂಡಿಕೆ ಅಲ್ಪ. ಅದರಲ್ಲಿ ಆಗಿರೋದು ಒಟ್ಟಾರೆ 34 ಲಕ್ಷ ಒಟ್ಟು ಘೋಷಣೆ ಆಗಿರುವಂತ ಒಂದು ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇನ್ವೆಸ್ಟ್ ಆಗಿರೋದು ಕೇವಲ 5.20 ಲಕ್ಷ. Where the way in which in different parts of the
on this merits we'll consider.
Yes, this is also the
overall circumstances not necessary for this.
No, because my learned friend is saying that a contiguity. Now, may I request my learned friend to place that entire topography and demography of the
records barli.
ಇಲ್ಲಿ ಇರೋದು ಇದು ಮುತ್ತನಲ್ಲೂರು ಅಮಾನಿಕೆರೆ the entire 800 acres. And the field for the catchment and also the feeding the water is 1,500 acres. Those things has to be taken into consideration. That now if the entire.
But AG sir, I would need the records.
I'll get the records.
Complete records.
Please, I'll place it by tomorrow morning.
Yes.
Put a flap insofar as.
Ella flag haki.
And index I could put.
Yes.
Yes. I already have placed it in the first hearing, my lord, before the. My lord,
Idide bidi.
There is no contiguity at all. That's why I said it's a pick and choose method. With due respect, I can say that some of the developers and some of the other persons, they have left
That's what we are only concerned with
because
farmers not being hurt.
There is no contiguity. There is no contiguity. That's my submission. Lord, one other submission is now, what is the method they have adopted for 28(2) and 3? This humble court in Ketina of decisions, how it has to be looked into and how it has to be.
28(3) ಎಲ್ಲ cyclostyle orders ಇಲ್ಲಿ.
ಅದೆಲ್ಲ cyclostyle. ಅದರಲ್ಲಿ ಒಂದೆರಡು ಇದೆ in one of the decisions rendered before the.
Whether that is permissible or not, we will see.
Yes, one of the decision to say landmark judgment of the humble apex court, where Raghuveer Singh of the state of Haryana, the lordship says that this agriculture is also an industry. ನಾನು ನನ್ನ ತಂದೆ ತಾಯಿ ನನ್ನ ಅಣ್ಣ ತಮ್ಮ ಅಕ್ಕ ತಂಗಿ ಎಲ್ಲರೂ ಅದ್ರಲ್ಲಿ ದುಡಿತಾರೆ.
ಅದಕ್ಕೆ ಇಂಡಸ್ಟ್ರಿ.
ಅದನ್ನ ಇಂಡಸ್ಟ್ರಿ. ಅದನ್ನ the government shall consider this agriculture is also an industry is the thing which ನಾನು ಲಿಸ್ಟ್ ಮಾಡಿದ್ನಲ್ಲ 2012. May I kindly pass on, my lord? Lastly, I will switch it with the memo and I'll, with a brief synopsis, I will get.
Paragraph.
In the Supreme Court cases, the paragraph is not mentioned, my lord, but I'll take my lord to the paragraph. That's 2013 one Supreme Court cases 403, my lord.
Correct.
Yes.
ಪ್ಯಾರಾ ಇದೆಯಲ್ಲ, ನೀವು ಓದಿಲ್ವಾ?
ಪೆನ್ಸಿಲ್ ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದು ಮಾಡಿ. ಪ್ಯಾರಾ 931.
We'll take this tomorrow again. ನಾಳೆ ನಾನು ನೋಡ್ಕೊಂಡ್ ಬರ್ತೀನಿ.
ಮಾರ್ಕ್ ಮಾಡಿ. ನಾನು ಹಾಗಾದ್ರೆ ನಾವು with a memo will.
ಇನ್ನೊಂದು ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟರ್ ಇದೆ. I'll take that tomorrow. I'll take ಪ್ರಭು ಸರ್ ನಾಳೆ we finish.
With a memo I will submit all those citations so that.
ಕೊಡಿ ಎಲ್ಲ.
ಅಲ್ಲ ಮೊದಲೇ ಕೊಟ್ಟಿರ್ತೀವಿ, ತಾವು ನೋಡಿ ಆದ್ಮೇಲೆ.
ಆಯ್ತು.
Please ಮಲ್ಲ.
We'll take it tomorrow.
I'll appear online tomorrow.
No problem. ನಿಮ್ದು ಆಗಿದೆಯಲ್ಲ.
Please.
Our submission ಅಷ್ಟೇ. In fact, you have to hear them.
I'll produce the records.
Hanga, I want the records. Complete records. Yes, with flag of all the documents. Yes. Original records.
Please.
20.7 my synopsis.
Howdrida?
20.7 mela. My case mela the particularly.
16 houses kodi. Yes.
No, in my matter only one house.
One house only.
One house.
There
is no 30-40 house.
50/80 the construction area.
ನಾಳೆ. Take it tomorrow.
Matters pertaining to that one.
Tax matter ASG or idra tholem. ASG. Girish Hulmani. Sudas.
Bill number 1.
Vinny sir.
Has the other side addressed the argument?
They have addressed it. Then reply giddidu.
Oh, it is for my reply.
Oh, long back Girish Hulmani reply ಅಂತ ಹೇಳ್ತಾನೆ. Anyway, ಮಾಡ್ಲಿ ಬಿಡಿ. Shivadas sir has not submitted, I guess. Yes, sir. I also need a refresher.
I don't think so, Your Honor. Just 10 minutes, Your Lordship.
Yes.
Just take only 10 minutes. I'm referring Your Lordship to writ petition 106.
Shivadas sir. Yes.
This is 1.1, Your Lordship. 1.1 in the
Yes.
list. 106,955. That's the writ petition number.
1.1.
What is under challenge, Your Lordship, is two notifications. First notification, Your Lordship, is 2 of 2023. That's at page 35. And the second, Your Lordship, is the notification at page 56. That's a succeeding notification. Your Lordship will see page 35, how the notification starts. In exercise of the powers conferred by subsection 2 of section 8 of the Goods and Services Tax Compensation to States, the central government, on the recommendations of the council, hereby makes the following further amendments in the notification of the Government of India in the Ministry of Finance, etc., etc. Lords can come to 24A down below.
Yes.
For this particular product, Your Lordship,
Homogenized.
Homogenized or reconstituted tobacco bearing a brand name, 0.36 R per unit. Now, what is 0.36 R per unit? On the other side, Your Lordship, they have given an explanation. In the explanation after clause 3, following clause shall be inserted, namely, for the purpose of this notification, R appearing in column 4 means retail sale price as provided in the schedule to the Goods and Services Tax Compensation to States. After the explanation and before para 2, the following shall be inserted, namely, illustration, calculation of Goods and Services Tax Compensation cess on pan masala.
Yes.
Rate of Goods and Services Tax Compensation cess is 0.32 R per unit. If retail sale price is ₹10, Goods and Services Tax Compensation cess leviable will be 0.32 into 10, which is 3.2 per pouch. So the basis, Your Lordship, is the retail sale price. Our only contention, Your Lordship, is when they levy cess and they refer to the Cess Compensation Act, and if they have to take the value for the purpose of levy, they cannot go by the retail sale price. They can go only by the transaction value, which is there in the Act itself. That's a limited point before my Lords, Your Lordship. It's a small compilation, Your Lordship, we have just made.
You have to jump. Good. That's good. Yes, sir.
Page 2, Your Lordship. GST Compensation Act 2017, an act to provide for compensation to the states for the loss of revenue arising on account of implementation of the Goods and Services Tax and pursuance of the provisions of the Constitution. This is the purpose of this act, Your Lordship. I'll come back to this purpose slightly later, if required. Now, my Lords will see subclause 2 in the definitions, 2C. Cess means the Goods and Services Tax Compensation cess levied under section 8. Right, Your Lordship. Now, my Lords can come to page 4, which is section 8.
Yes.
There shall be levied a cess on such intrastate supplies of goods or services or both as provided for in section 9 of the GST Act, and such interstate supplies of goods or both as provided for in section 5, and collected in such manner as may be prescribed on the recommendations of the council for the purpose of providing compensation to the states for loss of revenue arising on account of implementation of the GST with effect from the date on which the provisions of the GST Act is brought into force for a period of 5 years or for such period as may be prescribed. So the purpose, your lordship, is only if on account of the implementation of the GST Act, there is a compensation required, then they can levy the cess. You can't use the cess, your lordship, for blocking any revenue leakage. That, your lordship, would be slightly relevant, your lordship, when I take my loss, your lordship, to the counter, etc. Because the whole purpose, your lordship, which they seem to say, which even the GST council also, your lordship, they seem to project the GST council is that on account of this product, there is a revenue leakage. How do we block it? By levying cess. You can't use cess, your lordship, for that purpose. You may increase the rate. You may do anything which you want.
That's all the issue.
That's the issue. Now, my lords, will come down to subclause 2. The cess shall be levied on such supplies of goods and services as are specified in column 2 of the schedule on the basis of value, quantity, or on such basis at such rate not exceeding the rate set forth in the corresponding entry in column 4 of the schedule, as the central government may on the recommendations of the council by notification of the official gazette specify. Next, this proviso is what is relevant, your lordship. Provided that where the cess is chargeable on any supplies of goods or services or both with reference to their value, then for each such supply, the value shall be determined under section 15 of the CGST Act for all intrastate and interstate supplies of goods or services. Provided further that the cess on goods imported into India shall be levied and collected in accordance with the provisions of section 3, last line, on a value determined under the Customs Tariff Act 1975, which again, your lordship, is the transaction value. Now, my lords will see the next page. Page 5, which is the schedule, which is referring to. Now, my lords will see first, Pan Masala. This is the tariff heading. On the right hand side, your lordship, 51% of the retail sale price per unit. Now, my lords will see what was substituted earlier. Earlier, it was 135% ad valorem.
Yes.
Which is there in the note down below here.
Yes.
So earlier it was 135% ad valorem. So if it is a value, you go by the value in terms of section 15 and say 135% will be the rate. Or my lords will come to 2. 4,170 rupees per 1,000 sticks or 290% ad valorem or a combination thereof. So you can have a value, you can have a specific rate, you have a combination of both. But if you have to go by a value, go by the value in terms of section 15. Now, my lords will see what is section 15, which is at page 7. The value of a supply of goods or services or both shall be the transaction value, which is the price actually paid or payable for the said supply of goods or services or both, where the supplier and the recipient of the supply are not related, and the price is the sole consideration for the supply. So me and my first purchaser, whatever be the transaction value, that will be the basis for payment of my GST. If that is the value for payment of GST, that alone has to be the value for the payment of cess also. You may have a combination of value, specific rate, etc., but you cannot go by the retail sale price. And my lords will also look at section 15(4), the next page, your lords. I don't want to trouble my lords on the other subclauses.
Yes.
15(4).
Yes.
Where the value of the supply of goods or services or both cannot be determined under subsection 1, the same shall be determined in such manner as may be prescribed. So what they do, your lordship, they prescribe what is the valuation rules.
Yes.
Valuation rules are there, Your Lordship, from page 10 onwards. They say, specifically they indicate what will happen to a situation where a consideration is not wholly in money. How will you determine the value? From page 10 onwards, Your Lordship, rules 27 onwards, the different rules are prescribed.
Yes.
None of those rules refer, Your Lordship, to the retail sale price. Now, my lords will see page 8, 15.5 also. Notwithstanding anything contained in subsection 1 or subsection 4, the value of such supplies as may be notified by the government on the recommendations of the council shall be determined in such manner as may be prescribed. They give themselves the power to do it, but if they have to invoke 15.5, you have to notify the rules for the purpose of administration. So if you have to retail sale price, notify a rule for the purpose of retail sale price, like what you have done for transaction value, and then adopt that as a basis. Without doing that, you cannot adopt, Your Lordship, the rate in terms of the schedule to be in terms of the retail sale price. Yes, sir. Now 15, this is 15.1, Your Lordship, and then 15.2, value of the supply shall include any taxes, duties, cess, fees and charges levied under any law for the time being in force other than this act. Page 7, Your Lordship.
Yes.
So anything else you want to levy as a tax, you can add it to the value of the transaction value. Then 15.3, value of the supply shall not include any discount which is given before or at the time of supply if such discount has been duly recorded. So what they want to tax, Your Lordship, is me and my first purchaser. Whatever be the value, I say 100 rupees, 200 rupees, whatever be the value, take that as the basis, add whatever taxes are leviable under other statutes to it, deduct the discount that is to be given, and then on that I pay GST. Take that as the basis for payment of cess also. That's a limited point, Your Lordship. Other arguments I'll advance based on what he replies. That's a limited point.
Yes, Seizure, sir. ಇವಾಗ ಮಾಡ್ತೀರಾ ನಾಳೆ ಮಾಡ್ತೀರಾ?
ನಾಳೆ ಮಾಡ್ತೀನಿ.
ನಾಳೆ ಮಾಡಿ. Because Gautam, you finished.
Without overlap.
ಮುಗಿಸ್ಬಿಡಿ ನಿಮ್ದು. ಇಬ್ಬರದು ನಾಳೆ ರಿಪ್ಲೈ ಕೊಡ್ತೀರಾ?
ಅಲ್ಲ, Gautam is also appearing to one of the other party.
One petition Gautam and one petition.
Very well, let him finish.
Same submissions.
I'll
Same
reply
submission.
together.
Yes.
I won't take much time.
No problems. Nale after the competition commission matter gets over.
Yes.
Probably in the afternoons.
Yes.
Yes. Nale matters there, is it?
It is there, but I believe the Attorney General will log in. Other team members are coming. The Commissioner himself is coming.
All right.
But Attorney General would be logging in from.
That's all right, but the petitioners mugispekala.
But that matter will go on.
Matter will, at least for half a day, definitely it will go on. Yes.
So my lords can have it in the afternoon.
Afternoon will take.
Yes.
Nale ಮಾಡ್ತೀರಾ Gautam? Yes. We'll take it tomorrow. You can same submissions ಏನಿಲ್ಲ. What is the other overlap other than the overlapping submissions you have?
One is, you see the cess. What will be said? This cess is nothing but a tax. It being a tax, the same regime as Section 15 should apply. The same, there can't be, today what we are trying to do is apply one regime so far as the compensation cess is concerned, saying it is only transaction value. So far as, my lords, the other supply is concerned, when they are imposing GST, that is on the supply transaction value. That is impermissible. The most material specifically says this is nothing but a tax.
That's all. ಅವ್ರು ಧಾರವಾಡದಿಂದ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. All right, yes. Tomorrow 2:30.
Post lunch session.
Post lunch, whatever, 2:30, 3:30.
Great.
At the time you walk in.
Yes.
Yes.
Great. I'm grateful.
Yes. Both.
Extremely great.
Yes.
There's one more Dharwad matter, Manoj.
Sorry? Oh, that.
ಯಾಕೆ ಮತ್ತೆ 5 o'clock your lordships asked us to.
ಯಾವ್ದದು?
17.
Oh, yes. Where is he? He said he will.
My lord, I'm here appearing. I'm in Bombay, my lord, for a matter I had come here.
Tell me, sir. Yes.
My lord, the contention, the major contention here is whether the person has acted in the power of being an advocate or not. When the bar council is in, when the matter is in sub judice in bar council, that is the main contention here, which the petitioner has taken here. So there are two major documents, one major document which we have submitted, whether they acted on the capacity of an advocate or not. That in the written arguments which was submitted in the last date when this was permitted, the last page of it, if yes, my lord, in that if you see, it is very clearly, it shows that the receipt is of the senior advocate for sitting thing. That is one point.
As advocate only, yes.
Yes, my lord. So the point here is there is one more citation which I have submitted, my lord, in the last hearing, which is of the Andhra High Court, my lord, where very clearly, if you see, that is between Chintapalli Pratap Kumar versus Bar Council of Andhra, where if I would like to take the attention of my lordships to the relevant portion of it. My lord, if I may take you to para 35 of the where it says when actually, 1 minute, my lord, I think the last page, if I may take it, my lord. Basically, this is a matter where where one of our councils was involved into certain transaction. So here, if I may take you to para in which page 15, where it says, in fact, the opinion has not been expressed by the disciplinary committee. So, but it is an opinion expressed by the Bar Council of the state while referring the complaint to the disciplinary committee. Notice issued in Form E1 by the second respondent on the reference of the complaint to it, expressing opinion that it had reason to believe that the petitioner or advocate had been guilty of professional misconduct is only a statutory requirement by the first respondent, but not otherwise. Hence, on this ground, the notice impunged cannot be quashed or set aside by exercising powers of judicial review. So, here, my lord, when the proceeding is in going on, my lordships can have power after the proceeding has been completed by the Bar Council. During the pendency or of the proceeding, there is no requirement of intervention, is what this judgment cites, my lord. That is one thing which I would like to point out. And second thing is, my lord, I think so, my learned friend had submitted in the morning where basically there is a contention with the petitioner has taken that that they acted on the capacity of a non-profit organization worker, which is defined with the records which has been submitted. And also, if I may take you to the page number 112, my lord, of the writ of the labor court order extract, where it says, the last para, my lord, the respondent number 6 is an external member of the internal complaints committee and has completely neglected professional ethics, and this behavior was notified as an advice to respondent number 1 very prior to the commencement of the proceeding, and the same was posted subjected to the report submitted by the internal complaints committee. It says, further submits that the internal complaints committee failed to grasp clearly the subject of the allegation made by the complainant, as there was no direct witness or evidence by means of documents in connection of this. That is one point which it says. And further, my lord, I would like to point it where it says where the 1 minute, my lord. Where the labor court has made an observation, my lord, in Yeah, in page number 113, my lord, it is further submitted that dismissing and terminating the appellant from the service by the respondent number 1 on such and such date based on the impungent and unilateral decision taken by the ICC on such and such date on the disputed report of the internal complaints committee is false and injustice and would lead to devastation of natural justice. So in the same proceeding part where the labor court has observed that there was a professional part of negligence which had come. So that is an additional point other than the contention which the petitioner currently is taking that they did not act as an advocate. Hence, I mean, these are the two major submissions, my lord. Remaining thing I have detailedly stated in my written arguments, my lord, where I seek that how and where very specially because there is an agent and a agent relationship than a independent member in the internal complaints committee. That was also being observed by the labour court, my lord. This is something which I would like to point out, my lord, and rest my arguments and allow my learned friend to continue.
Please. Notes, what has been assigned notes is the professional misconduct notes yet to commence. Notes, resolution was passed, complaint came notes. Opportunity was given to.
So even before the proceedings commence, the
It's
petition
only
is
notice,
preferred.
notice has been issued. Only notice has been issued. Notes at the time notes the petition has come and
All right.
notes what has been notes made. Just take notes my statement of objections. Notes resolution was passed upon to see that notes when the notes when that is what the procedure is on section contemplated.
Correct.
Notes this resolution notes has not been challenged notes before this court. Notes where in notes
What is under challenge then?
notice proceedings
Notice.
notice.
Complaint and notice.
Yes.
We just take notes in my statement of objections notes I stated notes annexure R1. I placed notes resolution notes annexure R1. Notes in which notes the council of members notes have opined by saying that notes by looking into the contents of notes the complaint as well as the
It's a matter for inquiry.
Therefore, this opinion notes has not been notes challenged before this court.
This is during the pendency.
Now, there is one clarification I need. Now, the entire complaint is based upon certain observations of the labor code. Is it correct or not? Answer ashte. Hauda illo?
To a certain extent, it is there.
Well, if the foundation of the complaint is on the observations made by the labor code, well, setting aside the termination of the complainant, correct? That those observations have been expunged today on a consent order by the coordinate bench. Now, if the complaint before the bar council is foundationed upon those observations by the labor code, and that today is effaced, how can certain things continue? That's all. That clarification.
Please, not to the extent notes, only basing on that notes the complaint has been registered upon.
It is inter-alia.
Inter-alia notes with respect to certain other allegations. But notes so far it's referring because what notes case which is considered is only the professional misconduct.
Correct. Your angle is not beyond what the scope of the act is. That's all.
Of course, the Supreme Court has held a relationship minutes of an advocate and the client's minutes should always be there. Notes what has been observed in the Palestine case. Nevertheless, notes insofar as notes reference is concerned, but it says notes there are two notes, three notes.
And now, is it that the senior advocate was acting as a member of that committee, or she had tendered advice being an advocate?
She had tendered. Sorry, madam.
Tendered advice, is it?
Yes, my lord. Yes, my lord. Because there was a meeting which was held prior to the ICC also, and also I would like to point out, my lord, even in the entire labor proceedings matter, the same firm was involved in the entire adjudication of the matter after that. And before that, before even the ICC began on 7th, in fact, they had submitted the screenshot of the meeting which had been held between the CEO and this. This is, my lord, there's one more point which I would like to bring to the notice of this court is that, my lord, the very fundamental reason for this thing to happen is that because there was how the regulation itself fundamentally has been used when because the respondent here is also a counsel here, and but the point is he was a general counsel of the company and he was part of the whistleblower committee as a chairman, my lord. And as a chairman of the whistleblower committee, he actually sent the basically the Sequoia Capital, which is the investor of the company, had actually sent a complaint on of the mismanagement and operation of the company and mismanagement in the company. And as a chairman of the committee, he actually forwarded the complaint and took action and sent a notice to the CEO of the company. And just a week before, the same general counsel had sent that the respondent here, basically one of his junior employee, she was not performing, and he had sent a mail on putting her into performance improvement plan and taking further steps. And after that, when this came and this was being sent to the CEO.
I think you are re-arguing the matter before the labor.
Yes. No, I mean, my lord, just a background to the case that how corporate governance gets affected.
I am not asking why the labor court wrote.
No.
Whether there was any communication by the counsel in the capacity of being a senior counsel, or it was on the part of the ICC team.
My statement
My lord, it was.
Lords, we have already said, Lord, that because Lords, the petition Lords was a counsel in record, cases started coming from that company Lords to his brother.
That is the crux of the issue.
That's what Lords
yes,
reference has been made.
The legal counsel of that company.
Please.
Yes, my lord.
But that doesn't stop you from acting as a member of the SEC committee.
No. I was a legal counsel prior to my designation.
Prior to your designation.
After this, I was only an internal complaints committee external member. I did not act as an advisor. That, my lord, in fact, his mail, my learned
You told me external member of the internal committee.
And 47, he himself addresses after the inquiry a mail to me saying that your part in the inquiry was good, but I have problems with the other members of the ICC committee, all those things. And
all right, that's a different. This clarification I wanted.
The ID commissioner only said that, but my brother files a caveat on behalf of the company. So now what they want to say is, your brother got cases because you were part of the ICC committee. You ensured that he is terminated. You ensured a dispute is started so that your brother gets prosperous. That is precisely what ID commissioner said. That is precisely what this court, my lord, eschewed.
We'll see.
Nothing more.
My lord, but there is one point which I would like to point out, my lord, that in page number 11 of the petition, where it has been very clearly stated that it is on one is on the honorary capacity. That is one thing. Second major thing which we are seeing is that when the proceeding is happening, my lord, because this proceeding was not instituted on the before the labor. This proceeding was instituted even before the labor court complaint was being instituted, my lord. That is something which I would like to point out.
One moment. Come back.
My lord, this complaint.
One.
Yes.
Complaint before the bar council is after the labor court's order, before the labor court.
Before the labor court.
It's not on the foundation of the labor court's order.
No, my lord. It is not on the foundation, my lord.
Yes.
Lords, the complaint before the bar council was on 11/9/2019. Then the order, my lords, just says the tribunal's order date is 18/4/20, 18th of April 2020.
So it's not on that foundation.
No, not at all, my lord.
The complaint, my lords. The
That's
complaint
all right.
is only that.
But that's not on that foundation anyway.
But the complaint.
Yes, my lord.
Complaint register made.
Correct, my lord. Correct, my lord.
Friend refer to one voucher.
No, the sequence would go like this. The complainant is charged of certain offences under the Act.
Yes, ma'am.
The internal complaints committee meet, decide against the complainant.
Yes, ma'am.
Whatever termination order is passed. The moment termination order is passed, he is before the bar council registering the complaint against the advocate, saying that the advocate was a legal counsel to the company and could not have acted as the member of the that's the complaint, could not have
I think
acted.
before.
Yes, my lord. Yes, my lord.
He had filed a complaint before, I'm sorry, an appeal before the commissioner. Simultaneously, he files.
It's not simultaneous, my lord. It's not my simultaneous.
Whether it is simultaneous or not would not make any difference. Now, after that, the complaint is in this stage. Later, the labor court reverses it and the sense
Yes, my
exercise determination, making certain observations.
Observations, okay.
Justice Hemant, on a consensus, has expunged those observations in the order of the labor court.
Yes.
Correct?
Yes, ma'am. Not, but it is independent of the complaints which was given.
I just
Yes,
wanted to know the sequence of events.
yes, ma'am. Perfect. Yeah, you're absolutely right, my lord, in the sequence.
Pointed out to one voucher to say I have taken money.
Money,
To say that I have received money, though it
For
is
what?
honorary. From the company. He
Oh,
pointed out.
legal fees badwa?
Huh?
Legal
Adu
fees?
sitting fees anta, if
Oh,
your lordship,
for the ICC.
and please see that voucher date, if my learned friend has produced it along with the judgment and the voucher which he pointed out, invoice copy. That is, my lord, the counsel for first respondent.
Correct. Because I took the copy from her.
Adu judgment jotege avaru invoice copy.
No, judgment is here.
Adu
Invoice is in the written arguments, my lord.
written argument. That invoice copy. is-
25,000.
Yes, my lord. Yes.
Invoice date is 8.
But
Wait. Yes, sir.
8/3/2019 is the invoice date, if your lordship sees.
Yes.
The complaint against R1 for the first time came on 23/5/2019. So this was a
is
prior event.
prior.
And inquiry against him was held in July 2019. That's how he's playing against me. ಹಳೆ ಇನ್ವಾಯ್ಸ್ ನ ಯಾವ್ದೋ ಬೇರೆ ಇದು ತಗೊಂಡು he says I have taken money.
No, it is for the same point. If my lordship.
He is not saying money is taken for this purpose.
Yes.
I think he wants to buttress his submission that you are the legal counsel receiving remuneration from the
Also
company.
is wrong. Please see, that's why my lord
No,
said only sitting fees.
My lord, no, my lord, that is not the contention what we are taking, my lord, because there is a contention which the petitioner has taken that they have acted on honorary capacity, and very clearly, if my lordship can see page 11, where it says not paid any fees, honorarium or any kind of payment for this purpose from the company. That is the contention which we want to also drive, that it is not that. Yes, they have taken a fees and there's nothing wrong in taking a fees. That is, as a sitting fees taking is not a wrong thing. But before that, they have acted as an agent in a relationship with the company as an advisor. That is the contention we are taking, and we have taken this even before approaching the labor court. Hence, the complaint is valid as of date, and let the Bar Council conduct its proceeding. Once that is complete, let them come before the Honorable Court to take further steps. That's where we are contending.
Ordered accordingly. Order ಹೇಳಿದ್ರಲ್ಲ. Yes.
Oh, my lord. Sorry, my lord.
My sign, it's only a premature petition. Lords, let them not face a trial. Let them face a trial. Lords.
Will answer all that. Yes.
Please.
ಅಷ್ಟೇ ಅಲ್ವಾ?
Otherwise, my lord, everyone will have to face a trial. Humiliation for being an external member of a committee.
Whether the rigmarole is needed or not.
Exactly. That's the point. Please.
Oblige, my lord.
The learned, ಅದ್ ಮಾಡ್ಕೊಂತೀನಿ.
Please.
Interim order ಇದೆಯಲ್ಲ?
Interim order, my lords, by mistake, last occasion has not been.
By
done.
mistake ಇದೆಯಾ?
Allah, usually your lordships, my lord, say if the matter also does not reach wherever it is subsisting, the last date.
We'll do it. We'll upload the interim order.
That one.
Yes.
My lord, I mean, let the Bar Council continue, and if the interim order can be vacated, it would be better, my lord. That's a contention. That's all we are taking. But I will leave it to the.
Leave the court. Don't argue the matter.
Sure, my lord. Sure, my lord. Oblige, my lord.
Yes. All right.
Yes.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ, ನವೀನ್ ಯಾವ ಧಾರವಾಡ ಮ್ಯಾಟ್ರ್ ಇದೆ ಅಂತ ನಾಳೆ ಅದಲ್ಲ, ನಿಮ್ದು ಯಾವ್ದು ಟ್ಯಾಕ್ಸ್? ನಾಳೆಗೆ ಅದು.
Lord, I may be permitted to make one submission.
Lord,
I had moved a memo for withdrawal of a writ petition. Lord. It came to be listed as serial number 2. Before that, there was another matter for the withdrawal. Lords had ordered that a similar order may be passed in serial number 2 as well.
Similar order alla, in terms of the memo.
Please, my lords. There, my
Of course,
lords,
memo, sir.
the parties,
Withdrawal al precedent idya. What is this?
because the pleadings are complete.
Don't worry, in terms of the memo, when I said same, it is in terms of memo anta.
The reason for seeking withdrawal was.
There may be, sir. You'll have different reasons. Can I say whatever reason is there covered by that?
Direction may be required.
There is no
to the
covered
client.
matter in withdrawal, sir.
Please,
It is
my lords,
only
there
memo.
may be a direction that may be required to be given to the.
Whatever
client.
you have said in the memo.
Please, my lords.
Yes.